I think if you live an interesting life, you like very interesting stories, which is also the beautiful thing about creative life overall. Learning can never stop. There is always something new, and I learn from my patients. And each one of us will use that choice based on the use that you have to put the technology to. The first film that made me sort of see how a human story and the layers of politics beneath. पानीपत का युद्ध पढ़कर आने वाले दरोगा लोग इन्वेस्टिगेशन कर रहे हैं तो उसमें थोड़ा इन्वेस्टमेंट होना चाहिए ऐसा मेरी अपनी सोच है A person may have a very external successful what's happening with them. It is not going to kill the supply chain, it is to empower the supply chain. And I'm happy to announce that we are still very much in the pilot stage, and beta testing is going on. We are gradually building up our presence little by little as people get more and more confident. Because of the state of our cities, we have no option but to build smart and resilient cities. Digital India is more for the prayer, the privilege and the right.
Ladies and gentlemen, esteemed guests, and also distinguished honorees, my name is Aditya Malik, and it's an honor and a pleasure to welcome you to the 5th edition of the prestigious BW Legal World Global Legal Summit and Legal Leaders Award, an initiative to recognize and also reward the law firms and lawyers who have made a mark in this very practice area. This is an annual initiative conceptualized to fuel excellence in the legal ecosystem by identifying and also enabling law firms and individual lawyers who have the potential to lead the way. The awards shall be presented in various categories and also preceded by a day-long summit with topical discussions on contemporary legal issues. Throughout the day, we'll delve into thought-provoking panel discussions led by top lawyers and also legal luminaries in India, covering a wide array of legal topics that shape a legal business landscape. From the intersection between general counsels and law firms to recent developments in arbitration law, balancing innovation and regulations, investigating white-collar crimes, and also exploring opportunities in debt resolution through IBC and mediation. Additionally, discussions on corporate governance will also shed light on essential aspects of legal compliance and ethical conduct within corporations. With esteemed speakers like yourselves and also moderators from prominent legal institutions, today promises insightful deliberations and strategic insights into the evolving legal framework of our country. And before we move forward, a quick introduction about the BW Legal World community. Launched in 2019, BW Legal World is an offshoot of BW Business World, a 4-decade-old publication that has since consistently ranked amongst India's largest and most respected business magazines. This exclusive GC community aims to bridge the gap between business and also legal sectors across the globe. BW Legal World brings business leaders and legal doyens from all verticals of the legal fraternity together, like law firms, in-house departments, jurists, independent practitioners, writers and researchers, law institutes, legal tech innovators, and more. All of them together on one platform. Pushing forward the vision of BW Business World, BW Legal World prides itself on covering the revolution in the legal landscape worldwide to bring its readers latest news and also developments and be the common thread that ties all of them in the opportunities to build a brighter future. With that, may I please request our team to play the community AV to give us a glimpse into the world of BW Legal World. BW Business World, led by Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business World and founder of the Exchange Media Group, is the fastest growing business media house in the country. With a network spanning across 24 niche business communities and 8 magazines, BW Business World is proud to be entrenched in various verticals in the domestic as well as global business ecosystems. And the changing times, BW now has a massive readership in the digital space as well. BW's portfolio has 24 niche B2B communities that organize conferences and also forums to facilitate interaction between sectoral business leaders and also create a conducive environment for collaboration. To keep yourself updated of all the developments, please subscribe to the Business World Group magazines. I promise you, it will add to your professional quest for knowledge and insights. For all our attendees today, we have exciting offers as well. The latest issue shines the spotlight on women entrepreneurs and intrapreneurs for reshaping the business landscape and industries through the innovation and also leadership. The issue also dives deep into India's stride in the rollout of 5G services, and an exclusive interview with the CMD, Vivek Kumar Devangan, on the ambitious solar rooftop scheme announced by the Honorable Prime Minister in January. For more details on this, you can visit the same registration desk where you got your bands from. To give you a glimpse on the latest magazine issue featuring creativity, tech, and innovation, I request our team to play the AV, please.
India's another opportunities, I think because of the sheer size of the market, because digitalization was democratized, creating a very strong foundation for creative and exploration. The stack has brought sources closer to clients that enable Indian cabins to more global innovations. Thus, the WPP always has led to unprecedented growth. And as I'm sure there are participating in this market, the solutions to global clients at scale. Think about our story and how we bring better futures to our program, planet, clients, and communities in this show of OW Business World.
Today's digital broadcast, it's being streamed live across all BW Business World platforms, including the social media channels and also on www.bwlegalworld.com. As the flag of today's event, I encourage everybody to please join in the conversations and share your learnings from the day by using the hashtag BWGLLS. With that, can we now have the event, AV, please? And before we move forward, I also take this moment to thank our partners for today. Our exhibiting partner, Volody, our legal tech partner, Lawyer Desk, our knowledge partner, Chandyok and Mahajan, advocates and solicitors, our event partners, Joy Travels Private Limited, Fandrum, Beanley Coffee, The Thick Shake Factory, Reality Plus, Exchange for Media, IWM Buzz, Impact, and Pitch. With that, can you also have the partners, AV, please?
Hi, welcome to Royalist. We at Royalist believe in empowering people with cutting-edge technologies. We are excited to introduce our suite of applications transforming the legal landscape with GenAI to deliver efficient, accessible legal assistance directly to your device. Introducing Advocates, our flagship solution designed for lawyers, sets new standards for legal efficiency and connectivity. Introducing Projalo, a pioneering platform crafted for the public, establishes new benchmarks for legal empowerment and accessibility. Introducing Lawful, a purpose-built solution designed for aspiring legal professionals, sets new standards for educational excellence and professional development. With lawyers, the future of legal empowerment is not just improved, it's redefined. We believe in protections and reshaping work, unlocking success for the legal professionals and public alike. And today, I'm pleased to announce that this new era begins with the launch of Advocates Listening, followed closely by Projalo and Global coming to you in June. Join us as we turn these groundbreaking visions into reality. I extend my gratitude for your attention and support. Have a good day.
We have all the more reasons to celebrate this Sunday as well. It's the day where we all celebrate the first loves of our life. Our mothers, any proud mothers in the hall today? Happy Mother's Day to all of you. I think can we have a huge round of applause for them? Let's just celebrate with that, Thank you for being you. That's the best I can say. And now to formally welcome all of you for the opening address, please join me in welcoming on stage Dr. Anurag Batra, the chairman and editor-in-chief of BW Business World and also founder of the Exchange for Media Group. Please.
Morning. My apologies for starting late. It is a Sunday. We're a little relaxed. We had a GC event last night. Welcome to all of you, especially Mr. Raghu, Mr. C.V. Raghu was part of our jury for the GC World. He's going to do a keynote. I'm not an expert on the legal services industry, but I have an understanding by interacting with you. And I must say my journey of knowing lawyers and law firms started in 1996 when I first met Diljit Titus. And subsequently, I started Exchange for Media in 2000. And I remember I met an industrialist. I used to be very young. And he said, why don't you come on Monday? I met him on Friday and bring an SHA. So I didn't know what, I went to a business school, but I didn't know what an SHA was. And I called a friend of mine, Harvansh Chawla, KR Chawla and Company. Mr. KR Chawla is no more. He passed away late last year. And I called Harvansh and I asked him, what is an SHA? So he asked me, why do you need an SHA? I said, I'm starting a company, and I went for raising capital, and the industrialist asked me to bring a SHA on Monday. So he met me, and that's how my Exchange for Media journey started. So I can just say that in the last 4 years, on 12th December 2019, we started the BW Legal World community. We started in this room. Justice A.K. Sikri was the chair of our first Global Legal Leaders Summit, which is primarily our law firm summit. And I can say we've traveled some distance thanks to the patronage by the community. We are not about courts. We are not about judiciary. For us, the two communities that matter most is the GCs. We want to be the homepage of the GCs, and the other community that matters for us is the law firms. And really, we're an editorial-driven product. We have a daily digital site. We have a monthly magazine. We have events. And, Ashima is starting a podcast soon. And we are building a YouTube channel in the BW Legal World domain. We are not in the business of magazines, website, or events. We're in the business of building communities. We've done it with 27 other communities. In the hospitality world, BW Hotelier is the absolute leader, and it is reflected in its editorial positioning and the aspirational product it has built. It is reflected in the revenues that we have. I was lucky enough to build Exchange for Media as the #1 community for advertising, marketing, media, and communication. And we do make an impact there. So in BW Legal World, we've had 4 years of, being active, but we have a long way. We feel we've just started. As I shared yesterday, we're very Delhi-centric. We need to go to Bombay, Bangalore, Chennai, Hyderabad, Pune, and possibly go beyond, just engaging with the current community we do, but we expand on the community that we engage with. I want to say that we are the MC was talking about our last two issues of BW Business World, which is in the 44th year of publishing. In September, it will complete 44 years and start its 45th year. Our next issue is on the India's most respected company, which we've been doing for 15 plus years, even before I acquired. And I can just say that digitally we are building, and I wanted to show you the new site of Business World. Prashant, can we? Yes. So this is the Legal World, can we? And we are very editorial driven. And yesterday we had 2 stories which may be of relevance, which were on the main site, which were of relevance to the, one is the SEBI fines AGI Greenpac for inadequate disclosures to shareholders. Then there was a justice. Then there was 2 HNG stories. One just went by, and there was a story about Justice Rohinton talking about how the judgment, yes, this one, the HNG insolvency. Next to IDA, go down. So this is, these are all related stories. Go back, Prashant. Just the second story below it. Below this one. So HNG is Justice Rohinton. And again, we're in the business of audiences and content. Form doesn't matter. We'll be in print, we'll be in digital, we'll be in video, we'll be in audio. And events are a very important part. Today is a Sunday. It's a relaxed day. We had an event yesterday. We had almost 100 plus GCs in the room yesterday. I can only say that what we've achieved with some of our communities in the main site, we'd like to achieve that with BW Legal World. We are a young community, but we have ambition, and hopefully with your patronage and your support, feedback will grow. Today, the content we create in this room doesn't stay in this room. It gets onto our YouTube channel, it gets onto the site, it gets into the main Business World magazine, it gets into the BW Legal World magazine. On 30th May in this room, we launch our BW Security World community. The BW Security World community has been around for a while, but we launch a print product, and in the first edition itself, editorially, it's a product that doesn't compare with existing 3 other products. I just want to say that the legal services domain is growing. It is expected to become 4 times in the next 2 to 3 years. And really, the law firms have become a choice, a chosen employer for a lot of legal graduates. The quality of legal graduates is another issue, and I won't talk about it. We have our law school rankings coming up, and I will use that opportunity to talk about it. But I would only like to say that the legal services domain is growing. As you know, it will be 4 times in the next 2-3 years. We at BW Legal World are there at the cusp of legal and business. That's how we see ourselves. So we, with your support, play an active role. I want to end by saying what I said yesterday. All of us work very hard. You work very hard. I just want to talk about 3 things that are very close to my heart. One is sleep. India is a sleep-deprived country. In our BW Wellbeing World vertical, we have taken a sleep study. Indians are sleep-deprived. Average sleep is 6 hours. Very few people sleep 8+ hours. I met some individuals who sleep. So I know lawyers work late in the night. Law firm professionals work late in the night. Sleep is the most important ingredient for health, the other being nutrition and movement. And all of you know that. You have families, you're accomplished. And I just want to say that do sleep more. A good sleep means a longer life, a better life, staying away from disease. It decreases your chances of almost every disease. Second is, I talked about an Israeli mountain climber, Nadab Ben Yehuda, yesterday. In 2012, he almost became the youngest Israeli to climb the Mount Everest. He was very close to the Mount Everest, and he chose to come back because he met with a friend who had died, as in he saw the body, and there's another friend who was about to die, and if he wasn't taken to a safer place in terms of oxygen, he would have died. So Nadab Ben Yehuda chose to not go to the Mount Everest. He was very close. He came back and he saved his friend's life. Life has become a lot about achievement, and that's okay. There's nothing wrong in that. We have to have goals. We have to have ambitions. We want to make impact. It is a materialistic life. Money is also important. I won't say that all that is not, but in our quest to growth, if we can create more leaders, if we can help other people to grow, be kind like Nadab, and all of you are. But I just reiterate it to everyone because I feel as a society, we've become too focused on our individual goals. And the third thing, we talked about the role of a GC yesterday, and we talked about how he or she is an enabler. Is also, the word business enabler came up a lot of time. GCs are getting onto the boards of large companies. They have a seat at the decision-making table. And we talked a lot about ESG. I want to say that a lot of things Donald Trump says are not true. He said climate change is a hoax. That's clearly not true. Look at the wildfires happening in the US, in Europe, in Australia. So as leaders in the legal community who interact with very large corporates, decision makers, founders, owners of business, raising the consciousness on sustainability, but it is very important. It does impact us at a micro level. And all of us have children, some of us also have grandchildren. It is our responsibility to be able to contribute to the planet. I mean, it's very arrogant to say that we look after Mother Planet. Today is the Mother's Day. But I think to raise the consciousness and to be able to do things that contribute to a healthier planet, are necessary. I don't want to stand between you and the first panel. We're already running late, but I promise you that we are in this for long term. In the next 10 to 12 months, we'll up our investments in BW Legal World, bring in more editorial people, more business people, become multi-locational, and hopefully enjoy some relevance to what you do, create an impact and a part of your daily lives beyond just content that we publish on the newsletter on the site. Thank you for your patronage. On 15th, I said as we built 27 communities beyond the main BW. On Wednesday and 15th May, in Bombay, we have the Wellbeing World. It's our festival of well-being. We did it 2 years here in this hall with the top-notch leaders. And I remember at 9:30 p.m. in the night, the hall was full, maybe 350 people standing. Sister Shivani was speaking, Gaur Gopal Das was speaking. It's about mind, body, soul. We have an equally enduring lineup for 15th May at the St. Regis in Mumbai. Prashant, can we have that poster? And on the 16th, our luxury and lifestyle editor, Jyotsna Sharma, every year puts together this design conference and design awards. That's on the 16th of May, again in St. Regis with Prashant. You can get both the posters fast. So, mind, body, soul, and well-being is important to each of us. We built the BW Wellbeing World Community, which is growing leaps and bounds. And we don't have a yet dedicated design and luxury community, but hopefully this year, Jyotsna has it on a bucket list to launch that. So we look forward to your continued patronage. In the evening today, this is our Festival of Wellbeing, and it's mind, body, soul. So, nutrition is very important. In fact, Chef Sunil Chauhan, who's the man behind Fab Cafe, has curated the dinner menu for us that day, and we have our BW Wellbeing World 30 under 30 and BW Wellbeing World 40 under 40 that day. So, almost 300 people in the room. And if you can also, this is our future of design. Dr. Pradyumna Vyas is going to he's the former director of the NID. He was the chair of our jury for the last 3 years. And before I acquired Business World, NID and Dr. Vyas would do an annual design awards with BW. For some reason, they got truncated. And when I took over, we restarted again. So this is the lineup. This is a partial lineup. There may be latest posters. So I just want to use your attention to be able to share what you're doing. And in the evening, we have our 5th edition of the Global Legal Leaders Awards. All our Business World Awards are done through a jury process. I don't even know who the winners are till the end. Our jury chair and some of the luminaries and jury members who were involved with the process will be here. Because of my Exchange for Media experience, I do know every media company and how they work and what they do. And I love all media companies. They should all do well. Life is about abundance and coexistence. But I do want to say that at BW Legal World and BW Business World, we don't sell awards, sir. So all our awards are through a jury process. We are custodian of the process. Mr. C.V. Raghu was on the jury of the BW Legal World GC 100. And honestly, whatever the jury decides is final. And I did share this story last evening, and I'll share it. It's a growing community. We still have a long way to go, but we'll get there. I believe in progress over perfection while we chase perfection. In the first edition of the BW Legal World 40 under 40 awards, of course, I was very conscious we are starting. So we assembled a jury. Every year, all our juries are spectacular, and they bring in people who are respected in the profession, who have a locus standi, who have domain expertise, and who have a conduct which is fair to everyone. So we brought in Justice Narasimha as the jury chair. We brought in Mr. Shardul Shroff, the late Mr. Rajiv Luthra, Mr. Ryan Karanjewala, Mr. Lakshmi Kumaran Sita, and another 6-10 very eminent law firm owners. And I remember I was on the jury and Mr. Justice Narasimha said, why don't we get Mr. Shardul Shroff to share the jury? And I said, I have no issue. And then they told me, Anurag, you don't know enough about the legal world, so please stay away from the jury. I said, okay. I sat through the whole day, but I did not participate. And I do want to tell you that there were 2 participants who I personally knew, and they applied just because they know me. I don't involve myself in the process. And both were at 41, 42. And they both were texting me. And one of them is my law firm, a law firm that we use, the partner from the law firm. And the main partner was texting me. And this other gentleman who, when I was on the MDI board, it's my alma mater. I'm also the chairman of the MDI alumni. And I introduced him and he became the MDI lawyer. He is also very close to me, very good friend of mine, much younger than me, about 42. Now he was 40 or little less than 40 then. And then divine intervention happened. Mr. Shardul Shroff is so meticulous that he got into details and he disqualified 2 people. And that's how this 41 and 42 got in. So that's the level of the jury process we follow. So whatever awards are being done today are through a process. I do not have any interference. Ashima is the custodian of the process. Krishnendra, Kaustubh, they work with Ashima on that. So I just want to say it's an honest awards. And that's very important. I know you're in the legal ecosystem and there is all kinds of sometimes accusations we read in media about judiciary or on WhatsApp. But I can tell you our awards are honest. And by and large, I have only met people who have conducted themselves with high integrity and with a sense of purpose. So with a sense of purpose of building a community that really adds some value to you, we are on that journey. Thank you for being part of it. God bless you.
Thank you. Thank you so much, Dr. Batra, for setting the context for the day and, of course, for our upcoming events as well. Picking up from where Sir left and also what he spoke about yesterday was all about GCs. Today is about you, the law firms, etc. So first, let's just listen to some guiding thoughts between the intersection between GCs and law firms. And to guide us through that, please join me in welcoming on stage Mr. C.V. Raghu, former Group General Counsel, Samvardhana Motherson Group. Please.
Good afternoon, everyone. First and foremost, thank you, BW Legal, to invite me for this. It's a Sunday afternoon. I see the hall half empty, but that's okay. First and foremost, today being Mother's Day, happy Mother's Day to all the mothers who are in the room and who are likely to join later in the evening. When I was asked to talk about the intersection between GCs and the law firms, I was wondering what do I speak. When I started my career about 33 years back, there was only one law firm in Delhi. That was J.B. Dadachandji, right? And we used to be told in Unilever that, have you been to the temple? So every day you had to go to J.B. Dadachandji's office and you were there. But at that point of time, I think, interestingly, while law as a profession was also rising, I think there was also general counsels, various companies started hiring general counsels. In fact, when I just joined Unilever as general counsel after not joining civil services, I was considered I was a fool in my batch, but I continued to be where I was. So first, let me talk about how the general counsel's world has moved on. And as I believe economy plays a very big role in this, as the economy grows, everything is based on economics. Because there is a cost factor and there are people, there are general counsels, and companies have started realizing that when you split corporate work into the 80-20 principle, 80% is regular, routine, contractual work, which earlier used to go to law firms or individual lawyers. Now, more and more in-house people have started doing it. There's 20% which needs far greater expertise, and obviously that's where the law firms become relevant. Over a period of time, again, coming back to economics, and this is my personal, if I give a few contrarian views, don't kill me for this, because I've seen the world from the other side. And the reason why I say this is that law firms have to be relevant to the clients. It's very important. somewhere we drift from the profession of law, it's become the business of law. The moment you're into business of law, targets, billing, you know, there comes a time where the companies start realizing why we engage in this law firm. So it's about relevance. I have not seen till date, and I say this with complete humility, I have never seen a law firm invest on their client. Investment is not meeting. Investment is not having cup of tea. Investment is about how many law firms have actually gone and seen what business their client does. How many lawyers have actually been to the factories to see how, like I remember when I was briefing a law firm and my last company was Motherson, wiring harness. The lawyers did not know what a wiring harness was, but they were drafting shareholder agreements and all of that. Because at the end of the day, be relevant. You know, clients are not only for billing. You have to invest into the clients, and invest doesn't mean pay money or buy their shares, but invest, understand their business. And that's where, and I always believe that GCs and law firms are complementary to each other. Nobody is in competition to each other, but please complement. The second most important thing as the GC world, it's so easy. And if you see the narrative of law firms, how JB Dalchandji disappeared. After that came other law firms. Law firms have split. So there is a churn that is happening at that end. And there are maybe in 1990, there was one law firm. Today, there will be about 100 law firms in Delhi, if not more. Now, the law firms are top-tier law firms, mid-tier law firms, then specialized boutique law firms, and all of that. The fact is that my biggest worry is that we are getting into the business of law. We are not getting into the profession of law. Law firms have to be very, very relevant. Otherwise, what's happening, and I can say this with, in-house, the teams are becoming larger and larger. Earlier, the teams used to be small. There are a couple of colleagues, friends who were in the GC world earlier. I know small teams, 5, 7. Today, general counsel offices have 25 members. Why have they built it that big? Because somewhere economics has started playing. And they also hire lawyers from the same institutes that you hire, and they create a small. It's like, I call this as mini law firms within the general counsel office. There are, like in my past company, we have 4 lawyers who used to do only M&A, and they were specialist M&A guys. So we used to only go to the law firm only for the vetting at the top end. And the other thing, please don't underestimate or don't miss the opportunity. General counsels are now no more India limited. They get to see the best practices because companies are large, companies are multinationals. They get best practices from various law firms across the world, and they bring it back to their table. And that's how they're building their in-house, I would say, in-house law firms in a manner of speaking. Now, again, coming back to how can you be relevant? It's important for me to share that. Be precise, be concise in what you are advising. Don't hide behind opinions. Be a stakeholder in that process. I have seen many times that you get a 10-page opinion, out of which the opinion is only 1 paragraph. 9 pages are written to caveat the whole system. Now, everything that you share with your client is not necessarily going to be held, because you have to partner. You can't say that I'll give you the opinion. It's up to you, take it or leave it. Because if you are my counsel, you have to be with me in good and bad times as well. So did I hear something? So the question is that being relevant. The other thing is that provide tips to your general counsel, because they are very hard pressed. They have to take decisions on, if they don't have all the information. The chairman calls in the morning and says that, can you give me a view in half an hour time? Now, the general counsel cannot obviously within half an hour. If you are their counsels, please keep giving them some, if there are any developments that is happening or any of that. Spend time with the general counsel to understand how the general counsel's day operates. What are the key challenges? I have always believed if a law firm comes to my office, it is all billable. Somewhere we need to understand between what is billable and what's investment. No investment, every business will come down, even if it is the legal profession. And please do that. Now, I will not touch upon billing, how you invest into your skill enhancement of your lawyers. I've seen opinions where the opinions are so outdated in the context, and people don't even understand what's the question that's being asked. Somewhere we go to law firms based on the competence of a senior partner. The senior partner has not even seen the opinion. The opinion comes to you. It tells you that it has become an assembly line where you're churning somewhere, and that's where your relevance starts depleting day by day. The second thing, I would be very happy to hear law firms tell me, don't contest this matter. If a client comes and says, I have this problem, I have not heard a single law firm telling me, don't contest, settle this matter, or tell your chairman that this is not worth your time. This is good money after bad money. There was only one instance where long ago we had drawn for an opinion to Mr. Salve. Mr. Salve said, tell your chairman, if he wants to demolish the brand, I will contest this matter. And that was it. So the question is that learn also to say, don't always try to please your counsel, because one time you please, but the impact over a period of time, the council gets to know, and over a period of time, the feedback, and therefore, the change happens. And gone are those days where you get briefs based on, the chairman, somebody. It's these days, at the end of the day, buck stops with the general counsel, and more companies are doing that. I know many very senior law firms who tried to reach out, and when we would say that we don't have the time, or they would go to the chairman thinking that they can bypass. It doesn't happen anymore, because the boards are very, very careful about it. They do not allow any kind of nepotism to happen. I've had several instances, and so many of my GC colleagues will bear with me for that the board doesn't want to see an opinion. They want to hear the opinion of the GC. And how do you arm the GC with that opinion? And please work in that direction so that you become the backbone. It's a complementary system. They are lawyers, you are lawyers. I remember many years back when we used to go to the law firms, we were not even treated like lawyers. We were not even treated like lawyers. I will tell you, listen. My friends, the world is changing. The world is changing, and GCs are playing a far, far bigger role. Their relevance has become far important. And the companies are no more willing to spend money on destructive litigation. And I can say this with pride. In my previous company, we have zero litigation. Zero. Motherson, for a $26 billion company around the world, we have zero litigation, except for one-odd prosecution that's happening, one-odd. But we don't get litigation at all, because the drive is towards reduced litigation. We don't have legal work? We do a lot of legal work. We do so much. We spend all our energies towards productive movement and use law for the enhancement of the business. So coming back to the relevance, the intersection, I would urge there is a lot of relevance between GCs and and law firms. Please be cognizant. Try to understand your client. I am sorry to say this, but even the largest law firms in this country wouldn't have even read your annual report. You are their client for the last 5 years. They don't even read your annual report. They don't even know which are your new lines of business. Now, the same counsel, who is a very good M&A guy, will now start advising you on aviation. And the moment you say, no, you are not in aviation, then they'll get you. So your billing will continue to grow up. But at the end of the day, is your advice coming, which is very, very relevant, what you want. So broadly, 3 or 4 points, stay relevant to your client, be concise and precise. Keep giving tips from time to time to your counsel so that the counsel believes that you are with the counsel and you are not there only for billing. And last but not the least, if there is a new development that is happening, if there is a new method, give impetus to the general counsels to innovate. Because if they survive, at the end of the day, they are the guys who cut the bills. They are the guys who pay the checks. So please help them, because if you don't have their confidence, somewhere, the churn will start happening. And with that, I'll leave it. I wish BW Legal a fantastic day today, and for all of you, for the various panels. One last unsolicited feedback. I was looking at the agenda of the day. There's a session in the evening on corporate governance, but I'm sorry to say I didn't see a single corporate person on that panel. It's all lawyers. The last mile of corporate governance is always done by in-house people, or you could have had some CEO. But if you don't have the corporate represented in corporate governance panel, I don't know what kind of corporate governance we are talking about here. So with that, I'll pause. If there are any questions, I'm happy to take. Otherwise, wish you all a fantastic day today. Thank you.
Thank you. Thank you so much, sir, for sharing with us your experience and your thoughts. With that, it's time for the first panel discussion of the day on recent developments in arbitration law, implications for India's legal landscape. While they set up the stage for the same, I shall introduce the panelist. Bhavyam Agarwal, partner, JSA, Shashank Garg, counsel and arbitrator. Joining them is Payal Chawla, founder, This Contractors. Joining them is Arush Khanna, managing partner, Newman Law Offices. Mehul Parthi, counsel, CNM. Joining them is Sonal Kumar Singh, managing partner, AKS Partners. And this session will be chaired by Samir Jain, founder and managing partner, ESL Advocates. So we have 5 panel discussions followed by keynote addresses, and then we shall also have the Legal World Global Legal Leaders Awards 23-24. Okay. Can you please join me in welcoming all our panelists and our moderators to the stage now, please? Thank you. Thank you so much.
Thank you, everyone. Good afternoon. It's quite realized a Sunday afternoon, and we've had a heavy day yesterday. As you all know, there was a launch of the Arbitration Bar of India. And so this 45-minute session, while the topic is the recent development in the arbitration law and what implication it has for India. I think all of us can speak for 4 hours and given enough time, but we only have 45 minutes and we'll try to keep it interesting and very conversational. We'll try and have some audience Q&A at the end if that works. So how we'll do this session is it'll be very conversational. So I'll be asking questions to my panelists and we'll be taking their views on various developments which we think are relevant for today's discussion. I mean, arbitration is one area where after 2015, we have seen consistent developments and major amendments. And when we talk of development, it's not only legislative developments which we talk about. We'll also talk about a lot of judicial development in clarifying the arbitration law on various aspects. And I mean, the discussion on recent developments in arbitration cannot really be started without talking about the expert committee report, which recently came out, which suggested multiple developments in the Arbitration Act. Why the expert committee becomes extremely relevant is the committee was comprised of all the stakeholders from the industry, from the law firms, the lawyers, the government. Everyone sat together, pooled in their views. The institutions were invited to give their views. So, and I want to start right away, and I want to ask Arush on the aspect of the expert committee report. Do you think there were hits and misses in the expert committee report, and do you want to just summarize the developments and the suggestions there?
Thank you, Samir. It's an honor to be here and sharing this dais with people I admire. Well, as you said, the expert committee report, firstly, in my view, they do recommend some path-breaking reforms, and I would highly recommend all aspiring arbitration practitioners to give it a read. In the interest of keeping it short, I'd just like to highlight some salient amendments that have been recommended and probably just dive into the pros and cons. I think first and foremost is the elephant in the room, which is the proposal to introduce the concept of a emergency arbitration in India. They've recommended the insertion of 12 capital B, as per which institutions would now be permitted to, in that sense, to have emergency arbitrators who will then have to pass his or her award in a period of 30 days. Now, of course, it is a very, very laudable initiative, and I do hope it's implemented, but I think they could have maybe widened the canvas from just being constricted to institutional arbitration, perhaps to even move into ad hoc arbitrations, where parties may perhaps have agreed in their arbitration clause to have a named emergency arbitrator. Perhaps, I mean, just thinking aloud, because right now the concept of EA is only being proposed to be in, there in institutional arbitration, which is also good because it kind of promotes the concept of institutional arbitration and steer away slowly from ad hoc arbitration, which has plagued the landscape for the best part of last 25, 30 years. Number two, I think to introduce the concept of TPF in India. Historically, under the common law principles of champity maintenance, they were prohibited in India. But now, to embrace modern day economic realities, these concepts have watered down and also been abolished in a lot of common law countries, England, Australia, even Hong Kong for that matter. So I think to get third party as a concept in India, I think we need to thank Shashank for that firstly, because I think he got the ball rolling when arguing the SBS Holdings case. So yeah, I think we all owe a note of gratitude to him for that. But third party funding, well, again, I think it is a reform which is required in India. But TPF as a concept needs to be first regulated, because otherwise we are foreseeing problems in relation to confidentiality. Today, 42 capital A of the Arbitration Act covers the parties in the tribunal. Perhaps the ambit of that might have to be widened to include parties who are funding parties to the arbitration. Then there could be issues of conflict of interest. Today, of course, the Bar Council of India rules don't explicitly prohibit a lawyer from representing the financer as well as the party. But what if during the course of an arbitration, there are some issues that arise between the party and the financer? And the lawyer would be knowing, of course, the kind of trade secrets of both parties, which would lead to some ethical considerations. Then there could be an issue of influence over an arbitration that a financer might want to wield, which will affect the partiality of the process, the independence, and may lead to problems in enforcement. And of course, regulating the flow of investment. We'll need guidelines from the RBI if your financer is a bank, the IRDA if your financer is, if you've taken ATE or insurance or as a TPF means, and even FDI policies. What if there is cross-border investment involved, which is the idea now that foreign law firms are also coming in. So I think TPF as a concept needs to be regulated as well. So we need to do this in a little nuanced and calibrated way rather than just, injecting TPF in India. Then, of course, there's a dedicated chapter on MSME arbitration, which is again very, very good in that sense. But I think it's chapter 6, capital A, to my recollection. But again, they'll need to harmonize the provisions of this chapter with the existing MSME law, which, as per the Apex Code ruling in SILPI, has an overriding effect over the Arbitration Act. And of course, lastly, it's the power of the court to modify an award. I think now, of course, we all await the case, the ruling in the Gayatri Balasamy case, but as of now, it's very scattered. We have one chain of rulings starting from NHAI versus Hakim, which says that a court cannot modify an award. You have one chain of rulings starting from Vedanta versus Shandong, which says the court can modify an award. So I think the proposal to insert a proviso to 34(2)(a) is also good, where it says that if an award can be compartmentalized into various claims, each largely, independent of the other, then a part of the award can be set aside. And I think that is good because that will not relegate the parties back to square one. And the court, but again, we have to be very conscious not to make it a court under Order 41 exercising appellate powers. It still needs to be a 34 court. So yes, it's important to do the right thing. The recommendations are great, but it's also important to do it the right way. And let's hope they kind of, shape along well for all of us.
Right. Those are very valid points taken care of in the report, and we'll talk much more about modification. Do anyone else has a quick comment on the expert committee report, if there's anything which we missed out? No? Okay. So yes, you spoke about funding a lot and taking a cue from that. And since Shashank has been part of very progressive and a landmark ruling on tomorrow sales and SPS, which though the question was not in relation to validity of funding in India, Shashank, the question I think was in relation to liability of funders when there's a cost award. So in some senses that matter dealt with a question which is 5 steps ahead of where India was in terms of funding, while we were grappling with the whole issue of whether funding is valid in India or not. That judgment posed a question whether funders would be otherwise liable in case there's a cost award against the party. So, we'll be very glad to hear your views on where we are. And while we're talking about funding and regulation, you may also talk about IILF, in which you are also a part. So, over to you.
Thank you, Sameer. First of all, thank you, Business World and Ashima, for calling me here. And in addition, I must thank Arush, who's given you the flavor of what is happening around third-party funding in India. Indeed, tomorrow's sales was a landmark judgment in its own set of facts. But I must also give you a caveat that it is pending before the Supreme Court for final adjudication. So what we have, I would of course hope that it doesn't get changed, but it is subject to what the Apex Court has to say, and it should be heard very, very soon. So let's see if there are further developments around it. But where we are, Third party funding, I think as a concept, I understand we have a very, very mature audience, so I don't have to explain what it means. But whether it is legal in India or not, this question, as Samir rightly pointed out, does not require an answer anymore with tomorrow's sales judgment, when it has answered questions which are far more nuanced and accepted third party funding as something that India has to embrace. If India has to become a progressive jurisdiction in the arbitration field. Very basic facts. And before I go on to that, I must say that Samir is or has been involved in that matter. He was the one who brought the funder in and did that arbitration. So another piece of information which some of you may not know. So the question before the High Court, before the single judge and division bench, was whether there would be any liability of a third party funder when the third party funder is obviously neither a party to the arbitration agreement nor to the arbitration proceedings. So, of course, if somebody is not a party to the arbitration agreement, we know the group of companies, Doctrine, Alter Ego, and so many other ways to fix liability if such a party is intrinsically involved in the financial aspects of a litigation. But this is a party who's obviously not a party to the arbitration agreement. He's a funder, steps in when the dispute has arisen, and is also not a party to the arbitration, doesn't take part in anything, and is also not made liable through the arbitration award. But the winning party in the arbitration wanted to recover costs from such a funder in an execution proceeding and in a Section 9 filed before the execution in the Delhi High Court, saying that since the party who has lost doesn't seem to be paying or is going through some financial constraints, please make the funder liable, since funder was the one who really enabled them to conduct this arbitration proceeding. So Delhi High Court, the judgment as it stands today, the division bench said that nothing doing. The funder was not a part of the arbitration. He has not been made liable through the arbitration award. And in Section 9 can only be in aid of execution. When you cannot execute an award against a party, you obviously cannot seek an interim relief against that party. So while deciding this point, there were several references which clarified India's position or India's growing position in accepting third-party funding as a practical and upcoming norm. Now, something Arush said about regulating third-party funding, I think that's where I may differ slightly. I think most progressive jurisdictions have a self-regulatory mechanism. And in India also, we are trying to develop that. There is already an association called Indian Association for Litigation Funding, which has come about a year ago. Still, work is in progress. And this is going to be regulating, hopefully, it will set out the self-regulation mechanism for third-party funders. But an important point highlighted by Arush, which appears to have emanated from the report, is is confidentiality and conflict of interest. I think for that, we would certainly require a wholesome disclosure and a duty of the third party funder as well as the party using the funder to disclose as and when funding is taken. Institutions have rules for it. In ad hoc arbitration, of course, we do not have any provision in the Act. So, of course, there either through judicial pronouncement or amendment in the Act, there should be a requirement of a detailed disclosure as and when that happens. I can just to conclude, I can tell you the Delhi International Arbitration Center has already set up a team to formulate rules around third-party funding. So even the Indian institutions are accepting it as something that should be, the next big thing around the arbitration ecosystem in this country. Thank you, Samir.
Thank you, Shashank. I think it's one of the most contextual topics right now, which is which has an impact on access to justice. So, any other of my panelists will have view on third-party funding? So, one very important aspect which everyone I think needs to know is the background of what was claimed in this matter was the recent slew of judgments in the UK, where in litigated in funded litigations and funded arbitrations, the tribunals and the courts have held the funders liable for cost. The argument of the party who has been awarded cost is always that if the funders are not held liable, and we are dealing with parties which are either pauper or do not have money, there's no use of having a cost award because the parties anyways do not have money. I mean, the counter argument to that is, at least in institutional arbitrations, there's a concept of security of cost, where you can apply to the tribunal to say that, listen, this party does not have money or does not have assets, and in case I was to win, or in case I was to be awarded cost, then there will not be any asset against which I'll be able to claim it. And more often than not, the tribunals in such cases award security of cost, and the arbitration will not continue if the party against whom the such order has been made deposits the money. So very interesting question there. And I think with this development, India at least moved a step ahead in terms of making India a preferred seat of arbitration with some clarity. And now when we talk about, preferred seat of arbitration, we had recently had the judgment in the curative petition, when the DMRC's judgment, where in an exercising curative jurisdiction, the judgment in the civil appeal has been set aside. Now, I want to ask Payal this: is it one step forward, two step backwards, or is it one step forward and plus two steps again? I mean, we have had very, very contrary opinions on this. What's your view?
So I'm going to swim against the tide and say it's going to have absolutely no impact on India being considered a. Is it? Can you hear me at the back? Oh. Can you hear me? The better. So I don't think that this judgment which has come is going to have any significant impact on whether India is considered a seat or not, a preferred seat or not. And the reason I say this is primarily because the DMRC judgment is being delivered in the context of domestic arbitration. And for those of you who are not aware of the facts, I'll just quickly recap the facts for you. There was a concession agreement between DA, MP, I'll just call it DAMPL for ease of, with DMRC. And there was an arbitration between them, a 3-member arbitral tribunal held in favor of DAMPL. And the matter, of course, went up to the Delhi High Court. The learned single judge upheld the award that was then set aside in a 37 by the DB. And that's very important on what it was set aside. It was set aside on a grounds of patent illegality and perversity. The matter then traveled to the Supreme Court. The 2-judge bench reversed the decision of the DB. And they held that the power of the tribunal can have a difference. The tribunal is really the master of the evidence, and they have the right to interpret the contract, even if that's a view that may not be acceptable. This went up in a review and then the curative. Now, remember one thing: at the end of the day, in a domestic award, the patent illegality, that the definition has been widened by SsangYong to include perversity and irrationality. I have long taken the view that this expansion is the issue, because one of the reasons for the expansion is to say that, the quality of arbitrators is not that great in India. That, I think, is going to have an impact, because if you don't trust your quality of arbitrators, why would a foreign party? But I don't think that this curative in that sense is going to have any impact, because the question that the audience may want to ask, or you may ask, is that does this not then set a precedent for it to be expanded to an ICA? I think not, because the parameter for the court's intervention is so small in an ICA. And this is not the judgment that is first opened the door for the curative. So that's in the stamped agreement. And if I may just add one more thing, remember the curative jurisdiction has been exercised under 142. Now, you may say that 142 has been exercised in other matters, but not in a curative. But at the end of the day, in arbitration, in several matters, and going back to McDermott, the courts have exercised power under 142. So,
Yeah, absolutely right. I mean, 142 is the inherent in the Supreme Court's jurisdiction. My only comment, and it's not flowing from me personally, but with a lot of people I've had a discussion with, and I would open the panel and would seek everyone's views. Is it not putting a dent on the whole concept of certainty? While one caveat, I am of the view that there should be some level of intervention in the award, because of what we have seen on ground as the awards come out. They are sometimes shocking. So there must be some level of intervention. But at that stage, for the court to interfere, is it not putting a dent on certainty? And I'll just go from this side to that side for everyone to, yes.
Can I just take
Yeah.
the first crack at it? And the reason I say no is I think the criticism on the issue is a bit misdirected. That's my view. I think the issue is not so much the curative power as much as, and I'm at the cost of repetition saying, the expansion of the patent illegality test is really where the issue is. If you see the 246 Law Commission, it had never intended for even patent illegality to ever include perversity and irrationality within its domain. So that's where the issue is. So whether the court intervenes at the 37 stage or at the stage of the Supreme Court, or does it in a curative, then those are just additional layers that you're adding. So I think it's a bit misdirected, the criticism. The judgment may have other issues, but this, in my view, is not the issue.
Just a caveat, I'm also Central Government Standing Counsel, so but the views I'm expressing are completely personal. I would agree with Payal on saying that I think the criticism right now, what I'm hearing from everybody in conferences and events is a mixed bag. And there is some confusion. I think the fair criticism should be on the timing of this. That, okay, you had a 34, then you had a 37, then you had an SLP review. And then ultimately, at the stage of curative, the award was set aside. So I haven't really heard anybody going on to the merits of whether the award was patently illegal or not, but really the aspect of it being set aside at the stage of curative. So it's that, I think Sameer's question also, that, where are we going with the certainty and predictability? And this can certainly become a standard for PSUs to wait until curative. That would be a problem. If that happens, then even as a state council, I can say we will be in a lot of trouble, because the Supreme Court in its curative also has, while adding paragraphs and paragraphs saying that, okay, this is not a regular SLP, curative is to be used with a lot of caution. We don't encourage curative to be filed, all of this. will still not be enough deterrent for many public sector undertakings to wait until curative. And I think that's really the challenging part. But on the merits of the decision, because it was an award of 3 technical arbitrators, and I have nothing against a tribunal consisting of 3 technical arbitrators, the court found some glaring issues which, unfortunately, at the stage of curative, the Supreme Court decided to, it just did not pass the test of their conscience to let the award stand.
Thank you, Samir. I think I agree with both Payal and Shashank on this point, because the issue really is not that, the award was set aside at the stage of curative, but you actually have to see the background. We are in a jurisdiction where the entire arbitration system is developing at this moment. And we can't expect, or we don't see as council also, perfect awards. And there are awards which may have glaring, loopholes or deficiencies as per Section 34. So it's very easy to say that, oh, there is an award, please throw it out, or don't throw it out at the Section 34, uphold the arbitration. But the entire focus should be on upholding the justice. If the award is perverse and it needs to be set aside, then stage should not ideally matter. So that's something which we should focus on, and also see the background there, because it can't be a straitjacket formula that, in UK somebody says that, oh, we have a very good court system and we don't interfere with the awards, etc. India has a different background, different jurisdiction, and we have to see the things from that perspective and from that background. So I completely agree that, the stage should not matter, and it should not be criticized just because an award has been set aside in curative. And I'm sure that this is an exception, and it's not some, the courts are not going to entertain curative after curative for each and every award. This is an exception considering the background of the award, the facts, and the stakes involved. So I don't think that this is something which we can say that we have gone 2 steps back. I think we are where we were.
I absolutely agree with Sonal, because we need to remember that the curative right has always existed. So what DMRC did was just exercised that right. And the Supreme Court in its own wisdom then said, yes, okay, this is a perfect case for a curative petition. So in that situation, that you can't put a blame or consider, because for n number of other cases also, it would be that any party can go for the curative petition. It is not a case where only DMRC was given a right to go for that curative petition. Supreme Court in its wisdom allowed that. Now we are here, and it also caveated to a sense by saying that it will not be treated as a precedent. So it was aware that it may be a very unique case that requires my attention. Having said that, I will not be accepting all other cases.
Right. Thanks. Mary. So while we're discussing Supreme Court, Sonal, I would want to ask you, the recent judgment and then global and the whole quagmire of stamping, registration, unstamped agreements, the debate has been put to rest. But while the debate has been put to rest, as someone who's regularly appearing in both domestic and international arbitrations, as an arbitrator, as a counsel, what do you think is the on-ground impact of that judgment? Is it, are there still open issues? Have you seen tribunals being comfortable dealing with the implications of the judgment?
Yeah, thank you. Thank you, Samir. I think the recent 7-judge bench judgment on this issue is a big relief, for the arbitration community and also the business community, because if you would recollect, this all started from Judgment Garware, and where the court said that if the underlying contract is not sufficiently stamped, then the arbitration agreement is also invalid, which in my personal opinion was against the basic principle of severability, which is an underlying principle when we are dealing with an arbitration clause. But That judgment was again followed in Vidya Rolle, a 3-judge bench judgment, and then came NN Global, a 3-judge bench judgment, which said that, sorry, whatever you are following, I don't agree with that. This is, if the underlying agreement is not sufficiently stamped, it should not impact the validity of the arbitration agreement, which was, according to me, correct proposition. But because there was already a 3-judge bench judgment, it was referred to a 5-judge bench judgment. And with the majority of 3:2, the court again said that if the main contract is not sufficiently stamped, the arbitration agreement goes out of the window. You can't, it's an invalid agreement. And it also added that the court should test this at the stage of Section 11. So, and that was a major concern for a lot of businesses. Maybe not for law firms and lawyers, because we were, approached by so many companies, and they were fixed that what to do with their contracts, agreements, approaching the concerned authorities for stamping of the contracts. But it was complete mess, as from the perspective of the corporates and the business houses, because there were several contracts and issues like which state stamp duty differs from state to state, which stamp act or which state, according to which state they should impose stamp duty. So all those issues have crept up. But thankfully, the Supreme Court, I mean, this matter was again referred to 7-judge bench, and Supreme Court was very swift in acting and overruling this. And finally, it has been decided, saying, in the 7-judge bench judgment, the Supreme Court has created that distinction between inadmissibility of a document and validity of a document. So they say that if the underlying agreement is not sufficiently stamped as per the Stamp Act, it could be inadmissible, but you can't say that it is void or it is invalid. So because again, relying on the underlying principle of severability. So now that has brought some clarity, for the business houses and councils and arbitrators, people who are sitting as arbitrator. But also the Supreme Court in that judgment said that if the arbitrator feels that this needs to be stamped, then of course that can be taken up, and that those issues, it can be sent for proper stamping. In my personal opinion, after that judgment, I think that lawyers and arbitrators are pretty relaxed, and I have not seen arbitrators sending those agreements for stamping, and the process has been smooth. And the most important part is that the courts are not interfering at the stage of Section 11, because in that judgment, the Supreme Court also emphasized that at the stage of Section 11, you can only see the existence of an arbitration agreement, but cannot go into issues like non-stamping. That will also be against the Section 16 competence, doctrine of competence. So I think right now that 7-judge bench judgment has put those issues which had arisen earlier to rest, and the field is pretty much comfortable for lawyers, arbitrators, and business houses.
Great. Thanks. Yes.
I just have one thing to add over here. I mean, there's a little bit of a practical concern as an arbitrator. So now the buck has been passed on the arbitrator, because issue of stamping being an issue of admissibility is within the remit of a tribunal. But if you look at 38(1) and 38(2) of the Stamp Act, because we're still bound by the Stamp Act as arbitrators, if at the stage of the evidentiary hearing, an unstamped instrument is not going to be admissible. Now, yes, as an authority with the consent of the parties to receive evidence, I have to impound the instrument. But in practical reality, what teeth does an arbitrator have to impound that instrument? I can at best prepare a letter saying that please impound this, please adjudicate the appropriate duty leviable on this instrument. How more meaningful or more binding is that for the stamp authority as opposed to a party doing it? So ordinarily what tribunals are now doing is let the claimant or the respondent, in most cases the claimant, give an undertaking to adequately stamp the instrument. But that has to also be factored in 29 capital A, because I can't have control over when the stamp issue, because right now I'm doing an arbitration and everyone is saying that all the concerned authorities are on election duty. So there goes 2 months, and my meter is is down in that sense for 12 months under 29 capital A. So that kind of clarity needs to be given, because otherwise we will end up delaying the process further.
A fair point, but I think yeah, all these teething points will be more clearer when high courts take over these issues in matter-to-matter basis.
I don't want to eat it too much into anyone's time, but I'm sort of married to this matter because I had the pleasure of appearing in that
Yes.
matter. So I'll just see, it's not going to be very different whether the court did it, because it's the same amount of time, right? So, but I think may just add one thing, which was which already Sonal has alluded to. It's a very, I think for everyone here, it's a very interesting issue which weighed in with the court as well. At the issue of stamping, if you say that the document is invalid because it's a curable defect, if you pay stamp, something that's void is never resurrectable. It's void and then dead at its heels. So this is something that is just an interesting law point which you all might want to think about.
No, that's
Because
food
the
for thought.
five-judge bench had said,
Yes.
right? So that's something.
Okay. Now coming to the next point, and I think most of us who've appeared as counsels or made filings have had experience of dealing with some defective filings of 34 and the whole issue on timelines and are you saved, are you not saved, and refilings. Now, the Delhi High Court has recently referred this question to the larger bench whether some form of defective filings can be considered as non-est, meaning thereby that you do not get saved on time and it will not be considered at filing at all. So my question is to Mehul on this as what are the what exactly is the question which the court wants to get answered, and what kind of filings could and should be considered as non-est, therefore not triggering your timeline under 34?
Thank you for your question, Samir. It may seem like an innocuous question at first blush because it's very procedural and technical. Our clerks may do it and let's just go ahead and finish it. But the flurry of judgments and matters before the High Court in the past 12-15 months has made it a very relevant question. So to answer that, it can be, I think, divided into two buckets. First is with respect to a fairly well settled principle about the mandatory nature of limitation under Section 34. It is an interesting point there is that it is divided into two parts. First is an initial period of 3 months and then an additional period of 30 days. Now, usually what people end up saying is that, oh, there is a limitation of 120 days. That may not be right, considering the fact that if, for example, you're in the month of February or July, the time period could be 121 days or it could be a 118-day period. So, but at the end, fairly well settled that it is a mandatory period. The moment you skip it, your right extinguishes. Now coming to the question regarding non-est filing. What is non-est filing? Again, the High Court in a plethora of cases has held that it shouldn't be a bunch of papers that you file merely to defeat limitation. It has to be something when the court or the registrar reads, it has to come out to be a Section 34 petition. It just cannot be a bunch of papers. Now, what are the essential principles of a 34 petition? You must have an award. So if you don't file an award, of course, it is a non-est filing. Second, the grounds of challenge. If you don't have a ground, if you've not put in the grounds on which you're challenging the award, again, it is a non-est filing. Issues actually come when you start dealing with slightly procedural aspects. Was there a wakalatnama filed? If filed, was it signed? if signed, was it signed by the person having a board resolution or a power of attorney? Was there a power of attorney or a board resolution present before the with the petition? And now the question of statement of truth also comes in. Now, as we know, statement of truth was introduced by the Commercial Courts Act and then incorporated by the amendment to the CPC. Order 6, Rule 15, capital A, if I'm not mistaken, talks about a statement of truth. Now, what is a statement of truth? It is essentially a fatter and meatier version of an affidavit. It has all the principles and essentials of an affidavit, including 2-3 other statements, such as the number of pages in the petition are X, all documents are certified copies or original copies or copies of the certified copies, and then you sign it. It has to be stamped. There should be a company stamp, and then it has to be notarized by a notary and an oath commissioner. Now, what happened before the Delhi High Court recently in April was that a statement of truth was not filed with a 34 petition. So in the case of Bharat Broadband before the single judge, both sides put forth 2 decisions of the division bench. One decision was in Sai Rama, in which the court said it is merely a procedural defect. Therefore, I'm allowing it because from your petition, I can make out it's a 34 petition. It has all other principles and all other requirements are fulfilled. Therefore, the mere filing or non-filing rather of a statement of truth is just a procedural defect. I'll let it go and I'll allow your refiling, and there is no, and I'm allowing a condemnation of delay. Subsequently, last year, the division bench in Planet Cast held that if you read the CPC as amended by the Commercial Courts Act, and as all filing lawyers, at least before the Delhi High Court, would know that the Commercial Courts Act is applicable on all matters pertaining to Section 34, 37, so forth and so on. It said that since it is mandatory, because the wordings used in the in Order 6, Rule 15, capital A, make it mandatory. Therefore, it is not just a mere procedural defect. It is a defect which is inherent. You've not filed it, the statement of truth. Therefore, it is a non-est filing. Non-est. Now, these 2 decisions were placed before the learned single judge. The learned single judge was of the view that this requires an authoritative decision, and he's referred the matter to be placed before the Chief Justice, and in all likelihood, the Chief Justice would be setting up a full bench of 3 judges.
Right.
It's been done, I believe.
Just before we close this question, I think the judgment in which it has been referred was Shashank's judgment. So it's very imperative for you to.
Yeah, so there is a further update in this. Another decision has been referred to larger bench that was recently done.
Bharat Broadband.
No, this is in my case where I was appearing for the Union of India before the division bench. The division bench, of course, was looking at its own Sai Rama judgment and a coordinate division bench's Panacea Biotech judgment. The question really that now has been sent by division bench to larger bench is whether non-filing of an award in itself is a non-curable defect, because the division bench was referring to the reasoning in Sai Rama to say that all of these defects have to be seen cumulatively, and if it is an intelligible filing, one of the defects cannot be isolated to say that, okay, if you've not filed the award, you're out. So on this question, there has been a further reference, and this was as recent as 4 days ago. So even non-filing of an award, this question has been added to the list of questions now that will be answered by the larger bench.
Basically, 1 step forward and 2 steps back, because if the question of non-filing of an award is also before the full bench now, or the larger bench is.
Right.
Just to conclude, I just also wanted an interesting question came up in one of our matters regarding non-est filing, was the applicability of what kind of rules, whether it is the original side rules of 2018 that will be applicable, or as we would know, there in the Delhi High Court website, there are a certain other Delhi High Court rules and orders which are available just on the website. So the main difference between the 2 is that in the original side rules, after 30 days aggregate for refiling finishes, you can still approach by filing a condemnation of delay before the registrar. However, was missing in the Delhi High Court rules and orders, in which it stopped at 30 days filing. So in our case, the learned single judge actually relied on a division bench judgment to hold that the original side rules would supersede, considering they were later in time. They were prepared under the Delhi High Court Act, and there is a notwithstanding clause which gives them superseding powers. So just so that everybody knows
Sure.
that this was
Thanks, Mehul. We're short on time, but I must also talk about Section 34 and 37 court's power to modify an award, and I think there's a lot of debate on whether modification should be allowed, whether India is ready or India needs it. What's the situation globally? Divya, my question is to you, and there has been a reference by the Supreme Court on this question, but more conceptually, do you think India needs a modification power, or will that be too counterproductive for India?
Thanks, Amir, for the question. First of all, thanks, Dr. Batra Ashima, for inviting me. I know I'm on borrowed time right now, so I'll be.
No, you're not. I will take that liberty. So please go ahead.
Okay, so I'll try to be quick, but cover the point. I think the discussion needs to be, and it's like, let me divide it into a spectrum, which starts from a very strict view that you can either set aside the award in full or partially. Then you move a bit on the lenient side, you go towards an aspect of severability. Then you move further, then you go to a situation of Article 142 being made applicable to do substantial justice. Then you move further, you go to a sort of a modification only limited to the extent, let's say, of an interest component. And then finally, the end is where you decide to modify an award. So that's the spectrum we are looking at. In that, Hakim, which is Arush mentioned, NHI versus Hakim, is a judgment which is somewhat in the middle, where Justice Nariman, while going through all the case laws, decided that you cannot modify an award. What you can probably do is to partially set aside or sever a portion of the award. You cannot modify. Yet, interestingly, Supreme Court, while passing its decision, exercised 136, 140 to actually modify the award. So that was the interesting aspect. So what I will like to point out is that the word which Justice Nariman used, Lakshman Rekha, I like to add a phrase to it. I'll say that now the position in which is what the larger bench is likely to see is a Lakshman Rekha versus Dharam Sankat. So Lakshman Rekha is a situation where you don't want to transgress into the boundary of arbitration. You want minimum judicial intervention. You want a finality to be achieved, as opposed to doing a substantial justice. Consider a situation where you are not in a position to partially set aside the award or to sever any particular portion, but it's not ultimately doing substantial justice. So you're not left with a choice to even modify it. So I would say a fine balance needs to be drawn between them. There have been instances where courts have exercised this balancing act by, though minimum two aspects of interest component, as I pointed out, there are judgments to that effect where they have exercised it. There are case laws where, and in fact, I would refer it to what Justice Yashwant Verma did in NHI versus Trichy, that he said that you can sever a part of the award. You should exercise the concept of severability. If you can actually devise out of a particular claim, that part can be removed. So I think it is all about striking a right balance. As I said, you cannot take either of the end of the spectrum and be happy with it, because somewhere or the other you will face a situation. I am currently faced with a situation where there was an arbitral award. Out of 13 issues, 12 issues were decided in my favor. It was a specific performance versus a damages case. Ultimately, the damages, they gave nominal damages and be done with it. My client challenged it 34, 37 now in Supreme Court. Supreme Court is in a position to see whether that damage quantification, can they go into this aspect at the stage of a 34, 37 and later on in 136. But we are left in a situation that either they send it back, let this issue after 15 years again be decided by an arbitral tribunal, creating a huge amount of delay, or the Supreme Court gets into the aspect of a judicial intervention of sort and says that no, let me for do substantial justice by fixing a sum around the damages, or let me appoint an expert who will determine it. So let me partially set aside this, or if possible, let me modify it. So it's all about striking the right balance. As I said, and time is less, so I'll just simply say it has to be a balance between Lakshman Rekha and a Dharam Sankat.
Very, very well put that way. And now I'm on borrowed time, and Ashima, I'm in a Dharam Sankat, whether to cross the Lakshman Rekha of this to ask 2 or 3 questions from the audience.
Yes, absolutely. We have some questions waiting for the panel.
Fantastic. Thank you.
Thank you. Thank you, distinguished panel, for the discussion. We heard the good, bad, and the ugly of the recent developments in arbitration. Before I go to Dr. Vijay Kumar Singh, Professor and Dean, Faculty of Law, SRM University, who has some questions for the panel and the young crowd that we have in front of you, there's a question that I would like to ask, which is, has alternative dispute resolution become a disputed resolution due to its own complexities and challenges? So, Samir, over to you.
Very interesting question. And I think we are in a situation where we keep on talking about making India a dispute resolution hub. We had the External Affairs Minister yesterday at the launch of ABI, who said arbitrate in India, we have resolve in India. But India comes with its own set of challenges and complexities. And you know, we have a very myopic view when we start criticizing the ADR system in India, because we are probably looking only at a very small cross-section of society which is using this system. We must understand that the mainstream arbitration practitioner, the phenomena which is only 7, 8, 10 years old. And as a country as big as this, as diverse as this, we would require another 15, 20 years for the system to really shape up, become stronger, and a preferred mode of dispute resolution. I must also say that we don't have any other option. We cannot stop ADR and go back to the courts, because courts are already overburdened. All we need to do is to put in checks and balances, not only for the councils, but the arbitrators. We need to put in checks and balances for the courts when they're dealing with 34. We need to clarify some, or rather demystify some issues which are plaguing or which are cropping up due to the complexity of our jurisdiction. So I don't think it's becoming something worse than it was already. I think it's only getting better. The problems which existed prior are just getting highlighted now, and because when they're getting highlighted, they'll be cured over a period of time. So that's my view on your question. Anyone else?
Yeah.
Thank you, Samir.
Just to add on to this, and thank you, Ashima, for having us on this panel. Just to add on to your to what you said, Samir, I think we need to look at from where we started and where we are, and that will give a lot more positive perspective about the entire dispute resolution system in India. And I agree with Samir that we are a huge jurisdiction, and I see very often that comparison being made with Singapore, Dubai, or maybe UK. And I must tell you that no jurisdiction is perfect. There are decisions which can be criticized from the UK courts, from the Singapore courts, but it's just that our jurisdiction is huge. There are so many high courts. The judgments which come are much more than what you would see in Singapore courts or UK courts. So the opportunity to criticize our judgments is more as compared to judgments which come in other jurisdictions. But I would like all of you, I would like to invite all of you to see the positive perspective. We are, the entire dispute resolution system is developing in India, and you see the approach of the courts, you see the approach of the practitioners, the arbitrators which are being appointed now. The quality of the arbitrators is great. We are moving towards institutional, arbitration. Mediation is on its way. So there's a lot which is happening in this jurisdiction, and I think that moving forward we have better things to see.
Thank you, Mr. Kumar.
Just one line, Ashima. Just remember that arbitration is not mediation, it's an adversarial system. And it's the job of every lawyer to be able to provide the best representation. So while Sameer is entirely correct that there are some things that have to be fixed to be able to reduce the timeline, perhaps, but that it should not be confused to say that ultimately, we'll sort of have some sort of a middle ground unless the parties settle.
Right. Thank you, Payal. Any other inputs on this, or we go to Dr. Vijay Kumar Singh? Also, a little insight that I would like to share with the room today, that although my journey in law was short, but it started with Mr. Sonal Kumar Singh in arbitration at AKS Partners. So it's great to have him in our midst today, speaking on arbitration.
Thank you for giving this opportunity to ask a question. I am from law school, and I would like to ask a question on behalf of my students, particularly because a lot of students come and they're aspiring for arbitration as a career. So, what all things they should look at their law school journey, and focus on which areas to become, to enter this particular field as an arbitrator. So that can be one thing which, if the panel can address. And I have one more question that is relating to the institutional arbitrations, because we are seeing a lot of development around that. A number of institutional arbitration institutions have come up. And what do you say as a panel, the future of these institutional arbitration in terms of, helping process or, providing opportunities to the youth which are looking towards to enter this particular profession? Yeah, thank you.
Yeah. So let me take the
Yes,
first
please.
one, and the second one you can. So for the law students, I think the couple of things they really need, apart from, of course, a good education system, which you guys are better equipped to provide and answer. I think internships, and if they have any arguing or oratory mind, then they should go for moot courts. These are the two important factors I feel are relevant to build up the students' overall horizon of the legal landscape. Do as many internships as possible. That will give you a great idea about how which particular area of law, which particular stream, practice area you need to focus on. And moot court gives you that added skill of how court craft, how to present your argument, even how to negotiate your deal in case if you decide to go on the corporate side of it. So these are the two advice I would have in case anybody would like to add.
Just one word, read. That is, I think, the most important thing. Because if you want, if you're aspiring to be an arbitration lawyer and you are not aware of the latest developments, like whatever this panel has discussed and things that go on, then you can't expect yourself to be an arbitration lawyer. If somebody comes to, I think, all of us for an interview, we don't expect them to be perfect drafters or anything. The only thing you expect is knowledge. Because if you claim on your CV, yes, I want to do arbitration and I want to practice under you, the first thing everybody asks is, okay, what do you know? So you have to have that knowledge. Therefore, the only word is read.
Yeah, very quickly, apart from what is taught in the classroom and your experiences as interns, I would say every student should be encouraged to look up these courses that are being offered by some of the top institutes and associations across the world. Whether it is the CIR, whether it is the IDA, which has a students initiative program, whether it's the ICC. So therefore, today a young law student has a wide array of options which are beyond the confines of his or her classroom, and those should be explored. And even colleges should consider forging good relationships with the India branches of these associations. Most of these global associations have an India branch, India chair, India ambassador, representative. Try and forge tie because it's a great think tank they have to give you a perspective from beyond the borders, best practices across the globe, which may not sometimes be disseminated in a classroom. Sometimes they may have certain inhibitions, and even in a internship in a law firm, because a lot of law firms do a wide array of work. We still don't have super specialized, dedicated arbitration. I mean, of course, we have some experts here, but there are very few of them. So, yeah, this was my 2 cents.
Just another 30 seconds before I request Shashank to take your second question. Is managing expectation? I think why we need to ask the students a question. Why do you want to do arbitration? Because they see the glamour in the arbitration. They don't see what goes behind. So it's very important to understand you cannot do arbitration to the exclusion of any other thing. Arbitration is a dispute resolution mechanism. What you do inside that dispute resolution mechanism is important. You need to be thorough with your contract law. You need to be very, very thorough with how you cross-examine the process. So, and to learn all of that, you will have to slog your time in the courts. You cannot say, I will not go to the court, but I will only do arbitration. I'm sorry, that's not going to happen, at least in this country, because the way we are structured, there's a lot of arbitration-related court litigation, which you will have to go to the courts and do. So, while it is important for you to know arbitration, is also important for you to get that skill set, which you will get ultimately by dealing with so many other things, but arbitration. So manage expectations.
Before I take on the second question, just one more input. A lot of students, straight away ask, or rather make an elementary mistake in asking the right question. They all want to become arbitrators. They all come to us and say, how do I start my career as an arbitrator? I want to become an arbitrator. I think that's a question that they need to ask 5-7 years down the line after practicing arbitration. So just adding on to what Sameer said, they need to first understand what arbitration is and manage their expectations accordingly and ask the right questions. If a student would come to me and say, I want to become an arbitrator, it's quite an ambitious statement to begin with. So the next question very briefly was on institutions. I think more and more institutions in the country is not a problem. I think we from a state when it was a monopoly of a couple of leading institutions, we have come to a stage of perfect competition. There are so many robust institutions in the country. Many of the foreign institutions also having dedicated India teams and seats. I don't think that it's a cause of worry. What is the cause of worry is mushrooming of institutions. There are so many smaller institutions erupting in cities who obviously are coming with a very different objective. They are not there to promote institutional arbitration. They see a business opportunity in it, and they're just putting two rooms together and are calling themselves an institution and are somehow able to get some of us to get empaneled with them, etc. That's a cause of worry, and that is something the Arbitration Council of India, as in when it is formed, is likely to take care of. But I think the debate between ad hoc and institutional arbitration was a debate which started 15 years ago. We're all a very mature audience and users of arbitration. I think now the choice is conscious. No, there is nobody who takes up ad hoc arbitration because they don't know about institutional arbitration. They make this choice consciously for good or bad reasons.
Thank you, Shashank. We also have another question.
Sir, this is Pooja from Lloyd Law College. I'm a student of final year, and my question is regarding third-party funding in India. As maintenance and Champati is there, So already it is there in the common law countries. I just wanted to know, first it has to be regulated in India also. So what are the insights, like how it can be regulated in India? We have read already in books about these things and all. I just want to know what are the insights of yours. I think you were talking about it, Arush Khanna sir. So I just want to know how it can be regulated in India.
Well, firstly, it shouldn't be over-regulated. It needs to, I mean, by the end of the day, if it's attached to an arbitration process, it is better if it's slightly more autonomous. And as Shashank was saying, self-regulation is important, but certain tweaks in the regime have to be made. Like 42 Capital A would have to be expanded so as to include TPF entities that are funding the parties. Likewise, issues you might want an amendment to the Bar Council of India rule, because if you remember the famous case of A.K. Balaji versus Bar Council of India, the Apex Court held that third party funding is not barred, so that so long as there is no lawyer who's funding the client. So that case law was also cleared in that sense. So what we need, and of course, when we are seeing foreign investment today, India attracts a massive amount of FDI, and with the opening up of law firms, foreign entities, we're going to expect more FDI. So what if my investor, or rather my TPF entity, is based in a country that shares a border with India? It's not an automatic route. So there are some corollary tweaks that are needed, but as a concept, I think it's much needed in our landscape. So yeah, I mean, it's work in progress. I'm sure we'll see the light of the day soon.
Thank you, sir. Thank you so much, sir.
Shah, you want to add to this?
Thank you. Thank you so much, panelists. It's been a great conversation. And we move to Aditya, over to you.
Thank you. Thank you so much. Can we have a big round of applause for all our panelists, our moderator as well? Thank you so much, everybody. Thank you. A picture, please. I also request Ashima Ohri, Managing Editor of BW Legal World, and Soul Kanala of BW Business World, please join us on the stage for this picture. Thank you. Thank you so much. Thank you. I always say this from food for thought. It's now time for food for your stomachs. It's 2 o'clock. It's time for lunch. Lunch is served at the back of this very hall. For the speakers, lunch is served outside. We shall reassemble at 2:30 and then start with the next panel discussion. Enjoy your lunch. Thank you.
Hi, welcome to Rounders. We are Rounders. We are having technologies. We are excited to introduce a suite of applications transforming the legal landscape with GenAI to deliver efficient, accessible legal assistance directly to your device. Introducing Advocates, our flagship solution for designs and barriers, for serious barriers for legal efficiency and productivity. Using, for example, a pilot platform establishes no benchmark for legal empowerment and accessibility. Using Upper education designed for aspiring legal professionals, sets new standards for individual excellence and ethical with lawyers, the future of legal empowerment is not the same thing, it's legal. Actions and executive work unravel success for the legal professionals and the public life. And today, I would like to announce that this new era begins with the launch of advocacy cell, followed closely by the channel and coming to you in June. Join us as we turn these groundbreaking visions into reality. I extend my gratitude for your attention and support. Have a good day.
That's what about privileges. Because of the sheer size of the market, it has been like the digitization will get democratized, along with a strong foundation of the ground of integration. The best stack is modern sources closer to clients, so tapping options. Thus, the development has led to muscle and as a short, nothing is modern solutions to learn styles and skill. A story and job of the functions of planning possibilities in the social and business world.
May I please request everybody to settle down so we can start with our next panel discussion. If any of your colleagues or friends are outside, can you also request them to come inside? So we can start now. Ashima, are you here? Is anybody outside? Can you just make sure? Before I start with the next panel, I also take this moment to once again thank our partners for today. Our executive partner, Waradi, our legal tech partner, Lawyer Desk, our knowledge partner, Chandok and Mahajan, advocates and solicitors, our event partners, Joy Travels Private Limited, Fandrum, Greenlee Coffee, The Thick Shake Factory, Reality Plus, Exchange for Media, IWM Buzz Impact, and Pitch. Yeah, not a problem, please. Section slide come up here. मैंने तो ट्राई मारा पहुंचे मैं नवली से बोलने वाला हूँ because I also you're leaving it to me. विभाग it's विभाग मैं पूछ लेता हूँ उससे. Okay, now that you've all had lunch, let's begin with the next panel discussion. This is on balancing innovation and regulation. Perspectives on technology, ethics, environment, sustainability, data protection, and future trends. While the panelists are already here, I shall introduce them quickly. Dr. Pawan Duggal, advocate, Supreme Court of India, expert authority in cyber law, cyber security law, and emerging tech law. There is also Tejas Pathak, partner, ELP. Navneet Vibhav, partner, Shardul Amachan Mangaldas, Vani Mehta, Regional General Counsel, South Asia, GE Aerospace, Lakshman Menon, Director and Associate General Counsel, Head of Legal India, Geo HP Enterprise, also Komal Gupta, Chief Innovation Officer, Sil Amachan Mangaldas, and this session will be chaired by Manir Vasani, Head of Legal, Southern Asia, India and affiliates, Indonesia and Philippines at Pinview. Previously, Johnson and Johnson I also mentioned last evening. Now let's welcome them collectively, please. एक बार जोरदार तालियों के साथ. Sir.
Thank you so much for that introduction. And I know the session just after lunch. I think I hope that it was interesting enough, and the panelists are going to make it very interesting, engaging. So let me talk about can you please tell us a bit about AI in the context of generative AI output?
It was day before last night at about 11:30 in the night. And I was supposed to be giving an opinion to one of the premier medical institutions on DPDP Act. So I said, okay, let me go to the most favorite child of today, GPT, ChatGPT 4.0, and ask them some fundamental questions on the DPDP Act. And lo and behold, it started giving me answers that I could not believe, because those answers were completely off the mark, had no connection whatsoever with what the law was saying, but the confidence in which these said answers were being given actually was enough to fox anyone. I think this is the latest example to tell us that, look, guys, the technology is moving very quickly. Yesterday, before yesterday, China and France have now signed a new memorandum of understanding to collaborate on AI. But the fact is, when everybody is talking about AI, what happens if AI starts vomiting false information, or as we say, hallucinated content? Right now, there is no clarity in the world at large, right? Yes, You do find lawyers being fined $5,000 because they used ChatGPT for generating written arguments which had false cases. But there is no liability for the company yet who is actually giving you the stuff. And I think very quickly, I believe that the process that's going to go on is going towards more of responsibility and accountability. I look at the law in New York on AI, and I find the focus is very clear. They want auditing as a de facto basis for minimizing bias or description. I go to the Chinese generative AI law, which came into effect on 15th of August, 2023, and they are very, very clear. Should you come out with anything as part of your output of generative AI, you will be responsible. There'll be fines imposed upon you. There'll be disciplinary action, and even there could be criminal action apart from blacklisting you in the Chinese context. I look at the European Union's AI Act, and I find that they have still not very much gone in the particular direction. So right now, it's still work in progress. It's going to be a great technology. OpenAI has said, I'm coming up with a new search engine that's going to overtake Google in the next few weeks. Now, that's what the stuff is happening. The focus is, how do we deal from a legal policy and regulatory standpoint on the legal liability of AI service providers and the liability specifically for output? Now, traditionally, I advise a number of these players in India, and they are saying, guys, consider it as a good luck that we are giving you stuff. But please understand, we are not going to be liable. Why? Because in India, we want to come under the statutory exemption from legal liability under Section 79 of the Information Technology Act 2000. Little do they realize that they haven't even gone ahead and read Section 21W of the Information Technology Act 2000, which is saying that for you being an intermediary, you will not have to, you'll have to ensure that there's no editorial control. Now, when you are a generative AI, you are generating content. Yes, you say, I don't know what I generate. What your prompt is will determine what I generate. Fantastic. But does that mean there is no training at your end? Clearly, no. Does that mean that every data that you are getting collected with each particular search or query, are you not using it? Look at the terms and conditions, look at the privacy policy. They say, by and large, whatever you are sharing with me on my generative AI platform, I will be using it for training. So when they are using these entire exercises, I believe it will be very hard for AI service providers to really keep on successfully arguing that they are intermediaries under the Information Technology Act 2000. And of course, if there's going to come out with output which is wrong, which is hallucinated, which is false, or which is malicious, the question is that small disclaimer that we can make mistakes, be careful. Is that enough? I don't think that's going to be enough. So very quickly, I expect in the later months of this year, far more very quicker legal developments to take place on affixing more liability on service providers who are providing AI platforms for the purposes of making them more accountable. Now, it's a bigger issue altogether. How will you actually enforce this? Because globally, there's no one law or treaty on artificial intelligence. There's not even any law on cyber per se. So in a scenario like this, it will still be dependent on the national laws in respective countries who will be deciding what will be the legal liability. Now, considering the fact that it's only a handful of nations that have now come up with some laws on AI, there is a list of about 32 laws that have been passed. The fact remains is none of these laws have still gone ahead in the particular direction of legal liability. And how do we deal with this particular story that's come from Costa Rica? In Costa Rica, in a municipal corporation, a municipal corporator proposes a law, a bill. The bill gets debated, passed by the corporation, and then becomes law. 2 months after it has become law, the corporator has now disclosed, I did not write the law. I got ChatGPT to write the law. And that's put the entire corporation in a big tizzy. So the question will be, the liability will be a very, very ticklish issue to be determining. There are no crystal clear answers. But yes, you can't say that I've created a black box. You use it at your peril, but whatever comes out of it, don't make me responsible. That unilateral argument, I don't think is going to be facing much kind of a support from various stakeholders. But how this law will develop will also be very, very crucial. And it's hard for me to predict. A lot of people are saying, hold on, let's still rely upon the traditional law of torts for making them liable. But the fact also is, in the traditional law of torts, we are primarily dealing with duties of humans. For that, I still have to come back to the fundamental question, can we consider artificial intelligence as a legal entity? Can AI be sued? Can AI sue someone else? And number two, what happens when AI commits a crime? Recently, we're doing a matter where AI has been used for the purposes of doing a criminal activity. And that criminal activity has caused wrongful loss to the affected person. Now, we are able to reach out to the algorithm, but we don't know who's the person who's done that. So clearly, there'll be need for determining principles for ascertaining criminal liability, for ascertaining civil liability. And this is work in progress. And till such time that happens, the only guarding mantra will have to be that we will have to be more cautious, more careful, more duly diligent when we are using this. It's like the new toy that has been created for adults. We are fascinated by this new toy, but very quickly we'll have to start realizing that any use or misuse of the toy in violation of expected community standards could potentially be exposing stakeholders to legal liability. What? Not yet clear. Does that mean no liability? I'm not definitely saying that. Does that mean let's do whatever we want to do and wait till such time new law comes in? Not a problem. I think you are actually playing with fire at your own risk. And now with the Hanuman AI being launched in India, which is actually giving you generative AI in 20 different Indian languages, you have problems that are going to be very much complicated and confounded from legal liability. So I'm going to give a command to Hanuman saying, look, give me this particular output in this particular language. And I don't know that language, and that language comes out as an output. I rely upon that. And lo and behold, it could either contain stuff which is in violation of the law, or could be potentially obscene or defamatory or whatever. Can I be made liable? So clearly, there will have to be rules for determining the liability of users of generative AI at one hand. There will be need for developing the legal liability of service providers who are either providing these Gen AI services or who have actually gone ahead and coded. Now, the fundamental question finally that comes up for consideration is, can the coder say, I did nothing, don't make me responsible? Hold on, it's the coder who wrote the code. So can the coder say, I'm off responsibility? I'm personally of the opinion the coder will never be able to wash away his hands of legal responsibility, but the laws will have to keep on developing. We'll have to wait and see how things happen, but very interesting times. But till such time that happens, caution, care, due diligence will have to be a mantra. Don't expect that you can sue an AI today and be successful, because AI is still not a legal entity. Don't expect you can sue a company behind an AI. Yes, there are oodles of litigations in the US against the OpenAIs, the Microsofts, the Googles of the world. But most of that is only limited to infringement of copyright. They are saying, guys, we are the owners or we are the authors of original literary works. You guys have trained your AI algorithms on my works. That's tantamounting to copyright infringement. Please pay me damages. But while all this is happening, something is coming from Japan, which is leaving the entire world dumbfolded. Japan is saying, sorry, if you are an AI algorithm and you are training yourself on copyrighted works, we don't see that as an infringement of copyright. We are seeing that as fair use. So the entire jurisprudence around infringement of copyright, fair use in the context of AI is being turned upside down. Very interesting to see how things happen in the coming times. Thanks.
Thanks so much, Dr. Pawan. As very informative, interesting, and I know that it's like ChatGPT, we've just scratched the surface. There's a lot more to come. I didn't personally know about Hanuman, very informative. And as we were talking, I had a lot of questions in my mind, but I'll hold my horses because of the paucity of time. After the session, I need to talk to you. But thank you so much for your insights. Yes, changing gears now and moving on to the topic of sustainability laws. We have Navneet here. Navneet, I have questions for you. So, how do you see the relationship between education and regulation from an environmental perspective in India? The second part is, what is it that the industry and government could do better, foster innovation and reap its benefits?
Thank you. And so I think to answer your question, first question, innovation pretty much should drive regulation the way I see it. Because what is happening, unfortunately, is, and you'd agree, in if you're talking about, waste management, especially plastic waste and a whole lot of things, the regulation is actually kind of driving innovation. And that is where the problem starts. Because many a times, and if you take the example, any example, for example, if you take the example of managing plastic waste, for example, and there's something we often talk about is, biodegradable plastic or something like that.
Yeah.
Now, my understanding is, if it's something which is biodegradable, it cannot be plastic. Because the very reason, if you see the chemical composition, as also mentioned in the regulation itself, the rules and the statute and all of that, of course, the plastic waste rules, it clearly is something which cannot be biodegradable by the very nature of it. So the unfortunate bit is you'll have a whole lot of people, talking about it. They'll come to the lawyers. They'll say, what is this? What is it that we should be doing? And see, I tell them very clearly that, I'm a lawyer. I'm not a scientist. And the idea simply is, if this is, and whatever little science I studied till class 12th and chemistry, I understand that if this is the substance which is kind of required and this is what makes plastic, then it clearly cannot be biodegradable. So all I'm trying to say is that, I think there's some thought which has to go into this kind of policy making. There is some thought which also kind of, and I think, forget that. Also, there's a whole lot of requirement where you have to have the companies have to have these certification from the urban local bodies. And then you kind of go and submit what you're doing in terms of your, extended producer responsibility and all of that, EPR goals and all of that. Now, for a company which actually has operations across the country, if you expect them to actually go to each of these urban local bodies and kind of, collect this on a regular basis, on a monthly basis, it's just not practically possible.
The infrastructure is not there.
The infrastructure is not there. And that also kind of leads to a whole lot of corruption. It breeds corruption. So something of this sort, this kind of requirement coming from the Central Pollution Control Board. And this is something which I'm saying this from experience because I've actually represented a whole lot of companies before the CPCB in matters like these. All I'm trying to say is that, when people come up with these kind of requirements or, come up with these kind of regulations, they should actually kind of give some thought to it. Now, the reason I say is because innovation actually should drive regulations. For example, this was one part with respect to regulation bit. Now, what really comes to my mind, if you're talking about innovation, I think there's a whole lot of stuff which is happening right now and which also needs to be promoted. For example, if you're talking about, say, conservation. Now, I've done a matter before the Supreme Court where, it was with due respect, you have a whole lot of activists also which come to the Supreme Court with all kinds of environmental issues. And this was for a company, of course, I don't know the name. They're building a 100-key hotel somewhere in Uttarakhand. And the concern was that, they've actually cut a whole lot of trees. And what we actually did was we got these satellite images through some website and all of that. And, so we were actually successful to show that, through this satellite imagery, we can actually have this green cover. And which clearly showed that no trees were cut. And, say a couple of years before or later, we showed those images. And of course, we kind of, got away with it. But there are also challenges to it because, and I say this because this is off the record, that, because a 4-meter or 2-meter shrub also will look like a green cover or a canopy from the top. It need not necessarily be a fully grown tree. So there are ways in which, if I, as a lawyer, and if anyone is a little smart, you can actually use technology to your advantage. And also that may not be the best thing for the environment. Now that actually gives a lot of scope in terms of, how technology can be utilized for the betterment of the environment. Because so that was, of course, one stray example. But if you're talking about, depleting forest cover, for example, now I think we are somewhere, the State of India's forests report, if you see every year, they claim 23% or whatever. The reality, I'm pretty sure, is less than 20% because a whole lot of green cover, which does not really qualify as a tree, is also being counted as green cover. And at least when I was in school, I would always study that India's forest cover or green cover is 30% or 33% is, of course, the requirement. But you can use a whole lot of technology to kind of ensure that you kind of promote conservation, green cover, air quality monitoring system, water quality monitoring system. There's a whole lot of stuff which is happening with respect to, a whole lot of discussion with respect to electric mobility. Now, what are the things we can actually kind of, and I'm sure that, and to answer your second question on that, the government is actually promoting a whole lot of startups, where they want to kind of also promote startups which are actually coming with innovations in the area of environment conservation, sustainability, and all of that. So my simple point is that I think where we really need to kind of be a little more innovative and a little more patient is, I think first we have to have the right kind of innovation. We have to see if that is actually feasible. We have to see, as you know, what are its pros and cons over a certain period of time, and then kind of frame our regulations in a manner, because then it'll be a more, I think, well thought, sustainable kind of a, lawmaking. And I think it's also good because then you also kind of have had some kind of consultation with the industry bodies, and they kind of agree with the idea, buy the idea, and they are like, they're on the same page. Because what really happens is you come up with the regulation first, and then you have the industry bodies going to the CPCB and the MOEF and giving representations, and that really doesn't serve the purpose. So I very sincerely feel that when it comes to environment or sustainability, there is a lot that can be done in a country like India. And I think we have the right kind of talent which actually is capable of coming up with brilliant technologies at very, very low cost. And I think the government and the private sector, of course, should kind of collaborate to ensure that, you kind of promote such innovation. So, and once you have tested that this is really something which will help beat in terms of carbon capture, sequestration, and a whole lot of things, air quality, water quality, biodiversity conservation, wildlife conservation, you have a whole lot of technology being used for wildlife conservation these days to see the habitats of these critically endangered species and ensure that your conservation efforts are actually carried out in that fashion. And that is where you should kind of decide as to what is the kind of regulation that you want to have. Let's talk about that. And then if there's more time, then we'll talk about it. Thank you.
No, as you were talking about a couple of things from the industry perspective, because I'm on the other side. What we are saying is that regulations have come, which we have over times, and industry don't have any option but to go and make a representation. Paper straws is a classic example, and this is a very important point about there are people around who are able to help in India. They have a lot of stuff around sustainability. I remember our R&D telling us that there is an alternative to paper straw, which is bamboo straw. It's made of bamboo, and it's 100%. I don't think any country has explored this. So the government to encourage such kind of things which are alternative to plastic and not sustainable. But thank you so much for that. And your passion for sustainability also comes through. Thank you. Lakshmi, I have questions for you. How can you balance innovation and policy in the face of unprecedented technological advancement in artificial intelligence? That's one. And AI's carbon footprint is rapidly growing. Please would you shed light on the opportunities and challenges that this presents for us? Thank you.
Thank you, Mayur. I would start by first, making a statement where I draw parallels between artificial intelligence and humans, because one creates the other. And now we also see scenarios where the other seems to dominate, humans. So I like humans. I think artificial intelligence is also very paradoxical in the sense that from a human rights perspective, it both threatens, the advancement of further inequalities. And at the same time, it is used extensively in order to promote human rights. In the context of human rights, I think one of the biggest topics extensively discussed is in the areas of data privacy, data transparency, data governance. And the other important aspect, which is also extensively talked about, is employment, because there's always this constant fear and threat that artificial intelligence will start displacing people from their jobs. So I'll first start by talking about data privacy and data governance, because those are extremely relevant. And especially with, the requirements of explainable AI, and that gathering a lot of momentum and a lot of research being done in order to bridge the gap between what is called as opaque algorithmic decision making vis-a-vis, the need to ensure that there is clear transparency. I think that's what's driving a lot of research around explainable AI. Now, if I have to shed some light, I'd like to talk about 3 specific use cases. The first being that of how artificial intelligence and facial recognition is used in smart city projects. So I represent a technology company, and in Hewlett Packard Enterprise, we have had the privilege of working with the public sector in around close to 70 odd smart city projects. We've deployed facial recognition in those projects. And I will like to, highlight how it has been used both in order to drive efficiencies in management of a city, and how it has also presented certain surveillance risks. So when you deploy a solution like smart traffic management, what essentially a company like ours would do is set up a data center a command and control center where we monitor how the traffic is moving in different parts of the city. So just to ensure that you decongest the city with, traffic clogging, etc. But while this has been proven to be very advantageous and very helpful in cities like Bhopal, or you look at cities like Dehradun, the flip side of, deploying facial recognition is that oftentimes, governments want to use the data for purposes beyond what it has intended to use it for. So while it's supposed to help with traffic management, sometimes our project managers get requests saying that, can we use the data that you get also to monitor how our drivers who drive state transport buses, how they are functioning? And they use it to track drivers' absenteeism, their attendance. So the data is clearly being solicited for purposes beyond what it is intended. And that's where we see a deficiency even in the regulation. Okay. At the same time, I would say that smart traffic management has significantly helped cities like Thane, Bhopal, Dehradun. And the positive thing also is that we've used it extensively for tracking crime, right? What's fascinating is even there, it acts as a double-edged sword. So on the one hand, it is used to say, like during the COVID pandemic, it was, facial recognition was used extensively to map containment zones. So these smart city projects, in fact, doubled up for even, stepping in to perform these sort of services, which was not part of the project, but we were monitoring containment zones. We were also additionally asked to do things like, monitor crime activity in certain areas. So countries like Argentina, for instance, has perhaps taken a lead where they've realized the potential of AI. And they've used it to reduce crime in certain areas, right? But the flip side is, all the surveillance equipment that's deployed is monitoring the faces of individuals, and in a way that's being used for purposes beyond the scope. Recently, we got a very peculiar request from a local law enforcement agency where they wanted to, they wanted to investigate a bomb scare. And in connection with that, they sought a whole lot of data from us with no specific time frame or time reference. So it was like an unrestricted demand for flow of data. So those sort of demands sometimes can prove to be fairly daunting, because that there's no regulation, there's nothing regulating it. And it's very difficult when you're dealing with either law enforcement or with the government to say no to them, right? So that's where regulation plays, I think, a very critical role. The other, important use case I'd just like to talk about is how artificial intelligence is used in the admission process in universities. So there was this study done on how AI can prove to be a huge game changer in the admission process, because you can identify the best talent and people who bring in perhaps the best and highest rate of success if they get admitted into a university, right? At the same time, the same technology can even perpetuate biases and can, in fact, enhance the chances of inequalities, because the historic data that is used to input the AI training model or the tool is historic data, which will perhaps have data which prefers one particular race, one particular group of people, or perhaps, prefers a certain kind of student. So that in a way is already perpetuating bias. So that's why I said it's like a double-edged sword. So you can use it to, your benefit, and it also has the potential for backfiring. NITI Aayog has come up with a set of principles for deployment of responsible AI. There are two important considerations that they have kept in mind. One is from a societal perspective, and the other is from a system perspective. The reason I talk about both these aspects is because the government is already taking such a decisive role in taking it forward. In fact, last year in the GPAI summit, which took place here in Delhi, what it fortified was the government's stance in terms of bringing together together governments and private sector entities, researchers, and academicians to come up with a sort of strong policy or a commitment to drive trusted stewardship when it comes to AI governance. So in that sense, there's already a firm commitment that's being seen from, the government side. And they know that this partnership will not work without the support of the extended community because it's going to be used by both sides. So that's very important to take note of. Why I talk about the government's commitment is because right now there is a gap in what is happening in terms of responsible development and responsible deployment. Now, these two things are very different. Responsible development becomes very critical because you need to ensure that the data that goes into any AI training model is not biased, right? And how do you ensure that? One, by ensuring there's proper training given to your technologists, ensuring that there is a fair representation of people from different groups so that whatever data they put into an AI training model represents a wider audience set. So your data is not underrepresented. The other thing is to bring this topic as a boardroom conversation, because in more and more organizations, especially when you're deploying artificial intelligence, there is very little thought given to what is our AI strategy? Why are we deploying it? What is the outcome that you want from it, right? And how much data will you use in order to bring your AI training model together? So these are some very important questions to dwell into. The other and last aspect on the first question that I want to complete by saying is, for responsible AI, there has to be also a cognitive bias test that is applied to ensure that people who come and work on these technologies are not biased. Very, very important to sensitize people about it, because I think that's where there is a huge gap. And to make governments also responsible and bring in the right kind of regulation. On the second question you asked, I'll just like to talk about how our organization is dealing with sustainability and, with especially from the perspective of new technologies in the context of AI. The first would be, so Hewlett Packard Enterprise currently has a sustainability goal of a net zero target for 2040, but this is going to be so difficult to achieve. And while it sounds very rosy and sounds very ideal, we understand that it's going to be a very arduous journey. And why I say that is because we already have servers and storage and computing devices which are manufactured from a sustainability perspective. So when we sell our products and we deploy, especially edge to cloud computing services, where we provide or lease our equipment so that people don't have to buy it and all of that, which again increases carbon footprint. We give them sustainability dashboards so that they are able to monitor their consumption, energy consumption, carbon footprint, costs. Right? These are the three most driving factors while making any decision regarding investment in technology. So this is something that our organization does. Apart from that, I also just want to, quickly highlight that at HPE, one of the interesting things we do is we also believe in upcycling our technology products, which is one of the coolest things we do. So I've visited one of our factories, and a lot of the used chips that we use, especially for our servers and in some of our computing devices, they all get recycled, upcycled, and it's very cool to see. I would say that AI, especially in the sustainability sector, has been very fascinating in my view, because, like in the aviation industry, you look at like data centers, like companies like ours, we support a lot of data centers, and those are very fascinating places, but they emit the highest amount of, greenhouse gases, equivalent to that of the aviation industry. American Airlines, for instance, they have in fact introduced, AI primarily to monitor vapor trails, right? Which again contributes significantly to your, to global warming. It's used obviously for predictive analysis like floods, earthquakes, other pandemics, etc. But what is most fascinating is the final takeaways when you look at how you can use or deploy AI sustainably. So just a few takeaways to conclude. One, it's very important to first see whether you really need artificial intelligence embedded in a technology, because you don't need it for everything. So it's very important to have a clear strategy because you don't need to embed it. Second is to use solar energy energy or to use other forms of green energy while developing AI. Because the biggest problem with models like ChatGPT 3 and 4 is even just to answer 15 to 20 questions, it takes 500 ml liters of a bottle of water. Right. So again, a lot of water consumption. Like Google, for instance, they admitted to the fact that when they were developing their large language model, they ended up spending close to 1 million liters of water. In their justification, they said that, we only use wastewater. We don't use any fresh water. We use seawater. But, they now have a commitment to replenish that water, by 2020, to around 120% by 2030. So companies are also increasingly becoming, conscious of this. And last but not the least, I would say that to deploy AI in a sustainable fashion, it's also important to look at where you're going to deploy it. Because if you deploy it in a warmer country, like an Asian country, the amount of water consumption is just going to go through the roof. Whereas when you deploy it in countries like the US or slightly colder countries like Canada, the water consumption is less. So it's very important to keep these factors in mind. Thank you.
Thank you so much, Lakshmi, on this. As an in-house counsel, I was just wondering how different our fields are. When you visit a factory, you see a chip. When I visit a factory, I probably see chips. Pretty different, Yeah. So moving on, we have Tejas here. Tejas, I'm a big client of Tejas. Tejas is an expert in tax laws, customs, indirect taxes, GST and all. So welcome, Tejas, and let's see how tax fits into the scheme of discussion that we are having now. So my question to you is, in light of the pressing need of environmental conservation, do you believe that tax policies can actually push sustainable practices, or is it not like a regulatory or environment of tax policies there?
Yeah, thank you, Mayur. So you've raised a very pertinent question, and I'm really delighted to share my thoughts on it. See, largely we all know that environmental sustainability and economic growth, it's like walking a tightrope. And howsoever difficult it is, in the present climatic condition that we are in, it is equally important, and we all understand that, right? And in that, tax can definitely play a very significant role. Now, why significant role? Because largely for a country like India, consumer behavior pattern are not related, relatively they are not focused on the greener technology, right? And at the same time, even for the industry, they are unaware of the benefits which they can reap by adopting greener technologies, in future, or even today also, largely they are unaware. Right. So in a country like us, it is very important for the government to play that role and to use tax as a tool to ensure that such behavioral patterns can be changed. Right. For instance, a very simple example could be electric vehicles. Right. By reducing tax on the electric vehicles, what happens? As a consumer, I will be excited to, buy that product because now it is, on a pricing and it is perhaps on a similar range or maybe at a lesser range. And therefore, it is, building a culture in me to perhaps give preference to that product, right? And which, of course, will then boost production of electric vehicles, right? So that is how it is used as a catalyst, to build that behavioral patterns in the consumer and in the, for the industry as a whole. Now, largely today, there are three main measures which are adopted by the government to use this tool to ensure the environmental sustainability. Number one, to give benefits to products by way of reducing or slashing the tax rates, right? For instance, there are, exemptions which are being offered to solar panels or to, renewable batteries and so on and so forth. So that is one measure which is adopted, or maybe on the services end also, lesser tax is payable on the waste management services and so on and so forth. So in the entire, business cycle or the supply chain cycle, whatever is related to renewables, whatever is related to waste management, whatever is related to transportation where there can be less use of fossil fuel, that is something where government is endeavoring today to reduce the tax cost. So that is one measure which is typically adopted.
So there's a conscious effort which is being already.
Absolutely. The other effort which is equally important is to offer incentives, direct incentives. Now, the first measure which we saw is to reduce the tax cost. The other is to offer incentive directly to the industry. So which means that, one typical example could be PLI scheme, right? Under which scheme, if you make investment in, say, solar sector, then you will be awarded certain benefits from tax perspective. Other benefits are also available, but tax also plays a very important role in it. Right. So that is the other measure through which government is trying to push for environmental sustainability. And third and the last measure which is typically adopted is to ensure that higher tax burden is posed on something which is not green, right? So which is not fostering any greener technology. Like while in India we do not have a concept of carbon tax yet, globally you will see many countries imposing carbon tax, which means that there's a tax which is levied clearly on the basis of CO2 emissions, right? Which is not presently in India. It will come in future. It is not in existent at present, but it is, in the course of discussion when it comes to the government bodies and all. Yet what I was saying is that there is no carbon tax. However, to ensure that fossil fuels such as petroleum, etc., are not consumed the way they used to be consumed, in the past. So petroleum rates, tax rates, if you see, are on a very high end today, right? And, for coal, we have coal compensation cess, right? So all of these levies are in a way, indirect ways of imposing that carbon tax, right? So these are the three measures which are typically adopted today to ensure that we are moving towards an environmentally sustainable era. The question remains is, are they sufficient enough? In a country like us, we are perhaps, at number 3 when it comes to CO2 emissions worldwide. So whether it is sufficient for us or not is one will have to think. And at the same time, one will also have to think that whether, if we are adopting that path of being environmentally sustainable, whether we will hamper our economic growth. For instance, today EU has come up with the concept of a carbon mechanism where, what will happen is that today, for their local domestic manufacturing, of course, there are taxes which are being imposed on the basis of CO2 emissions. Now, when you import something to an export something to an EU country, there will be an equal levy on an exporter as well, on the basis of their CO2 emissions. So for instance, from India, if we are exporting something to an EU country, then we will have to buy a particular certificate in order to ensure that we are also contributing equally to environmental sustainability. Now, the question which comes here is, will that make our exports less competitive? Of course, it will make. Then how do we balance between economic growth and to ensure that exports are not getting hampered? At the same time, for a country like us, we do not even have a proper mechanism to do this computation of how much CO2 emissions, etc., are being done by a particular industry. So we are lagging a way behind when it comes to, accurately seeing as to how much is the emission and how much, pollutant is being, sent into the air, right? So that is so. What I'm trying to say is that it is very important to see whether what we are doing presently is sufficient or not. At the same time, there are several other factors also. So on the one hand, say government is proposing to offer benefits to renewables. But on the other hand, tax, there are several issues. There are classification issues. There are, multiple legal issues which are going on, right? For instance, in the solar sector itself, what is a solar generating system and what is a solar generator itself becomes a big issue. So on the one hand, you're giving the benefit, while on the other hand, you're taking. So government has to go all hearts in it, when it comes to tax matters. To give you another example, there's a payment which is being made by the companies to a particular authority called CAMPA. That payment is made for the purposes of afforestation. Now, and that is to be made, because if you have done deforestation, then it is your responsibility to ensure that you are contributing in afforestation, which of course industry is doing. But there is a huge litigation going on presently. There are investigations going on by the DGGSTI authorities that whether this amount which is going for afforestation is actually liable to GST or not. So there are various such complications when it comes to tax. So government must ponder upon those complications also to resolve those complications. There are complications of rate resolutions. For instance, if you wish to promote domestic industry to manufacture renewable products, at the same time, if we are, in order to promote domestic industry, if we are imposing higher duties on imported products, which is good, but then it has it may have severe consequences in that if we do not have enough domestic capability, then how do we ensure that environmental sustainability in terms of, promoting renewables and so on and so forth. So these are few thoughts which are important to know. In nutshell, tax has always been used not only in India, but otherwise also globally as one of the very, very important tools to ensure that, as a society, we all are moving towards, environmentally sustainable, thought process.
Thanks for that. I never thought about sustainability from a tax perspective, which are happening. I was reading recently that India plans to be an exporter of green hydrogen in times to come, not only just a manufacturer, but a huge exporter. And the latest thing that I read is that solar panels are going to be installed on water, so that it takes up less space. So a lot of innovations are coming, but this will not help unless the tax benefits are there. It's a long time since I've stopped wearing a tax hat, so I don't keep thinking about these things. But thanks for these things. We are just spinning up a bit because I think we are like thanks, sorry, but my question is, how do you balance between innovation, use of AI, and challenges and risks around it? Say ethics on bikes.
Thanks, Mayur. I'm going to confine my thoughts to use of AI in law for lawyers only. Today, I can share that I use AI for a number of things. Myself and also, the lawyers of our firm use AI in various situations. For example, we use AI for legal research. I can ask the technology to point me to the absolutely relevant precedents. Not only does it tell me what relevant precedents are there, it also tells me and rather warns me not to use some precedents which are not being treated in a positive way by the courts. Similarly, if I have a very complicated judgment or a complicated agreement, I can ask the technology to summarize it for me. Or I could just ask pointed questions, what are the obligations of both parties in this, according to this agreement. Similarly, I could also ask the technology to extract information for me. I can point it again to, I need to know what is in this agreement under assignment, under liability, under indemnity, etc. There are so many ways that, technology, AI-enabled technology is being used by me and the lawyers in our firm. Similarly, I could, again, for instance, ask the technology to generate a draft of an agreement after learning from the various agreements that I have drafted. So my own knowledge, and then the technology is capable of generating a new draft by learning from my previous drafts. I can also ask questions. Like I said, I gave an example of, what are the obligations of both the parties here. Now, is it as easy as, plug and play, go to the market, explore, find out what is available, and then just bring it on? No, there are. It's a whole exercise. It's very logically, very scientifically done to figure out what is the best. What are the use cases? What are the right technologies? What are the risks involved? And when I talk about using all of this, I really think that it'll be a shame if our lawyers, by getting scared or by worrying about the challenges associated with AI, stop or just, refrain from using AI. It's great. I can say that from my own personal experience, first-hand experience, that it's great. It's a great technology. It's great enabler, makes me more productive, makes me more efficient. But like the other panelists said, that the accountability continues to be mine. So like you use your phone and even when you type a message on the, your phone is suggesting various words in a sentence, it's kind of reading your mind. You say how, and it says, are you? But you decide, right? You might be just saying, how are you doing? It just says, how are you? So you decide, right, whether you accept that prompt or not. That's exactly what you have to do when you are using AI-enabled technologies in your day-to-day work. So like I said, it will be a shame if lawyers refrain themselves from using technology, saying that there are too many risks involved. They're very good at, pointing out problems. What about the solutions? So like the challenges, we've got challenges around privacy. I mean, it's not a secret. Everybody knows about privacy, where private information, confidential information, privileged information may just go out on the internet. Similarly, there are ethics issues where the technology is capable of hallucination, is capable of making cases or making up information, which it will tell you with so much confidence that to you it appears to be truth. But again, the accountability lies on the user, so therefore you have to know whether that's correct or not. And I'll give you an example of when we were writing law papers, our law exams. We had to write really lengthy answers for each question. And it was a technique taught to us by our seniors and then maybe passed on from us to our juniors. That just, you could also make up a few cases, in your answers. You could just say Komal Gupta versus Union of India and get away thinking that, the invigilator, the person who's marking you will not notice. And it's the length of the answers that will matter. That's pretty much what ChatGPT is also doing when it makes up cases. But we can't get away with that as a lawyer because every filing is happening in our name. I can't go to the court saying that I use ChatGPT or whatever else, and so please excuse me. I can't do that. So the accountability lies on me. Similarly, about biases, Lakshmi gave an example. I'm going to again restrict myself to law, where lots of judges have tried worldwide using AI to decide bail matters, including our own Punjab and Haryana High Court, wanting to know the worldwide view from ChatGPT on bail. Now, what happens here is again that not ChatGPT, any technology, any AI technology has been trained on previous judgments, right? So when it says, okay, should Komal be granted bail? If the answer is yes or no, not necessary that the technology has given a wrong answer, because it's only going to, give you the answer based on the training it has been given. But what if the previous judgments were biased? What if it was against a particular race community? The same example that Lakshmi gave. And in that case, you can't really prevent the bias because that is what is historical data. And you can't create new data, right? So the past data that you are training the technology on is going to be biased, and therefore the technology is biased, not the technology's fault. So like I said, we can't just keep on listing the problems. We have to find a solution to those problems. So at least I can say that when I'm looking at technologies, I am looking at various risks. I'm looking at where the servers are, where the data is going to be located, where, is my data getting deleted? Is my data going to be used for other people's advantage, or other clients will also get the learning of my data or not? I will involve the InfoSec team to make sure that, whatever I can't see, they can, because they come with a different lens to, deep dive into the technology vendors, infrastructure, etc. And finally, I would say that, as lawyers, like I said, we must use technology. We should not, stay away from using technology, but we should use it responsibly. And for technology to do wonders, to not become, the risks involved should not become an obstacle in the way of innovation. I think it's important for all the stakeholders to come together, lawyers, policymakers, the judiciary, including the technology vendors as well. everybody needs to come together for the responsible use and responsible regulation of AI.
So much Kuku, for that. And I met him quite recently. I mean, and I was very intrigued by the title Chief Innovation Officer in an organization like mine. A Chief Innovation Officer would be an R&D head. So I was just wondering, and I spoke to you, and very informative the kind of role that you play. So nice meeting you and what you do. Moving to our last panelist for the day, for the session. One, thank you for being here. I know you have been traveling. I know you are probably sleeping, but okay, so thank you for being here. And my question to you is, how do you see the existing sustainability laws relevant for the Indian market today? How they are?
Well, I'm very well aware that I'm the last panelist and we've already overshot on time. I'll try to make myself as crisp as possible. And I think firstly, when it comes to sustainability, there are a couple of things that I would like to speak about, especially the organization that I represent. That, you know, from a GE Aerospace perspective, we talk about new technologies coming into sustainability, be it looking at reducing the carbon footprint. And worldwide, we are committed to having zero emission rate by 2050, which, like, you know, what Lakshmi mentioned, is a very ambitious stance. But then the fact is that once you take a pledge as an organization, you make a commitment, you go back and make a blueprint that you commit across multiple continents across the world, working with different jurisdictions, different regulators, as to how you're going to implement it. And India being a very big market for aerospace across the world, we are touted to be the third largest users of aerospace going forward. So with the growth that we see in this space, with the companies actively pursuing sustainable aviation fuel. We're already in our first test on that. And I think one of the first flights have already been launched very successfully in collaboration with one of the airlines. Now, coming to sustainability and the rule of law, I would like to say the role of lawyers is extremely important over here. I think firstly, we are the natural crusaders of law. We are the ones who uphold constitutional rights, not only for individuals, but for areas of law and areas which affect our society, which no one else champions. So naturally, we are the ones who are leading it by example. It is a lot of responsibility on all of us as lawyers to do that. We are what I would call myself a public enforcement officer. Even within organizations, we are looked upon as the voice of law to guide our managements, guide our leadership, guide societies, organizations to do the right thing. And also to, very importantly, to guide our judiciary to take the important things. You know, we have such an esteemed panel of not only internal in-house lawyers, but also external lawyers who represent us, clients like us, and many more who uphold the rule of law. You know, rule of law is what is the basic difference between civilizations. From the time we started and our evolution as humanity, if we look, we have championed causes which nobody really thought about. And sustainability is one of them. Sustainability, especially when it comes to India, we have always been a civilization and a country which has looked at very sustainable ways of living. It is with the, you know, change in society, change in evolution, westernization, that we sort of adopted so many things that we originally never needed to. And now when you look at that simple concept, we are taking a U-turn in a lot of ways. Like, I think I remember very vividly as a child, having a cloth bag and going to the vegetable market with my mom. And today we pay 20 rupees to buy that same cloth bag. Now, are we making a U-turn? Yes, we are. We're going back to where we started. And I think that is what is required when you look at sustainability. The approach of law has also to address the changes that have taken place, be it in use of carbon footprints, be it in use of plastics, be it in use of different regulation that we have. Now, the point is that when we are looking at ourselves in various industries, we are also looking at societies, at jurisdictions which have come up with very strong laws to enforce sustainability. And we do admit to the fact that India is in a lot of ways lagging behind that. And we are lagging behind, not that we choose to do it, because we've never been to an extent of use of, I would say, technology the way West has been. Electric vehicles have come into India in the last 7 to 8, 10 years. They've been using it for the last 15, 20 years. So they know what technology has led them to and what are the issues they need to resolve. Now, that is an advantage and a disadvantage for India at this point of time, because we know what is the laws we need to correct what the West is facing. And there is where we're in a unique position to fill the gap. We know the laws, we have gone ahead and we've got our regulators in over enthusiasm at times pass the laws, but we do not have the infrastructure. We do not have the people in the system who understand the laws and who are willing to walk that path to guide. And simple example, corporate governance. We've all got the public listed top 100 making the disclosures. We've all got the committees in place, but how many of our managements, our leadership really understand the disclosures? Is it just a tick in the box? Or do we have the right departments to address it? Like, I don't think maybe 5 to 8 years back, we had a sustainability department in any organization. Today, we've got sustainability officers. And somehow, by default, the general counsel was always a sustainability officer. It was a role given to us because I go back to what I said, we are looked as the natural crusaders, the champions of law in areas where none exist. So I think there's a lot of responsibility on people in this room, people on this dais to carry on with that voice, help organizations become aware. And I would not like to further elaborate to what my esteemed panelists have already mentioned in various fields, including yourself, Mayur, that what all we are doing to help educate the leadership, business community, as well as the regulators, and making sure that we continue contributing in the right fashion, in the right manner on sustainability laws in India. I like to stop at that.
Thank you so much. In relation to the subject that we were discussing, we have overshot the time a bit, but thank you so much for your participation and your thoughts. Really appreciate. Thank you. Can we have a big round of applause for the panel here? Thank you.
Thank you so much. And I also request Ashima Ori, the managing editor of BW Legal World, and Smith Over, the VP at BW Business World, please join us in our picture as well. And thank you, Mayurji, for moderating that. Thank you. Thank you so much. Thank you. Fish, can you call the panelists? Can you use this one? Oh, okay, from balancing innovations and regulations, let's move ahead with our next discussion on white collar crime investigation and enforcement landscape of India. And to share the view on the same, please join me in welcoming on stage Samudra Sarangi Patna, law offices of Magan Babu. Joining him is Bharat Chod, founder, Chambers of Bharat Chod, also former judge. Joining them is Parvez Menon, senior partner, MZM Legal. Joining them is Parsival Bilihar, senior advocate. And this session will be chaired by Mumtaz Balla Patna, PL. Please welcome everybody to the stage. After Zordar Talia ke saath. Is anyone warmer than these? Thank you so much.
Thank you. Good afternoon, everyone. I'm extremely thrilled to be a part of this wonderful panel with these esteemed speakers. And today we are going to be speaking about white collar crime investigation and landscape in India. We've seen a paradigm shift in the seriousness attached to white collar crimes in India in the last decade and a half. And it's become a more serious and a more aware issue for investigative agencies today. So before we get to specific questions, I would like to have everyone's opening thoughts on the paradigm shift of white collar crimes in the last one and a half decades in India. I'll start with Percy, sir.
Hi, so good to be here after a while. So I remember the resurgence of white collar crime. So America always had this law which made corruption and graft illegal, even if it was a crime committed in countries outside the US. So it had extraterritorial jurisdiction to that extent. Nobody really took that law very seriously until 9/11. And then the Bush administration found that a lot of terror financing, the source of terror financing was corruption and graft. They discovered how the terrorists were funded through Hawala, of all things, which we, of course, are very familiar with. And that began a new paradigm. So I remember sometime in 2003, I walked into the office of a New York law firm and they said, we would like you to meet our white collar crime partners, and 7 or 8 people marched in, and I was wondering what the heck are these guys doing? And then it turned out that this had indeed become a very big issue in the US. In India, we followed suit. I think the first very big white collar crime matter after Bofors, that is, was the Commonwealth Games. And believe you me, there are Commonwealth Games matters that are still going on. I just finished one last year. So, and it keeps going on. And then we have ED, which is a new law and which has been amended. And recently the Supreme Court in Vijay Madan Lal's case has said that there are adequate safeguards in this law. So it has refused to strike down the law. This is the bird's eye view of where we are right now.
Your opening thoughts, Parvez?
So to take a cue from where Percy started, we have to go back to the history as to how this term white collar crime was coined. It came through Sutherland when he first discussed white collar crime in criminal law to mean that any crime or offense committed by a person who holds a position in office, who is involved in white collar crime of a job, when he resorts to this kind of criminal activity, it is termed as white collar crime. The paradigm shift that we have been seeing through decades, in the past few decades, more so with force of ED and CBI coming into picture, and various scams that you pick up a newspaper of, you can see a scam being discussed in the corridors of the Supreme Court. That's where we see today white collar crime, that you are going through scams and scams and scam. To name a few, it started with the Satyam scam in India, if I'm not wrong, Percy. The first scam that I studied as a student when I was in law college was the Satyam scam, which had ramifications on Indian economy because it has shaken the stock exchange. Though it, on the face of it, it was an accounting scam. So these kind of offenses, which have a ramification effect on the society, are termed majorly as white collar crimes. The investigating agencies now enforcement agencies other than the local police stations are the CBI and the ED, which are majorly in picture. And off late that we are discussing here in Delhi is the liquor scam, where we all know that the Honorable Chief Minister was arrested and now he is let on interim bail. So I'll move that question now to, if I may pass it on.
Yes, thank you, Mumtaz. Broadly, on just to share a few thoughts on white collar crime. I mean, we all understand that that's very, very important to punish them, treat them differently. You know, a white collar crime, just because we call it white collar doesn't add some respectability that otherwise shouldn't be there. But it definitely needs a different approach. It's something that, Justice Krishna Iyer famously called the subtle murders on the economy, and, crimes that affect basically far more people than possibly traditional and conventional crime. But my problem is that have we gone too far in our enthusiasm of punishing white collar crime, or to be seen as punishing white collar crime? Have we gone too far? And I think in the course of discussion we'll be talking about it, how there are certain offenses which have been added now which have over criminalized or criminalized certain parts of doing business, how certain parts of white collar crime today, primarily the way some of the agencies have functioned, how the PMLA has panned out, how the Prevention of Corruption Act has panned out, raises some very, very disconcerting questions to me as a human rights lawyer, and I believe every criminal lawyer is a human rights lawyer first and foremost, and as a student of the Constitution. So definitely there have been some, if I take a bird's eye view over the past few decades, some very important developments where we've recognized certain areas of white collar crime as specific offenses like the PMLA. But maybe the pendulum has swung way too much in the opposite direction, where even, and we'll discuss it in the course of the discussion, that even innocent acts sometimes are seen as criminal, sometimes acts of public servants and businesses in getting certain contracts we've seen were seen to be criminal, when ultimately on a trial nothing really came out. Grant of a tender, for instance, and this is a classic illustration on a grant of a tender where there was no competitive process. Even if there is no evidence of an illegal gratification or a bribery, was perceived as criminal back in the day, troubled a lot of people and certain economies and companies, but finally came out to nothing after a trial. So I think the focus today is on, and we have a number of these laws, the focus today is how do we introduce back the basic guarantees under the Constitution which are open to an accused or to the defense in terms of presumption of innocence, in terms of the right to bail, in terms of other protections against custodial torture and interrogation. Are we today in a position to ensure that they remain firmly in place and are not really ignored in our enthusiasm to treat white collar crime in a certain way?
From my perspective, I think we've been talking about white collar crime growing for the last 20 years. I feel corruption and white collar crime have been ingrained into India's history, political history, for a very, very long time. So it's not uncommon that bribery, corruption, these words have been thrown around for a very, very long time. What I believe there has been a paradigm shift in are a couple of things. I think one, the sophistication of the investigative agencies to deal with financial crimes has increased, and thus there's some amount of prominence regarding the prosecution themselves. The second piece around it, the people being prosecuted also have a certain amount of profile associated with them. I don't think by white collar crime, we only talk about money laundering cases, which necessarily currently and more relevantly so is the focus of most of our conversations. Historically, customs cases were also white collar crime cases. Corruption cases have always been white collar crime cases. When people got cheated of their money by a contractor, by a contracting party, we had provisions in law already in place to deal with them. So what I believe there has been a systemic change in is lawyering around it. I don't think traditional criminal law, what we grew up learning as criminal law, is something that currently works, and we've had to redefine how we approach the law and how the regulators and the enforcing agencies approach the law with a lot more vigor, a lot more energy than they historically had while pursuing these type of cases. So I think on both sides it's a match. There's an obvious level up when it comes to the enforcement agency side, and I think there's something that we need to catch up as lawyers as well, that we need to push the boundaries and try to take it slightly beyond what the enforcement agencies bring to the table right now.
Thank you, everyone. Those were some interesting observations. PMLA is a 2002 Act, and we are seeing its use more than ever in the last 1 decade, if not 1 decade, definitely the last half of the last decade. Why is this being invoked more than often? Percy, what are your views? Why do you think PMLA being a 2002 Act, and like Samudra said, all these white collar crimes were always there? Why is PMLA now synonymous with a white collar crime, and why is almost every investigation leading to a repercussion under PMLA and arrest under PMLA? Because like you said, Vijay Madan Lal has actually made everything very, very stringent and strict for the accused. But with the Supreme Court carving out an exception for Arvind Kejriwal by granting interim bail for contesting elections on the ground that he's not a habitual offender, does this actually become a flexible position where the courts are now going to go beyond the 3 conditions given under the Act and consider other factors while granting bail? What are your views on that?
So, slightly extensive answer, so please bear with me, but I'll be very brief and to the point. So, everyone says about, talks about these 3 conditions. To my mind, it is a bunch of tripe and piffle. Okay, make no mistake about it. See, bail comes after arrest. Prior to arrest, the PMLA authorities, that is the ED, has to publish, or at least give to the accused the grounds of arrest. Now, unfortunately, as a matter of practice, they were not giving the grounds of arrest. And I think the accused were not even demanding this. There are a few instances where people said, how can you arrest me without giving me the ground of arrest? So then they started saying, well, okay, here's the ground of arrest. There's a little small para that doesn't say anything. Please remember that your 3 conditions of bail have to be in the context of the grounds of arrest. So you need a proper extensive grounds of arrest so that you can prove. Now, in terms of the onus, the grounds of arrest have to show that the arresting officer has reason to believe guilt. As opposed to that in 45, where the bail conditions are set out, it is the bar is still lower. It is reasonable grounds to believe that I am innocent. So if you have a proper grounds of arrest, and now recently we've had a judgment of the Supreme Court that says that grounds of arrest is compulsory. The difficulty is that they arrest the person and then they hand over the grounds of arrest, where the chap doesn't know what the hell is going on, and he signs it. Right. So I think our practices, see, the biggest difficulty in criminal law is that our practices are little antiquated and not too refined. If the prosecution follows proper practices, and this is the single biggest problem, the difficulty is not really with the law. And I think that is what Vijay Madan Lal said. There are adequate safeguards over there. And as far as arrest is concerned, everyone who's arguing a bail, if the argument comes from the ED or if the judge poses an argument which is on fact, you simply have to say that is on fact. That will be proved in the trial. I am not supposed to answer that. I am supposed to answer you only on the grounds of arrest. That's it.
Thank you. Bharat, since Percy sir has said there are adequate safeguards under the law itself, as a former judge, what is your view on the same? Because how do you see a statement made to a police different from a statement made to ED during the course of investigation? Because their admissibility is completely different. While a statement made to the police is not admissible, but a statement made to ED is a during the course of investigation is treated like a judicial proceeding and it's admissible in law. So do you really think there are enough safeguards under the Act? And what are your views as a person who sat on both the sides? Let us have your views on that.
So I think on the question of adequate safeguards, I have a few concerns there. One that you rightly mentioned is that any statement given to the enforcement directorate is admissible in evidence. Now, of course, there are judgments that say that that cannot be the sole basis of a conviction under the law, and you'll need other evidences to corroborate that statement, right? But even the fact that it is admissible in the first place is very, very problematic. And I think the Supreme Court, in the case of Vijay Madan Lal Chaudhary, decided that they are not quote unquote police officers. And that's the test still under the law with 25 of the Evidence Act, where only a confession made to a police officer is inadmissible in evidence. And if the authority is not a quote unquote police officer, it is still admissible in evidence. The reasoning in the judgment, and it's important to appreciate that critically, is that just because ED does not file what in law is known as a charge sheet, ED is not a police officer. So the test or the acid test remains that whether you are filing a charge sheet or not, does the case begin with an FIR and end in a charge sheet or not? So that technical issue. And ED, since it runs the case like a complaint, and ultimately it culminates into filing of a complaint before the court, which is obviously a deemed charge sheet in that sense, but it is still a complaint. So that distinction was kept in mind. But according to me and in my humble opinion, this is a distinction without a difference really. Because ultimately, whether it is a complaint or it is a charge sheet, whether there is an FIR or a complaint, the fact of the matter is a police officer is what the police officer does. The test is a substantive one. If you have the power to arrest, if you have the power to do a search, if you have the power to do a seizure, if you have a power to take a police interrogation or a custodial interrogation, then you have everything that a police officer does and then some more, right?
File a charge sheet in 60 days, you get
You get default bail. So everything that the agency does is what a police officer does, and the safeguards are relatively less. So I think that needs to be examined. And if you look at Tufan Singh's judgment, when they drew that distinction in the case of the NCB investigating NDPS offences, Justice Nariman in that very beautifully written judgment said that NCB is a police officer. So therefore, every statement made to a NCB officer has to be thrown out and eschewed from consideration totally. So this is something that needs to be maybe re-examined on some day. And talking about safeguards, the fact that and defense counsels on the panel would agree, and of the panel would agree with me, that if you're defending a PMLA case and you don't have a copy of the ECIR, which is the starting point of an ED investigation, that's also a big problem in itself. So you're arguing a bail and you don't have a substance of what the allegation against you is. Now, of course, they'll start providing the grounds of arrest, but how detailed are those grounds? What is the application of mind? I mean, a reason to believe may be different for different people, right? I may find a reason to believe in pure conjecture and surmise, but it may not really be reason to believe on basis of substantive evidence. So that's problematic. I mean, you don't have a copy of what the case is against you when you're arguing bail. It's like being asked to swim with your hands behind your back. A defense counsel's position is very difficult today, especially with your reverse onus's, the higher threshold for bail. And to add to it, I mean, you don't have in the public domain today the ED manual, which says how the ED is supposed to function in that sense. CBI manual has been out in the public domain, and it's been argued. Courts have tested the CBI's actions in how they've conducted investigations on the anvil of the CBI manual. You've done a search and seizure, you've not maintained the chain of custody, we'll check you on that, we'll check you on this. And the courts have gone on to say that if you've not abided by the CBI manual, which provides a number of safeguards over and above CRPC, then we'll check you, and it may also lead to disciplinary proceedings. But the ED manual, on the other hand, is not supposed to be in the public domain and is not going to be in the public domain. So I don't think there are enough and many safeguards, with great respect, as far as PMLA cases are concerned. And maybe, and I think some of these are pending still before the larger bench, where even the Vijay Madan Lal conclusions are going to be retested. Let's hope that we'll have an act or an interpretation that would be more constitutionally compatible.
Just curious about thoughts on something from anyone on the panel. Do you think it matters that most statements that are now given to the CBI, ED, police, I mean, police less so, in CBI and ED offices happen under videography? So do you feel that because now we have a lot more access to witnesses being videographed while the statements are being given, possibly it's okay that these statements are admissible? It's something that I wanted to test some opinions on.
So I'll give my views first. I don't think it's an adequate safeguard, because if I am investigating somebody here and I'm telling him that this is your arrest memo, say this or I'm going to arrest you, I'm putting a camera in front of you, it doesn't make a difference at all. That's my view. I've done enough and more ED investigations, and I've had enough and more clients coming in telling us the kind of threat and pressure they are in. So I don't think just putting a video camera is going to solve anything. It's like telling a police official that, okay, video record everything that you're getting recorded from a person who's an accused. It just means the same. The only difference is maybe the ED will not use third degree, and the police may actually use third degree, but the threat of arrest will remain the same. And if you put a camera in front of them, it's not going to make a difference, because what you threaten them before you put the camera is what matters. That's my view. Percy, sir, any views on this?
I agree entirely, and I think Section 50, which Bharat referred to, is a problem, because any statement made to the ED officer is equivalent to a sworn statement before a magistrate, which is the normal norm in criminal jurisprudence. And I don't think videography really matters, because I mean, the person is already under a great deal of duress, and will make a deal with you. All that can happen. So I don't think that's really helpful at all.
Parvez, what is money laundering? Is it an offense on its own? Do you need a predicate offense? What is the threshold? Do you start making arrests under PMLA on the alleged suspicion of money laundering when the predicate offense is not even proved, when the charge sheet under the predicate offense is not filed? What do you understand from money laundering? It seems like ED is everywhere and white collar crime is all about ED now. What are your views on this?
Mumtaz, firstly, let me clarify. Money laundering is not just Hawala transactions. Money laundering is a very complex subject. And ED, your question was a complex one. So ED cannot directly take cognizance of any offense until there is a scheduled or a predicate offense in place. That is number one. So scheduled offense is a must for ED to get into picture. The ECIR is registered only on the basis of a predicate offense, either by the local police station or through the CBI investigation that is going on. When in such investigation, money is the question which is to be investigated and the source of the crime is to be recovered, then the ED comes into picture under the PMLA Act. The act of money laundering, according to ED, is threefold. One is getting the money, placement, layering, and integration. Now, how this is done, I will explain through an example. So to give an example, say there is a person who's a white collar person with a job, say a principal of a college, say his name is Joe. He is principal in the day and he deals in drugs in the night. So he supplies drugs to the students and other vocation of the college. And through that, he collects the cash amount. Now that cash amount is the proceeds of crime. That proceeds of crime he deposits in banks through various channels and accounts in India. Then he layers that money through a complex web of sending it abroad to some shell companies that he may have some connections with. So he buys shares of those shells companies abroad. Then he forms companies in India where those shells company invest back into India, getting the money back. So now that money has come back to India through FDI, which is not drug money. So this is how money laundering takes place. So it is first placement of proceeds of crime into the system, then creating a complex web of sending it abroad, then getting it back into the system is majorly money laundering. So every money laundering is not just Hawala transaction that you send cash abroad or get cash from abroad. It is a complex web that is created by this so-called conglomerates in these days, which are in heavily into these scams and all, that money laundering comes into picture. ED comes into picture to investigate when there is a predicate offense. When they have to investigate the source of monies involved in that offenses, is all of this is investigated and gone into by the enforcement directorate, is my answer.
Thank you. Samudra, what is your take on corporate white collar crime? Is direct ocular evidence a material factor in corporate white collar crime?
I feel direct material evidence, right?
Yeah.
It would be a material fact. Statements.
Statement.
Yeah. Direct material evidence would be a factor in all kinds of crime. And more so particularly, I feel they take a special position in white collar crime, especially during the initial stages of an investigation. I think what we see from my experience, what I feel is the ED does investigate complex cases. It's document heavy cases, not necessarily the simplest things to investigate, unearth and reach and file a charge sheet in a way that it's understandable. What is a good starting point for an investigation is a statement. And probably the reason this question becomes relevant is surely the volume of approver statements we get to see these days, where somebody walks into the ED's office and gives their part of the story, which does incriminate a certain set of people. Now, given that the effect of this statement is that under the PMLA, you're naturally going to have a enlarged difficulty trying to get bail. Because the law as it currently stands, and I personally don't blame Vijay Madan Lal for it, I blame the parliament, which forced the Supreme Court to give that constitutionality decision. But given that is the law as it currently stands, a statement cannot be proved or disproved, like Mr. Billamoria was saying, at a pre-trial stage. So it becomes material to understand that, yes, you're in the right way to investigate from an enforcement agency standpoint. It's wonderful to have direction to your investigation and you can approach your investigation in a much more systematic manner. But from the legal standard of bail and what a statement places an accused in a predicament of, I think it's incredibly tough on a person to disprove a statement or prove it's false. But that said, I think it's entirely possible. I don't agree with the paradigm that bail is an impossibility in PMLA cases. It's tougher, sure, but that's exactly why. I mean, this was supposed to be for terror financing cases, right? Surely we've now evolved to reach a stage where it has acquired some amount of political notoriety. But for terror financing cases, you'd expect the standard of proof to be difficult, bail to be a lot more challenging and difficult. So I don't blame the law. I do understand it's going to be challenging to get bail. But from a purely evidentiary standpoint, this is a question that goes to the heart of an investigation. It helps the investigative agency. So yes, statement collection, I do agree. When you and I are as other than lawyers, as citizens, we are interested in seeing a prosecution agency reach the truth. And I think statement is a big part of it.
Thank you. Bharat, how important is mens rea in a white collar crime? And with Samudra saying that, yes, bail is tougher and the law is made that way, it's not an impossibility. Do you think putting bail at a higher threshold for a white collar crime, which is called the crime of the elite, fair as compared to offenses of moral turpitude, where there are actual offenses against people, you call them offenses against human body, for example, an offense of murder. Is it, in your estimate, because like I said, you've sat on that side as well, is it fair to put a higher threshold of bail in a white collar crime, like you said, which has ramifications on more number of people, as compared to an offense of moral turpitude? And how do you see the relevance of mens rea and motive in such cases?
Right. So the first part of the question first on mens rea. Now that's again something that is very, very disconcerting in a lot of ways. I understand over the years we've argued and advocated for strict liability offenses for some of these offenses. You know, it started with, for instance, kidnapping under the IPC is a strict liability offense. We started off with food adulteration related offenses, and then we've kept on adding to the list cases where you don't need to prove dishonesty or an ill intent when you are trying to prove the crime. Now, I understand in some cases it may be difficult for the prosecution agency to prove mens rea or a guilty intent, but at the same time, I don't think that justifies taking away that very, very important requirement. Now, if you look at PMLA now, with the definition of money laundering, there were certain parts, and the law has been amended a number of times, not getting into the minutiae of the language and how it has evolved. But ultimately, today, I think very few people would disagree with me that on a reading of the definition of money laundering, even innocent people can be brought into the ambit of the section. Within the Vijay Madan Lal Chaudhary judgment also, there are indications and counter indications, but broadly, the way the section has been interpreted, if you've had anything to do with proceeds of crime, and this may be an act of possessing, it may be an act of facilitating transfer. And even if you've not projected that proceeds of crime or that tainted wealth to be untainted wealth, which was the very idea of money laundering, if you look at how the offenses began and what were the first statutes on the issue, the very physical act of taking the money, as the name suggests, taking a tainted money and then laundering it and turning it into clean, white, authentic, legit money and portraying it as such to the formal economy and using it was the essence of the offense of money laundering, right? But now with the definition as it's structured currently, even if you've just possessed it, or if you've been an unwitting party in the entire assembly chain or the movement of proceeds of crime, for example, let me take this very extreme example of a chartered accountant or a lawyer accepting fees in a given case, and that fees may be disproportionate to his normal fees in a given situation, and you possess that proceeds of crime, even if you did not project it as untainted wealth and you knew it to be tainted and so on and so forth, the property may come into the ambit of proceeds of crime according to one construction at least, right? Because if you recall, the section 3 had a word and or, and has been read as an or and disjunctively. So ultimately, to cut the long story short, today even arguably a bona fide innocent third party may also be brought into the ambit of PMLA. You may not be able to secure a conviction for the purpose of prosecution. You may proceed. Now, this is very, very problematic to me as a student of the Constitution. I don't think there is a justification to go that far with mens rea has completely taken a back seat. You will have to remember what are the consequences. You know, consequences of a civil attachment may be very different, but here we are talking about lives and personal liberty. So again, on mens rea, that's broadly my take. On the issue of bail now, I think there's no taking away the fact that I think we are all speaking in one voice here that white collar crimes have to be looked at differently. PMLA has to be looked at differently. This is very problematic for the economy. This is very problematic for a number of reasons. But you may have that offense and you may have a very, very serious or a severe sentence for it, but is making bail that difficult with that higher threshold where the judge has to return a finding at the time of bail that I have reasonable grounds of believing that the person has not committed the offense. It's like abnormally high threshold, right? Having that higher threshold and denying people bail as a rule and granting it as an exception is not really the answer. I think it's the certainty of final punishment that would act as a better deterrent for people who are committing such crimes and who may be committing such crimes in the future. I think the certainty of punishment, a good sentence, a fair investigation, a speedy trial are all better deterrents than denying somebody bail at the time of investigation or trial. Because at the end of the day, there is a presumption of innocence. There is, some merit in the argument that the person may well turn out to be, because, with the conviction rates. Now, ED obviously would argue that this is a better conviction rate than the others, but many of these trials have not seen their final stage as yet, and we'll see in the next few years on how these trials pan out. But at the end of the day, have a more severe sentence, but certainty of punishment and not the denial of bail is the answer if we have to send out a strong message. Sorry for that very, very meandering answer.
Thank you, Bharat. Taking it on from there and just blending it with what Percy sir said, that you need to fight the bail on the grounds of arrest. Percy sir, would you then say that it's a far-fetched dream to apply for anticipatory bail, because then do we assume and proceed on the premise that it's illogical to apply for an anticipatory bail with respect to a white collar crime? Because we also saw what happened with Arvind Kejriwal. He had filed an anticipatory bail and it was rejected. So if we blend these two views, what is your view? Should one actually even apply an anticipatory bail for a white collar crime, or just wait for the grounds of arrest to be informed and then apply for regular bail?
So there have been situations where anticipatory bail has been granted in PMLA cases as well. The general difficulty with anticipatory bail is that if you do not get bail, if you look at the provision itself, the language of the section presupposes that you believe that you will be arrested. So if you do not get bail, then the police will immediately arrest you, even though they may not be planning to arrest you. Many times it happens that, we get to know that the cops are saying, who told you to apply for this? Because we were not planning to arrest you. But now that you've been rejected, we will have to arrest you.
The same happened with Arvind Kejriwal also. This was rejected and he was arrested the same day.
Arvind Kejriwal's case is on a completely different footing. He did not apply for bail. He was questioning the legality of his arrest. And that's one of the main points that I made, that look, there is a jurisprudence of bail. Why don't you follow that instead of questioning the legality of the arrest itself? Especially when you have pushed back on 8 summons. When he didn't answer the 9th summons, he was arrested. But the issue really is that today, the law being what it is, can any businessman of whatever standing, or can any common man refuse summons and say, please send me a question and I'll reply? I think that was a very cynical move on his part. And perhaps that is the reason that he was arrested. The issue really is that now the Supreme Court has thought it fit that given the election, there was a decision of Justice G.S. Singhvi in the PUCL case, where he said that democracy is one of the fundamental pillars of the Constitution, and free and fair elections is very important. And in the opinion of the Supreme Court, they believe that for a free and fair election, a leader from another party should be allowed to campaign. So I don't think it's a verdict either way. There's nobody who says that he was wrongly arrested or that. The courts will decide eventually. But I do believe that that decision was correct because constitutional principles of what a democracy means have been upheld by the Supreme Court.
Thank you. So this is the law how it stands today.
Kejriwal, he has never applied for anticipatory bail. What he applied for in the High Court was he has challenged issuance of summons against him and he wanted that summons to be set aside.
But he did argue for anticipatory bail in the same petition.
No. That petition was dismissed and then he was arrested.
I can't comment on the case. I represent certain people, but he applied for anticipatory bail, got rejected,
Yeah,
got
that's what I
arrested,
understand.
and then went to written to challenge it on
Yes,
instead
that
of
is what I
applying for bail.
understood. Yeah, that's why, because the moment he was arrested, he withdrew his petition from the Supreme Court because it was in line with what with the other lady's petition, that now that you are arrested, your anticipatory bail petition doesn't survive. So coming to Supreme Court does not make sense. Please apply for a regular bail. And that's why this petition from the Supreme Court was withdrawn.
That is right. He did apply for bail.
Yeah,
That-
I'm
that
talking about
part
the anticipatory bail. Yeah, that he did. So now this is the current set of laws. Now, Parvez, what do you think is the impact of the upcoming law, which is the future now? Because all this has been happening till now, and from July we are in a different world altogether. How do you think the new set of criminal laws will impact white collar crimes? Can I have your comments on that?
That's really interesting, Mumtaz, because we are at the threshold now. We are in June, I think we are in May, and 2 months here from we'll have all three criminal laws in new form, which is BNS, BNSS, and BAS. So, in few words, of course, there is not major change on white collar crimes as a subject in those new acts. But what the legislature has done in its wisdom is that the economic offenses which are defined under the IPC, erstwhile IPC, and the new BNS can also be now termed as organized crime offenses. So if an economic offender has committed the same offense twice, say even if it is a breach of trust or cheating offense, which he is a repeat offender, then the police can arrest you under the Organized Crime Act under the BNS itself. So this is very stringent. That is a major change for white collar crime that I foresee. That at the inception, of course, there will be many of interpretational issues which will go to the constitutional courts to seek it to be struck down as ultra-virus. But yeah, that is a problem. Plus, there is one section that has come to my mind from the BNSS is about bail. So under new section 479, which defines bail, there is a provision that after you complete 1/3 of your sentence, earlier it was half of your sentence that you are entitled for bail. Now it has been struck down to 1/3 of your sentence, but it is further qualified that that will not be applicable in case where there is one or more case pending against you. So the question to be asked here is that in a white collar crime, say in a PMLA offense, the ED cannot register an FIR without there being a predicate offense. So obviously there is an FIR, which is a CBI FIR or a local police station FIR, and then there is a AD ECIR. So does that mean that the provision of that 1/3 period undergone and entitlement of bail would invariably not apply to people who are being tried under the PMLA Act? Because there is more than one charge sheet, there is a predicate offense. The PMLA is the second offense. So how do we solve all of these anomalies? Only the time will have to say. We'll have to see with it. But all said and done, the new set of laws, I don't see any major changes except of the fact that few of the redundant provisions of the IPC are done away with. I think there are 20 sections which have been repealed and 11 new are brought in. So only it is reshuffling of sections which we will have to look at. So even when we started practice, we used to carry the books along to refer to sections. Again, we will have to carry new books along to refer and compare to the old section with the new section. But of course, there's going to be a lot of confusion, not only on lawyers' side. I also foresee it at judges' side and at the enforcement agency side, because a lot of training will be required to see as to which law is to be applied. Plus, if I step into the shoe of an investigating officer, imagine a situation that the poor fellow has to also mug up the old laws, because not all cases have reached trial stages as of now. So this act will not have retrospective effect. So only those offenses which are committed post 1st of July would be tried under the new law, whereas those offenses which are pending trial, which are committed pre 1st July 2024, are to be tried under the erstwhile law, say IPC, CRPC, and evidence. So at such point of time, the officer who's running to the court will have to be abreast of both the set of laws, be it IPC, CRPC, and evidence, or be it BNS, BNSS, and BSA. So that is the difference that I see. Plus, the legislature has now brought in more tech-savvy investigation tactics into these new laws, where admissibility of evidence of electronically recorded evidence is admissible. The police officers are empowered to record the panchnamas or record statements on their mobiles or on video cameras, which would be admissible in law. So all of this, it will take some time to come to fore, because immediately trials are not going to begin. Though the offenses will be registered under the BNS from 1st July, the trials would begin only maybe after a year or two, and then we will have to see how they shape up in the courts of law.
Samudra, I remember you telling us about how cheating is also been always there, and it is a white collar crime, and we are just talking about PMLA all the time. Now with the Parvez giving his comments on a repeat cheating offense, how do you see this panning out for corporates and for individuals in commercial contracts and tender contracts, where I know that there would be implications of Prevention of Corruption Act as well, but how do you see the stringency regarding a repeat offense of cheating, disentitling a person from asking for bail?
From a corporate perspective, I think the source of the problem comes from an integrity pact that you enter into whenever you enter into any sort of government relations, government contracts, government tenders. In terms of cheating cases, if you have any sort of a disagreement with a counterparty on a commercial transaction, might result to a criminal case. But what I draw solace from, and before I even draw solace, let me immediately clarify and say that this is going to be complex. I am not sure how the jurisprudence around it develops, but surely if two employees of one company get arrested in 2001, get convicted, and another set of employees get convicted in 2024, now the company is potentially a repeat offender. I'm not sure if it's being tried in an individual capacity or it's only in the preceding 10 years. So again, employee sets would determine whether you'd fall into the multiple category or not. But what I'm drawing solace from is I do see lesser and lesser convictions in 420 cases, especially on the corporate criminal liability side. There might be individual cases of cheating getting convictions, but on the corporate criminal liability side, there's no shortage of cases being filed. It's from my experience, mostly a good recovery tactic to have. But in terms of them reaching conviction, I think jurisprudence has reached some amount of progress that we may not have to worry about an innocent company falling prey to isolated instances of a couple of convictions. If you see cases where there are multiple convictions, I think it points to a larger problem in the company. That's more on a practical side.
Just closing remarks from Bharat. What is your view on the impact of the new criminal laws on white collar crime, and are we creating a bigger demon in now making stringent conditions for bail, even for offenses like cheating? Are we a foot in the door or a foot back now? What do you have to say?
So some of this, but before I say that, I think I'm terribly upset personally because I've lost a lot of my bragging rights on the lighter side. You know, when a junior would ask us a problem on a CRPC, I'll tell him 167 subsection 2 third proviso. Now I can't do that anymore. These are different sections. But that aside, there's good and there's bad. Okay, in some senses it is the thin end of the wedge. I'll come to that. But number one, for instance, organized crime is an offense now under the IPC, the new IPC. And if you look at the definition of organized crime, a lot of things that are very, very vaguely worded and defined can lead to organized crime. crime. For example, and organized crime used to be the MACOCAs, right? The Maharashtra Control of Organized Crime Act, which would apply on repeat offenders and crime syndicates and criminal organizations. Now a much wider, and we understand criminal law cannot by its very nature be vague and ambiguous, right? It potentially renders it unconstitutional. So the definition of organized crime under the new law is challengeable on the anvil of the constitution, number one. Second thing that I'm not happy about personally is police custody after the first 15 days. There might be legitimate reasons for doing it in a case. For example, the accused gets arrested and gets himself lodged in a hospital for 15 days, thereby bypassing police custody. But barring those extreme cases, I think there wasn't a need of any police custody after the first 15 days. Now getting bail across the board would become more difficult because the IO can now seek police custody for 40 or 60 days, as the case may be, depending on the offense. In absentia trial is another big problem. Now we can not only try people, we can convict people in their absence. Now, again, something that has to be looked at, from the lens of the constitution very strictly. The apparent rationale being that we've had a lot of problems extraditing people when they're only facing an investigation or facing trial. And now, since we can convict them in their absence, after recording evidence, it might become easier for us to get them, those fugitives, right? Not getting into the specifics of those cases. But I don't think that is going to be the case, because a trial held in absentia, whether a foreign authority or a country or the Department of Justice in a given country is going to accept your in absentia verdict of conviction and do extradition on that basis, a big question mark. Attachment proceedings under the new CRPC, very interesting. Now, investigating officer in a police station near you has powers equal to that of the Enforcement Directorate as far as attaching properties are concerned. Okay, can move an application before the magistrate, attach properties, and the kind of safeguards that we had in the PMLA on you going to the adjudicating authority, to the ATPMLA, all of those are missing as well. There are certain good things. I don't want to end on this is the last thing that I say, I promise. On search and seizure, and I'll end on a positive note, not all cynical about this. Now, search and seizures are to be videographed. We had, as defense counsel, problems, in a murder case, the police would plant the weapon. Right now, all these search and seizures and recoveries and disclosures shall be videographed, is what the law says. Okay. Now, that shall may be treated as may or may not be. Police may say we have resource constraints and so on. But at least the law imposes a very positive duty on you to record these things so that there are less wrongful implications going forward. Mandatory forensics is a good thing. I personally feel that the law does a few good things. Doesn't go as far as it should have in certain other things. Certain other things we'll get to fight another day as constitutional lawyers in a court someday.
Percy sir, any closing remarks on the way forward and how this is going to impact white collar crimes, the new laws?
I haven't looked at the new laws at all. So I don't know. There is something that I put for the summer break. But I think as a closing remark, I just want to say that, look, we have to trust the judicial process. Unfortunately, in the current environment, what has happened is the bar is getting very increasingly fragmented. And both sides of the political divide, if there is a decision that they like, they say democracy wins. And if there's a decision they don't like, they say democracy is in danger. I think this is a very unfortunate situation, and I think lawyers have to be very careful not to get mixed up in this political narrative.
Thank you, everyone. This was enlightening. I'm sure you all had a good time. Do you have any questions, or do we have time for any questions for the panel? So we have no time for questions, and I think the panel was very clear, and I don't think there should be any questions. Thank you, everyone, and thank you for a very patient session.
Thank you. Picture, please. Please request Ashima and Sumit to also join us on the stage of the picture. Thank you. Thank you so much. I'll quickly introduce our next panel. It's an IBC and mediation opportunities for efficient debt resolution in India. Please join me in welcoming our panelists for the same. Shweta Bhavta, Managing Partner, Hammurabi and Solomon Partners. Joining her is Arvind Nair, Senior Advocate. Shweta Mahajan, Managing Partner, Chandrak and Mahajan. Kamal Tandon, Founder, London and Go. Nakul Sachstara, Partner, Nutra and Nutra. Reko Bhai, Legal Head. Joe Nuva Hydropower, APAC. And this session will be chaired by Vallavi Pratap, and Managing Partner, Pratap and Colas. Please welcome to the stage, everybody. Well, let's only do a warm up to them, no? I think they are more louder than we are. Let's try again. फिर से कोशिश करते हैं. Thank you so much. Thank you.
I know everybody has anticipated that this panel will be the longest, but I'm going to make it as short as possible, sweet and short. And I've been told, oh, of course, we've got a very good, sweet topic. So I think it should go off very, very quickly. And I've been bribed already by other co-panelists to make sure that this panel goes off as quickly as possible. So on that note, I don't think any of them actually require any introduction. All of us are very well aware of who all they are. And so without wasting too much time, let's start with Mr. Nair and ask his 2 bits on how he sees mediation in the IBC.
Before I come on the topic, just a comment. I think when you start talking about panels being very sweet and finishing, I think the moral of the story is we should be a little careful of scheduling panels on Sunday, because we have at least 6-8 speakers in the speakers lounge rooting for us to finish very quickly. Because I think we will sacrifice their afternoon siestas. So about mediation, just a little bit of background for a minute or two before I get onto that. I am a great admirer of this legislation, which is very new and which I think is achieved a lot in the short period that it's been around. There has been a lot of resolution, and the problem is just with any process, you also have a very high percentage. I don't want to go into numbers. You also have a very high percentage of genuine corporate debtors who are losing control of their companies and their assets. And that's where restructuring and mediation comes in. I think if we push this firmly, we will be able to be in a position where we'll be able to separate the genuine companies, the genuine corporate debtors who are pushing insolvency and losing control of their companies and assets for various factors and reasons which may not actually entirely be in their control. I think the case in point is we are all still recovering from the 2 major lockdowns and the pandemic. And I think there are hundreds and thousands of companies who saw some big performance because of those factors. And for such genuine companies, if they are mediation, if they can get one more shot for trying to revive their companies and to keep control of their assets, I think it will be a very positive development. I can say from personal experience, without taking names of the case of those particular cases, that we are at a point where councils are starting to suggest mediation. In fact, we recently saw a case of lawyer, and it was a family company of the lawyer where there was an NCLT order of admission, and in 3 days gap, when the appeal was drafted and listed before the NCLT, they had approached the financial creditor and sorted out the whole issue. So mediation is huge scope. We just need to somehow fully incorporate it so that debt restructuring proposals and conversations between various stakeholders can take place and reach a better result.
That's actually a great thought. 3 days and everything gets sorted. No, I don't think mediation as such would arrive in such a quick time. Shweta, what is your take on this?
So my take is a little more pragmatic, and I totally agree with what Mr. Nair has mentioned. Mediation is here to stay.
Right.
mediation is ingrained in our system as a ethos. I think if you think about the older systems for resolution of disputes also, I think mediation was the one process which was adopted. Now, over a period of time, when you have started talking about ease of doing business, I think the first step of ease of doing business was to include insolvency in the process as a law. The second is now to make it a little more seamless as a process, because insolvency otherwise, from the time it started in 2016-17 and from then to now, the kind of timeline that we have started breaching is of, it is making a considerable impact in terms of the stressed assets and the value that it is getting lost. So when we are able to introduce mediation as a process, I think there would be some expeditious resolution of certain issues, which are the reasons why it is getting delayed in the first place. So I think for that one purpose, it is very important to have mediation as a process included in the system. The second is the success of it that has been seen globally. If you look at it, I was in Japan last week and I actually heard a lot of discussions from the Japanese lawyers also about the success of mediation in insolvency.
Right.
So which means, and again, Japan also has very similar, ethics and ethos like us. They also are very pro conciliation and mediation, and they are not into, too much of disputes. So they said that we have adopted, resolution of disputes through mediation very successfully. And it is working very successfully in the insolvency space as well. Similarly for US, I think if you look at their group insolvency, which is also getting resolved through mediation. So that is a success in point. There are Dutch judgments also. If you see, the insolvency process, has been expedited by way of mediation. So I think mediation has played a very integral role in terms of resolving the disputes and reducing the timeline that are required in various other jurisdictions. And I see that that can be replicated in India as well. And I'll just take 1 minute to, give an illustration of it in one of the matters that I was handling. Now, this is a matter before NCLT where the dispute is about 3 crore 54 lakh.
Yeah.
Out of that dispute, the other side says, no, 3 crore is something that I'm admitting to, but this 54 lakh is disputed, and because of which I'm not making the payment. Now, imagine if you're ready to pay 3 crores, then ultimately the court also said the same thing. You pay 3 crores and for 54 lakhs, you can go ahead with the resolution of dispute. But then the fact of the matter is, if we had possibility of doing a mediation, we could have probably resolved some of those issues, and we would have spent less time before NCLT. And there are multiple such examples that
No,
I can throw upon you on
I
this.
totally agree. And thank you so much for giving a world view of how it is working. Pooja, what's your take on this?
No, I completely echo what Mr. Nair said and what Shweta said. I'll just give maybe a couple of points from my perspective. I think the first thing is that mediation is eventually a means of resolving a dispute. So any area in insolvency law where there is a possibility of a dispute, mediation can be adopted. According to me, we need to have, if we are going to be introducing a mediation mechanism in insolvency, I believe that at least to start with, we need to make it voluntary and not make it mandatory, because it's very important to also make sure that mediation is not being misused by the parties to actually prolong, let's say admission process or even prolong the disputes. So I think that is very critical. And I think the other very critical thing about mediation, which will actually determine its success in insolvency, is the quality of mediators, especially in insolvency field. I think it's extremely critical to have people who understand business and who understand how to resolve these type of disputes. And I'll give an example. And this is especially relevant where a creditor and a debtor are negotiating a repayment plan.
Correct.
It's especially critical in pre-insolvency cases where insolvency is imminent and a genuine debtor, what Mr. Nair just mentioned, that we need to give chance to a genuine debtor, right? I think mediation can really be a bridge that will help in bringing back that trust between the debtor and creditors if debtors are encouraged to actually start mediation at an early stage before it's too late and before the company actually goes into insolvency, to avoid insolvency, to have a mediation process where there is a mediation between the debtor and various creditors to see how best the debt can be restructured. To give an example, there are a lot of jurisdictions, and I was attending one of the World Bank's module on mediation and insolvency, and one of the examples that one of the delegates gave of a case in Italy where businessmen, for instance, are mediators and were helping debtors and creditors resolve the disputes. And they had business acumen and they were really helping out debtor and actually figuring out how to cut costs, how to bring operational efficiency, giving their suggestions. So quality of mediators is absolutely critical, I think, to make it a success.
That I think is actually one of the most relevant things that you've pointed out. Kunal, what's your take on this?
So my take on mediation in insolvency, I totally agree with my learned senior colleagues here. I think we need to break down as to what kind of mediation we are looking at in insolvency. One is pre-insolvency completely, in the sense that pre-application also. To an extent, it is available in our Companies Act also, where you can kind of restructure it with your creditors and get into some kind of restructuring, go to court, get an approval of that court. It's a process which was available in the old Companies Act. Second is once the application is made, at that stage, can the mediation be incorporated in the insolvency code? Third is obviously if the application is admitted, at that stage, once the CIR process starts, whether mediation can happen at that stage or not. The other point we must keep in mind is that it is an action in rem. It is not an action in personam. It's not that Pooja and I are fighting with each other and there will be Mr. Nayyar who will say that, listen, you two please stop fighting. It is that the entire panel is fighting and entire panel has to be taken into consideration.
Absolutely.
So we have to take all those aspects into consideration. And I think it is that reason why in 2016, when the code was enacted by the parliament, that mediation was never thought out. Mediation in insolvency proceedings, I think, is a complicated process. As we see it in the United States of America, it started in '86 as against mediation otherwise, which had started in America in, I think, 50s, late 50s or something. But in insolvency, it started in '86. The first case I think they did was the Greyhound case.
Oh, yeah.
Yes, where they actually decided all these issues step by step.
Yeah.
Claims which could be settled, the claims which could not be settled, the claims which were really complicated. So they divided this and achieved some amount of mediation in this entire insolvency realm. So I think it is time for us to get mediation into insolvency with a proper procedure in place, which the authorities are studying now.
Right.
And surely I'm quite optimistic that it will resolve a lot of issues which are pending in courts right now.
On that optimistic note, what do you have to say, Mehak? Because I know Nakul has a very negative thing to say, and I'm really hoping for it.
On an optimistic and light-hearted note, I was reading the other day that mediators are like marriage counselors for businesses, except you're not arguing about who left the dirty dishes in the sink, but who's going to keep the sink.
Yeah.
So yeah. Anyway, on a serious note, I think this is the stark reality that it's a zero-sum game. The winner takes all. And so it's very important to transform this adversarial landscape into a collaborative one. And, just to put out some stats out there so that we understand really what we're talking about. As per the NCLT data itself, only 12% of the cases are getting resolved, 88% are pending. And it's taking an average of 4.5 years to resolve the cases. So mediation is the need of the hour. It's a necessity.
Yeah. Nakul, there you go. I am so keen on hearing your observation because...
No, so having heard everyone, I think so my point of view is a little different.
Yeah.
And I would first want to give the reasoning for why I think otherwise. Insolvency is not a mode of dispute resolution. Insolvency is not based on there being a dispute. Mediation by itself is a form of alternative dispute resolution. It's a form of ADR. So when there is no dispute, what are we going to resolve through mediation? We first need to understand this. Secondly, if we see, if an operational creditor files for insolvency, if the corporate debtor is able to show that there is a dispute, the insolvency fails. So you would have had mediation to solve a dispute, but if a party shows the dispute itself, the insolvency fails.
That's correct.
So the
Yes.
parties will be relegated to the normal Commercial Courts Act or any other arbitration act, and there you can explore mediation. When we come to financial creditors, which is the second mode by which insolvency can be initiated, in that, ideally, there are only three prerequisites that the tribunal needs to see. And none of those prerequisites actually circle around a dispute.
Right.
And insolvency ideally arises when a party is not able to stand on its obligation of making a payment. There is no dispute here that needs resolution. When there is no dispute here that needs resolution, there is no need to have a mechanism to resolve the dispute. And ideally, the Act gives a 14-day time period to the tribunal to either admit or not reject a petition. We all know that's not happening in the 14-day period.
That's correct.
If a party actually wants resolution, then they will have enough opportunity within those initial 14 days to say 3 months time period to resolve a dispute. But by introducing a specific mechanism to send the dispute for mediation, it will not only just prolong, but will give the corporate debtor a lot of reasons to delay it further. We also need to understand that the Commercial Courts Act came before the IBC.
That's right. 2000.
There was a specific provision in the Commercial Courts Act for pre-dispute mediation. There is no specific provision like that in the IBC. The legislative intent thus shows that at that point also it was not contemplated because the insolvency procedure is absolutely different and operates on a very different sphere than a dispute resolution mechanism. So that, I mean, my thought is based.
I understand Nakul. Nakul and I are actually against each other in a few matters, so I don't think we'll ever have mediation in those. But coming back to you, Mr. Nair, the question that I have is that there is globally, we've seen that there is something called as debt restructuring agreement. Do you think India has that form, or do you think it's workable in India?
See, I think there are, first, let me just straight away, before I come to this, let me just respond to what Nakul said. I quite agree with Nakul in the sense that unlike the Commercial Courts Act, you can't have a prerequisite of mediation like the conciliation that is there inbuilt in the Commercial Courts Act, because the potential for its misuse would be immense. I think a lot of time, we are in any case missing all the timelines that are given in the IBC in most of the cases, and that's clearly because of the rush of cases that are there, the sheer number of people who go to court in this country. So if we had a prerequisite of mediation, the potential for its misuse would be a lot, and I think parties would be constantly taking time about whether my notice was received, whether we had a conversation, whether this is adequate, good service or not. So we can't have a prerequisite. When I refer to mediation, what I meant was that in case of genuine issues, and I agree with Nakul, the intent is not to resolve the dispute, the intent is to resolve the corporate debtor. But what happens if, understanding the urgency, the promoters or the management of a corporate debtor understand that this is their last opportunity before they lose control of their assets, which have some potential to be monetized. And just to make my point, I'm going to give an example of a case where I was appearing, again, no names. I was appearing for one of the leading big sector banks, and the adjudicating authority rejected the petition. The grounds being that they were in a niche business, they had good machinery, they were doing some very sensitive contracts, so they should not be saying that they should not be admitted. And the appellate tribunal, despite agreeing with us that there was perhaps an error in what the adjudicating authority had decided. And its reasoning said that, look, we are conscious of the nature of the business that this corporate debtor is in. So let's try and give them an opportunity. And what happened in that 6 month, 4 or 5 dates that we took, eventually they ended up paying. So that's what I mean when I talk about the potential of mediation. It has to, of course, that initiative perhaps has to come from the benches. The only thing is about corporate debt restructuring, that also envisages parties talking about changing the terms, negotiating interest rates, renegotiating lump sum payments. So that can be connected to mediation. But of course, the note of caution is that this will have its own problems. For instance, mediation and arbitration and conciliation, one of the factors is that parties should have some sort of equality, negotiating equality, and that's why the Supreme Court stuck on the clause of unilateral appointments. Here, what we are seeing already in pending cases is that somebody who is sitting on the cusp of a Section 7 petition being admitted, why will he agree to mediation even if the intent of the corporate is wrong? So I think what we need to focus on is who initiates mediation, who are going to be the mediators, the quality of mediators, we also mentioned, others also said, quality of mediators is very, very important. There are 2 cases where I'm appearing in the bench has referred the matters, certain aspects of the dispute to retired members of the adjudicating authority. So that's perhaps one factor.
That's actually true. I mean, it is the intent of the corporate debtor whether or not they want it to be resolved. On that note, but Shweta, the thing is that, Kunal said that it is not in rem. It's going to be, it is in rem rather, it's not in personam. So now do you see that the mediation has to be done individually with each and every creditor, or do you think there can be some kind of a resolution which can be brought about, in terms of all the OCs together and in terms of all the FCs together? How do you foresee that?
So it's actually going to be a very interesting scenario that we are actually envisaging just now. And before responding to that, I also would want to touch upon what Nakul has said, because we all have been propagating
Nakul's got a
mediation.
Pandora's box.
So you have
open just
opened a
now.
Pandora's box, and which probably needs a response. And I'm sure each one of us would have a feeling towards it.
So nobody's giving closing remarks now. This is all that we get.
So if you look at, the number of Section 12A petitions that applications that are filed before the court, or even Section 30A1, of the CIRP regulation applications that are filed before the court, that in itself speaks volumes about the potential of mediation that exists in the insolvency process.
Yeah.
It's not only about A versus B at all times. It is also about situations which can be resolved and for which we have to go up to the Supreme Court many a times to be able to get this order. So if we are able to resolve it through mediation, I think we'll be able to reduce a lot of substantial time. So that was one bit that I wanted to add. Now, coming to your question on how is it going to pan out, because it is otherwise, the insolvency proceedings are a proceedings in rem. And if we have to resolve it through mediation, how does it pan out? And therefore, probably why it has to be kept out of the Mediation Act. That is the first step that has to be done, is it has to be in the exclusion of the Mediation Act, because it cannot be a part of it. Second is, if it has to be mediated, I think there would be certain issues which can be resolved through mediation, and for which there could be, in REM kind of a proceeding, which could be initiated to resolve certain kinds of issues which are common to multiple parties. I think that would be the one way of, looking at a solution around it. And secondly, also, if we are able to arrive at, a common solution, probably a settlement agreement or a mediation, a settlement agreement kind of MSA kind of a document which can be executed, and that can be separately enforced. And for the rest of the issues, any which way the CIRP process is going on. So I think we will have to bifurcate the issues into different parts and then, look at mediation. It cannot be one size fits all.
That's right.
Definitely not in mediation for sure.
Yeah. Pooja, your comment on Nakul's thoughts, one, and secondly, also on where do you foresee mediation to fit in as far as the CIRP process or the IBC process rather?
Yeah, sure. I mean, just on what Nakul is saying, and I'm completely on board that we should not allow it to be misused. And it needs to be voluntary according to me. So only if parties agree to mediate, that's when the mediation should actually be triggered. As far as proceedings in REM is concerned, of course, we all know insolvency is proceedings in REM, but within those proceedings, you will find specific areas of dispute. which do have a scope for mediation. And I'll give 3 examples of this. One is a case that my learned friend, Mr. Tandon, is fighting against our client, where there is a CIRP process going on. We are representing the RP, and there are disputes that have arisen between the corporate debtor and one of the critical operational creditors. I would personally like to think that that dispute can be mediated to keep the company as a going concern, and there could be some give and take within the process. So yes, there is scope in some areas which can be explored. Another example is intercreditor disputes, for instance. There are a lot of, and it happens a lot even practically when you sit in the committee of creditors meetings and when you're negotiating a resolution plan. A lot of disputes happen intercreditor, and these disputes are related to, well, my security is this much, why should I not get this amount from the plan, right? You will have cases where unsecured financial creditors will be saying that, even though I don't get anything under the waterfall, I should be getting some amount. You may have cases where there may be home buyers sitting in a COC saying that this is what we want out of a resolution
I think
plan.
you argued last week before Justice Chandrachud.
So there can be different scenarios here where intercreditor there are disputes, and I can tell you practically how it works is there is a lot of give and take. I attended a COC meeting last week, again, no name spaces, where creditors inter se were trying to figure out that, yes, if this is a resolution plan amount, how much do I give to each of the categories of creditors? There were discussions happening. Those are the kind of things where I think mediation has some scope, because sometimes these issues get prolonged. It could take a lot of time for intercreditor issues to be resolved. And if you have a very seasoned mediator who can negotiate between various classes of creditors, types of creditors, it has some merit. And of course, these are proceedings in REM, but there is some merit in some areas to look at mediation as a solution. Another example I'll give is plan implementation. We have cases where after approval of a resolution plan, when plan is being implemented, disputes may arise between a successful resolution applicant and the committee of creditors. Payment timelines sometimes get triggered. COVID happened. People are not able to pay on time. They need a little bit more time to make the payment.
That's right.
Again, there is a scope for mediation in these cases.
Yes.
Personal insolvency. I think there is a huge scope for mediation in personal insolvency matters.
Kunal, there you go. Of course, you can answer to Nakul. And also, my question to you is, how do you see IBC has been so far? And why do you think the mediation was never envisaged at the inception of the Act?
Okay, I think everybody has already answered the concern that Nakul raises. Nakul raises it in a negative sense. My panelists on the right side raise the same concerns in a positive sense. So that's the difference
I
according
think
to
I read something somewhere today where it said that, an optimist builds a plane and a pessimist builds the parachute. So I think
Yes.
Nakul is just building up the parachute.
So he's building the parachute for the plane.
That's correct. Yeah.
So both the things are two sides of the same coin at the end of the day. The concerns are genuine. And that's why when I said that the way and the manner of mediation is still to be worked out. It can't be mediation that we've seen in our traditional sense.
Correct, yes.
Why it was not included in 2016 probably, according to me, is that IBC was a very new legislation at that time. Even the parliament thought that let's test it out first. Second, I think over a period of last 7-8 years that we've seen IBC, we've also seen innumerable amendments to IBC.
That's right.
So as we grow with IBC in various courts, the government have taken cognizance of that issues and they've ironed out those creases wherever it was needed. Mediation is here to stay. If we think that mediation won't come in insolvency, I think we'll be wrong. Mediation is going to come in insolvency. In what form it comes is yet to be seen. And I think I agree with both Nakul and Pooja that it can't be mandatory. It has to be voluntary. Because it has that thing of being misused. So we are yet to see how it is going to come in and how it's going to play out really.
Yeah.
So, yeah.
On that note, Mehek, I remember our conversation yesterday where you said that, how is it that it's going to fit into the timelines? What are your thoughts on that today?
So, I think it needs to be a facilitative tool to the existing timelines, to supplement the existing timelines and not replace the existing timelines. So when I say that, what I mean is that during the CIRP process, you can concurrently hold mediation. So that way it doesn't impact the timelines. You stay within that. Another way to help not impact the timelines would be that you get trained full-time mediators. Right now, majority of them are part-time mediators. So if you want to make the process more expeditious, you need full-time mediators.
Maybe the quality, like they said, maybe a businessman or somebody who's invested in it that way.
Yes. And the last thing is, a lot of the times what I'm hearing here is that, at least from Nakul, what I heard was that it will prolong the process, right? I think it's a misnomer that is going to prolong the process. Just to give you an example, George Lim, the chairman of SIMC, he concluded a $1 billion mediation in 1 day.
1 day.
I myself have co-mediated a matter which was in the NCLT for 3 years when we wrapped it up in 2.5 months. So in fact, even Sanjukta was speaking yesterday, right? She said that the international standards are, they lock themselves in a room for 2-3 days and they're done.
Correct.
So I think it's the intention that matters.
That's true.
Yeah.
Yeah. So Nakul, have my panelists been able to maybe change your thoughts? Or
No, I mean, see,
are we all litigation oriented?
no, like Kunal said, like you also said, both of them are different sides of the same coin. Is just how you look at it. One of the thoughts that came across was that, when you have a company which is doing well and is otherwise not in any amount of stress, but you still take the company to insolvency because the corporate debtor does not go by one of its obligation of making a certain payment to a certain somebody, that's not correct. So that can be avoided. When a company goes into insolvency, a corporate debtor who's not otherwise barred under 29A can actually buy back the company. I mean, can file the resolution plan, take back the company.
Correct.
If you believe in your own company to that extent and you're not barred under 29A, no one holds you back from taking your own company back. 1. 2, let us see what are the type of bars that you have under 29A. The bars are, if you're a habitual offender, you are declared NPA, you are in the defaulters list. These are the primary bars.
That's right.
Now, would you want to give members of a company who come under these bars a second opportunity via a mediation route? Let us see also who we are trying to help.
Right.
Because if these people don't fall within these criteria, they can help themselves by filing a resolution plan, giving the best value and taking their company back. And lastly, during that period of CIRP, the RP performs a very essential function, which is to do the preferential undervalued transactional audit. So a lot of times, if there is something actually rotten in a company, it comes out in that audit, which otherwise it never would. So, I mean, a corporate debtor is never barred from taking back his own company in case he doesn't fall within the parameters of a 29A. So that works well overall. I mean, that is something that we can all think about. That would be my parting remark.
So I think that all of our fees is at least secured till such time that this is not getting sorted. But yeah, absolutely. Why not? Maybe that. So on that note, in case there are any questions, we are open for that. Otherwise, I'm sure the buzzer is still not on. So there. Oh, the buzzer's there. We've done it within time, just about a minute over. Yeah. Photos.
Thank you so much. One moderating and also within time, of course. May I request Ashima, the managing editor of BW Google World, and Sumit, the vice president at BW Business World, to please join us on the stage for a picture. I think when a moderator finishes on time, so खुशी होती है आप लोग को. मैम अवार्ड देना चाहिए. You can tell Ashima, she's right next to you. Thank you so much. Thank you. And with that, it's time to move ahead with our last panel discussion on corporate governance. Please join me in welcoming a panelist for the same. Board Saraf, founder, Saraf and Partners. Joining him is Balbir Singh, senior advocate, former ASG. Joining them is Sabir Mishra, founder, Trust Legal. Joining them is Navodit Mehra, managing partner and general counsel, Conferi Capital's Partners. And this session will be chaired by Mukesh Bhutani, managing partner, BMR Legal. Let's please welcome them to the stage, everybody. Well, this is not here.
Yeah, he's excused himself.
Not a problem, sir.
Good afternoon, ladies and gentlemen. It's a privilege and honor for me to chair this session. When this session was being planned, I was given a topic called corporate governance, but we just wanted to give some shape. And it's my privilege and honor to have with us sterling panel because the topic of corporate governance covers everything that I did in my earlier life, which is accounting, finance, audit, auditors, but it also covers a host of other issues as well. So what we thought we will do in the next allotted 35-40 minutes is take you through some specific themes that we have developed in the area of corporate governance. And those themes range from a host of topics such as interest of minority shareholders, role that the proxy firms have to play. It also covers other issues including related party transactions. We've also seen that in the last couple of years, particularly after SEBI LODR regulations with regard to ESG, that ESG has emerged as a very important facet of corporate governance. And we will try and see as we go along in this discussion to see if we can add more. Mohit, let me start with you first. You are on my immediate right. On minority shareholders, we've seen a host of debates and controversies that have arisen in the last couple of years. Some of them have gone through NCLT, some of them have even gone to the Supreme Court. I just thought if you can touch on that topic and we'll get the others to add what have been your experiences. Is the current framework of law enough to be able to address the minority shareholders? We saw the seesaw a bit insofar as the controversy between the Tatas and the Mistry is concerned, where the NCLAT order was eventually reversed. Of course, they were specific to the facts of Mistry and Tata case. So my question is not necessarily restricted to this one case, but there are many. The Invesco Z controversy also came up. So I just thought we'll start with you first.
Thank you, Mukesh. I think if I look at it from a corporate law perspective, I think the law is good enough. The problem is not the law. The problem is how you enforce it. Today, if you see NCLT, they're just too busy with IBC. They have no time. And then they are not able to look at the oppression and mismanagement issues. And therefore, this keeps getting delayed. And that is where the problem is. So I would say if this has to be fixed, really, you need specialized NCLT tribunal looking after the minority rights. If you look at really, I don't know whether Mukesh, you ever noticed that on the minority protection law, the World Bank came up with ranking. We are ranked 5th in the world. So as far as the law is concerned, we are up there. As far as the enforcement is concerned, we are bottom. And that is the problem. So instead of changing law, I think we need to make sure that whatever rights we have, we should be able to enforce. And therefore, what you require is specialist tribunal, specialist people who man there, and they are focused on getting things done. Like you mentioned about Z Invesco.
which was a very crazy thing that you, a shareholder as a 10%, had a right to call EGM and he just could not call. And courts kept delaying the matter. And at the end, the investor was frustrated and he sold off his shares and walked out of the deal. So what I'm trying to say is it's not the problem with law. The problem is the bandwidth of the courts and to make sure that they manage this law, they manage these cases properly and it get adjudicated so that the rights which are there theoretically, the fourth, fifth, top law, we have the rights, but we can hardly enforce it.
Just very quick comment I wanted, point well taken, no changes from a legislative standpoint, but there is also feeling that with the rise in shareholder rights, the rights given to minority shareholders from a statutory viewpoint could result in malicious and frivolous litigation. What are your views on that and any experience?
I agree with you. Again, just because it can lead to malicious and frivolous litigation, there is no reason why it should not be extended to more. I think what is required is regulatory bodies, courts, they should be very active and they should have the power to penalize. Mukesh, if I see the problem in India is only that you are reluctant to impose penalty on frivolous litigation. And you and me understand that unless there is a commercial disincentive, you will litigate because that buys you time. So therefore, to look at it, changing law, giving rights to different interest group is a great idea, but making sure anybody who's frivolous should pay for it. And as long as you are able to do the same thing, I think if you look at enforcement of contract, the courts are reluctant to award interest and cost. And because of that, even a person who does not have a right keep enforcing contract and keep delaying enforcement of contract. So I would say it's the same problem here.
Sudhir, your quick comments on Mohit, and if there is any rebuttal, but I just also wanted to ask you a related question on the whistleblower mechanism as it exists today. Currently, SEBI is making the whistleblower mechanism available to what they call it as internal stakeholders and not external stakeholders. And there has been a recommendation again coming from SEBI that external stakeholders are not totally within their powers. So I just thought if you can just quickly react to what Mohit's observation was in the context of minority shareholders and your views on the whistleblower mechanism as it exists today, or rather how you would like to see it in the future.
So, Mukesh, I will say from a little broader perspective on corporate governance, because I look at it from a litigation lawyer's perspective and also somebody who practices sustainability a lot. So I'll just tell you, Z, I won't mention because I represent them. So I have a conflict there. But I think what is happening in India, there is a wider discussion that why stock exchanges, why investment is not happening in a particular manner, especially the equity part, or the more and more people actually coming in the formal integration beyond fixed deposit and others and investing in the stocks, despite SEBI trying so many things, because there is a lot of secrecy involved, a lot of curtains are there with regard to the entire corporate governance mechanism. And that's a little broader issue. Independent directors or directors who are there, they are the first people who should be the whistleblowers actually in the entire corporate governance structure. Most of the time, they are also off guard or they are taken by surprises in any kind of situation when it really blows out of proportion. And the entire fear factor of not being accountable and not knowing the entire fact is something which is bothering the larger ecosystem of entire Indian thing. I think Mr. very rightly said that when you say about our trust factor, we are the fifth. I'm very happy to hear that. I was not aware about it. But when you see the trust factor in our corporate structure and also our governance structure, because now if you just touch upon this part, that what is the role of independent directors? If you are talking about beyond family, they are supposed to be the custodians for the entire shareholders, for speaking on behalf of everybody. But how many of them are in a position to be the real custodian for the corporate structure? That's my first worry on it.
Correct. So, Tanan, would you like to just quickly
I'll just say
something?
I'll come from the non-listed company's point of view. And what happened, I've been general counsel for 3 decades now. And my submission here is, although we are not regulated by SEBI norms and other things, but we have very strong corporate governance structure. And the responsibility comes to us as a general counsel when we talk about compliances. So if you are right there on the compliances, I think the governance is taken care of. And here, what is the problem, in fact, in that part where the compliance we at times fail? Because the question of, the concept of 80-20 comes. We understand that 80 can be done, but 20 cannot be done. And for that 20, whether our board is taking the right decision. With your permission, Mukesh, I'll just come with that. There's a book called Kathit Sarita Sagar, 11th century book. And that was written by Somdev. And there he talks about Vikramaditya and Betal issues, Betal Pachisi kind of stuff. So when he takes out that Betal, that's a problem for me, or the case study before the board, and he gives the right answer. Vikramaditya gives the right answer to that question. And when he gets the right answer, Betal goes away. Now, in the board, the question is the right Vikramadits are not there. They are not taking the decision on compliances. And therefore, this corporate governance structure is really required. Thanks.
What has been your experience? Correct. Auditors.
That is where there has been like a lapse or a failure on that part.
Yeah.
And yes, independent directors have also not been very independent. We concede that. But role of auditors, I think.
Correct.
Thank you for the intervention, sir. You talked about corporate governance in the context of unlisted company. Do you think that the whole noise about corporate governance is restricted in India only to listed companies?
I don't believe so. Maybe from the legislature point of view it is, but we have our own. I would say that I was general counsel for Samsung for about 6-7 years for entire Southwest Asia. And our corporate governance was as good as any listed company, rather better than them.
How many listed companies do have unlisted companies have whistleblower mechanism? Point number one. How many unlisted companies actually take out a portion of their profits for CSR? Because in my view, these are two measurable tests for corporate governance. If I just take amongst various things, some unlisted companies or managements or promoters of certain companies know it, and you can come in over here. Most of independent directors, though they are statutorily not supposed to be providing it. Now the company law requirement is thrusting a related party transaction requirement even on unlisted company, but that's again statutory requirement. But how many unlisted companies in India, promoter-driven companies that you are aware of, follow corporate governance norms?
One thing, if you look at the related party issues, if you look at the Companies Act, those laws are there, right? In this listed company, because of LODR, there are even more stringent laws. But what differentiate between the listed and unlisted space is that in a listed space, you have SEBI, which is a strong regulatory body and which is getting into it, and people are involved, and therefore they're whistleblower or they're complaining. There are no external whistleblower, but there are proxy bodies and things like that. They're complaining and they're enforcing it. In private companies, which are not public or private company, but unlisted, the problem is there's no really regulatory on site. And one thing, basically, I think we all understand, if there's no regulatory strong supervision, there are no strong penalties, your market cap is not disturbed, there's not too much of incentive for you to, unless that's a part of the ethos of the company. So therefore, if you see a lot of these multinationals, which they have it part of the ethos, they can't go wrong, they follow it. But a lot of other people do all the related party through unlisted entities. So I would say same thing is with CSR, because really there's nothing to lose. And I would say really, in my personal view, if you really need to improve the regulatory landscape to get to a $10 trillion, I think what is very important is to make sure that there is a strong regulatory body overseeing all these lapses. And that will be an important.
One of the instances I remember very clearly that in the healthcare segment, an unlisted company, private equity invested, and even for the European Budget Committee or any important committee which the investors have been participating and the regular management of the company was participating, a lot of related party transaction was happening. A lot of vendors were being taken, which were relatives of the main promoters. And this was within the knowledge of this private equity company too. And for 2 or 3 years, it kept on going on. And finally, when somebody, the auditors actually raised an issue, and internal mechanism was devised, and they were penalized for that. So the whistleblower actually, in that case, was the auditor which came into being. But I think you will surely like to know that when SEBI has taken the role of going after 1,000 companies to set standards for this country, if you are the 5th largest economy, and you are going to be 4th in next 1 year, the corporate governance will be the perhaps more important than the environment and the social, the governance part, because that is the message which they want to hear, that how much robust we are, how deep we are, and how much trust we can derive it.
I want exactly what Subir said. In fact, today, when I am in the investment banking kind of stuff today, what is required today, the ESG has taken a lot of precedence nowadays. Now, ESG report is one of the really important criteria to give any financing done. So these things are taking up.
Sudhir, while we're on ESG, I just wanted to get your perspective on the current SEBI framework. There is a criticism that the reporting requirements for ESG assumes that there is one size fits all, and there is very limited flexibility. And I know that there are several recommendations that have gone to SEBI, but what would be your blue sky thinking on what can be the future? Because this is a very important constituent of corporate governance and social responsibility.
So Mukesh, this is something I want to talk in detail. In fact, I'll say and encourage with Moisa being here. The law firms across the world are now making ESG reports, not only the audit company and consulting companies. In India, we make ESG reports as a law firm. And what has happened is we realized very early that every company which is interfacing development and environment today, or even if it's not doing environment, after John Kerry said that every lawyer is an environmental lawyer, virtually everything from capital markets to merger acquisitions to private equity, there's some element of green funds or some element of green financing which is going to come. Developmental banks are asking for different kind of guarantees. So we were thinking ESG means environment. It's not. ESG actually across the world is going in a different direction where E is one part, but basically you're addressing to the 14 or 16 SDG goals which the United Nations have fixed up. Now, the India opportunity is very unique. You are China plus, you are competing with Bangladesh and Vietnam. Their supply chains you have to conform to Europe when they are asking you to give all those things. So that becomes very important for you. How your women procure those things, how many working hours they have, do you use child labor? And the board has to look after all these things very carefully in a proper scrutinizing manner that are not adhering to all the demands. So these are the things. When it comes to the governance part, there's a huge lack, which Moisa also pointed out. Why it's a huge lack? Because your entire country, everywhere, from state to state, the laws change. The pollution control boards have different rules, regulations. The state filing authorities have different licenses, are very different kind of thing. So that needs a complete relook. Now, ESG reports have to be seen in a new dimension. If you're going for expansion, you're going for board meetings, if you're going for funding also, ESG report which talks about your energy uses, your water uses, even if you're in an urban cluster, whether you have factories, how the women health issues are being conducted, how they are adhering to the POSH principle. So all of this actually is voluntary, and you're absolutely right. There's no single fit, there's no single law which adheres to it. And the good part is the corporates have addressed to it. So last year, top 100 corporates in India gave their own consumption carbon footprint story. They all have published a report. This is for the first time any country has done. And seeing that sentiment, even the courts have started shifting towards that. Like the Supreme Court passed its first climate judgment, where they said solar power is equally important as saving wildlife.
So both have to be hand in hand. Just 1 month back, they passed an order. So I think ESG in India will be trendsetter for rest of the country too, rest of the countries too, that how we will compete with in post-China scenario, that I have a feeling that on social parameters will be better than Bangladesh, on environmental parameter will be better than most of the countries, and governance we'll have to really catch up. That's our difficult area.
Mohit, just your quick comments on one size fits all recommendations, and also on the CSR. There is a greater need being felt for voluntary compliance, because as you know, the law merely requires a disclosure of CSR and it's not mandated, though Ministry of Corporate Affairs has been picking up on large corporates who actually are not meeting the target. What has been your experiences with large Indian listed companies?
I would say at least my experience has been positive. Most corporates, at least the top tier corporates, are very committed. And if they are not able to spend, they spend it next year or things like that. So I don't see a problem. I think the problem is in the little bit lower down the corporates, where they feel that they can probably use this resource for growth and then they can do it next year. That's a problem, because I think it's all about getting the best out of the resource. But again, having said that, in my personal view, I think whatever said and done, Indian by nature if you have to get things done, you have to have a proper penalty. If you don't have that, I think we are great talkers. We'll talk about it. We'll say we are the best in the world, and we'll not comply. I think that's the problem. That's what I have seen it all my life. Like ESG, Sudhir is very passionate, but right now you can't export to Europe because they will not let you export, because they are making sure every importer is ESG compliant. And because of that, only those corporates in India who are exporting to Europe are complying. The rest are not complying. Because really, at the end of the day, what I've seen in my life is anything which is great theory, nobody cares about it, everybody talks. And lawyers are good to talk. But anything which hurts your wallet, everybody follows it. Like if you remember, corporate governance was a useless word. Everybody thought that it's too much of cost. Why do it? Then the era came when the private equity showed up in 2003-04, and they started giving more value to higher governance companies. And then suddenly the promoter starts saying, if I take $100 out, I actually lose 1,000 on my valuation. So why should I take it out? So therefore you have to, in this country, everything has to be economically incentivized. As long as you economically incentivize, I always feel that you can't enforce contract in India because you make more money by being breach of contract. And that's the issue. I think in my view, that is what is required, is make sure that every guy who uses it frivolously, you punish it. And and if you see today, if you look at the US, any company which does money laundering, they don't put the guy behind the bar. They make the company bankrupt. Here, when you put a guy behind the bar, I remember one of the promoters I was talking, he said, "Kya fark padta hai? Why are you so worried? Maximum kya hoga? I'll go inside and then I'll come out." But if the company goes bankrupt, then the whole family goes bankrupt, right? So I think in my view, the regime has to change. It has to hurt. I think in my view, that is the only way.
You mean the current framework is not?
Current framework is all based on not penalizing. And I think in my view, you have to economically penalize people, not penalize by putting behind bars. That doesn't solve it. I know that.
Please.
Yeah, आपके लिए बोला था मैंने.
I think the panel, but more importantly, Mr. Mohit Saraf seems to be in favor of very stringent conditions and all that. And I have always been against, over-regulation. Or regulations, do not solve the issues. It has to be like a change in the mindset. Therefore, having more penal provisions would not be a deterrent. People will always find ways and means, No one is allowed to murder anyone, but murder still take place. Therefore, what is required is not, again, regulation than regulation. That will create more disputes also. Good for lawyers, but bad for the country, bad for the economy. there has to be some mechanism to change, to have the change of mindset. And Mr. Sudhir Mishra rightly pointed out that there is some movement, you see, so far ESG is concerned. People are becoming conscious of the hazard and peril, you see, which you see not us, but our next generation face. Therefore, that sort of a impression, feeling that has to be created.
If I may
As
just.
a former general counsel of
Yeah.
Sterlite, I wanted to get your views on ESG. because you are the pioneers on it.
With great respect, I disagree with Mohji and agree with Basin sir always. So, see, as a general counsel, I hate to be penalized. Right.
We all hate to be
That's the voice. That's the real voice.
So penalty provisions are one provision, which really we hate. We are scared to come to the board and inform them this is the penalty which you are going to be imposed. But if you see from the other side, how to save the penalty becomes the lawyer's paradise. Right. But what we require here, as I said and gave you the example of Katha Sarit Sagar, that we are not having the right Vikramaditya on the board. And therefore, when compliance becomes loosened, and therefore the penalty provisions taken, so what we require to do, I think we have enough laws, sir. We have enough laws in the country to be the best. Just comply with those laws. That's what is required.
So every time I have a call
Sir.
with a GC,
Correct.
both domestic and international, you know what they ask me? What is the worst case?
Right. Right.
If I say the worst case is a $200 million, they'll stop and follow it.
Correct.
The minute I say the worst case is one officer will be put behind the bars, not a big issue. So that's the reason I'm saying that what hurts is pocket.
Correct.
Otherwise, it's all great job. And I think in my view, if you look at it, is whether it's a corporate governance issues, when you start doing token penalty, it doesn't move the needle.
Correct.
When you put people behind the bar, which is penalty, which I am not at all. I'm saying let commercially they pay. Like if you have spoiled the environment, then whatever you have done, you pay that. And that's what typically globally people do.
Right.
That if they do something wrong, they pay to that extent to fix that problem. And you don't do token penalty, because I think our concept of penalty 73 or section 73 of the damages in Indian contract is all outdated.
Correct.
And because of that, we actually have a field day on all these issues because we can always find a way.
So Mohit is trying to say that use penalty as such a big deterrent that you make people comply with it. Penalty. Yeah.
So almost just echoing what Moisa said. So there is one company which is a very big multinational company. They were involved in a plastic transition. So our country actually has done an amazing job on the plastic and packaging transition. Very few companies, even Latin America and Europe, have managed to do it. So the General Council, the Global General Council, actually said, why should we do it here? We are not even doing it in America. So we had to tell them that different pollution control boards are stopping your packaging and you will face bigger problem. So you will have to set the standards in India. Now, my one problem with the corporate world is, and the corporate governance is, that our boards are not told the truth and are not warned in advance. And that's the biggest thing. In fact, Supreme Court, our Chief Justice sitting here, there was a matter where for the first time it was seen in the Supreme Court only that the cement companies' environmental data were from Desert National Park, but the case was about Northeast. So you can imagine, they only pointed it out what is happening. So we just take things for granted as it was said, if it was an economic consequence, we just turn blind, we stop doing any job of whistleblowers. And now the change is happening because more than the prosecution, more than the court actually coming after you, it's the regulation which is taking care, regulatory bodies have taken, and SEBI has played a big role there, and we're being watchful about it.
So, Venkatesh, just I'll take 30 seconds intervention.
Only 30 seconds.
Only 30 seconds.
Yeah.
So, see, in one of the cases, in Legal Metrology Act, for us in the Samsung, for us in Samsung, Legal Metrology Act was a packaged commodity, that's what we are selling. And if we submerge, or if one of the things or six, are not written there properly, then there is a provision of going to jail. But who will go to jail? There is a penalty provision as well. But if the director will go to jail after 3 commission of events, right? But it was not being complied properly. And once I had as a general counsel advise my management, if I have a Korean director who is responsible for legal methodology, everything come to a state.
Absolutely.
So at times panel provision really works.
Sure. Thanks for the intervention. Our fourth element, and I wanted to, before the buzzer goes off, one element of the governance was on independent directors. We are now seeing 2 decades of completion of independent director regulation from a SEBI LODR perspective. And we are also seeing one major recall of independent directors because of the 2013 Companies Act. What is the quick verdict of each of you? Where are we on a scale of 1:10? Satisfied, a lot to be done, dissatisfied? Because I did hear some comments, are independent directors truly independent? Not first.
Basically, you're talking about whether
Quality of independence.
quality of independence director. I would say not satisfied because you know one thing, the problem, like people like me, I'm on the board of only one company. I'm just very reluctant. And it's not an easy thing to be on the board because the level of information you get, there's virtually no application, and then you are liable for everything, or your knowledge is presumed through the board process. So it's a very difficult job to be there and to understand, and obviously to even for lawyers who are a little bit more versatile to understand, but to understand accounting issues and things like that, it's not an easy job unless they have independent advisors. I think in my view, that is what is required. Right now, we penalize independent directors. The institution is building, but it's still a long way to go.
Your experience?
Yeah, I would say that it's a long way to go, and we really have to go beyond our cluster of people we normally appoint for reasons best known to the company and best known to the promoters, especially the non-listed ones. Even in the listed one, we have a remote system of appointing people, which is not very transparent. And I think a lot has to be done in that area. It's not risk-free also for real people who can make a difference or play the role of being whistleblower to be appointed or who look forward to be appointed. I think these are the areas we need to really work. And that's why I say that the ESG, the G part is the work in progress.
Your experience?
I agree. G part is certainly work in progress, but in the scale of 1 to 10, I'll give 6 to 7.
So, Mohit, before we end the session, I completely echo your view. I chair audit committees for 4 listed companies. And trust me, a day before the audit committee and the board meeting, I don't do any client work because the volume of papers that hits my table is so overwhelming that despite having practiced as a chartered accountant for 2 decades, I still find it difficult to grapple with the host of regulations you have to deal with.
So I think unless you're an auditor, really you need a lot of independent advice, and which typically no board gives or independent directors. And therefore, for them to apply themselves and really do a good job is very, very challenging. So I don't really blame them, but I think that we have to build an institution where they get independent advice so that they can apply themselves well.
Well, our time is up. Just at the right time. Our time is up. Thank you very much. I would like to thank our esteemed panel. And with that, hand it over to the organizers. Thank you.
Thank you. Thank you so much, sir, for sharing that much of attention and time. Thank you. I please request Ashna Ori and also Sumit Arora from the Business World teams to please join us on the stage for this picture, please. Thank you. Thank you so much. Thank you.
It's easy becoming strong. Yeah, governance happen.
Thank Okay, and with that, we come to an end of our panel discussions for today. And before we proceed towards the award ceremony, there's some very, very, very important keynote addresses to be delivered. First, let's please welcome the chairman and editor-in-chief of BW Business World and founder of the Exchange for Media Group for keynote address, Dr. Anurag Batra, everybody.
I remember. Good evening. It's my honor and privilege to welcome you to the 5th edition of the BW Legal World Global Legal Leaders Awards 2023-24. We started them in this room on 12th December 2019. First of all, it's my honor and privilege to welcome our jury chair, who led the jury with aplomb and guided the whole jury process to be able to arrive at the winners tonight. So let me welcome the former Chief Justice of India, Justice Deepak Mishra ji, who's here. Thank you for being here. And the BW Legal World team, you may want to get the outstanding lawyers who are outside the room, inside. Now that the networking and tea and coffee are an important part of what an event is. I don't want to stand between you and the other speakers that will speak. I would also like to acknowledge the presence of Dr. Lalit Bhasin, who's the president of the Society of Indian Law Firms, and is a stalwart who really doesn't need an introduction. He has, when I grow up, I do want to be like him, but for now, I'll be myself. I just want to say that last year and this year also, the theme has been about governance, about arbitration, about how mediation can help, because mediation was brought in as a tool to make the process shorter and also more efficient in terms of costs. But mediation hasn't served its full course. So arbitration has become, arbitration was brought in to, shorten the time period and the cost. And it hasn't really served the purpose. It has served the purpose to an extent, but hasn't served it to the extent it should have. So arbitration has become a big theme, and arbitration mechanisms are solving a lot of vexatious issues and disputes, but we have a long way to go. The legal services domain is multiplying. The number of law firms are growing. Within the law firms, the numbers are growing. Governance is leading to more and more GCs getting on the boards of companies. So the legal services domain is poised to quadruple in the next 24 to 36 months. That means every stakeholder in the ecosystem will grow. I just want to say that the process of jury was led by Justice Deepak Mishra. We have Mr. Vasani here and other jury members. My gratitude to Mr. Mukesh Badani. He was saying Mr. Saraf was saying not everyone has the legal understanding and the accounting understanding. And I was looking at you, there are a few people who have both, but they only practice one. I must qualify that. So, Mr. Sudhir Mishra, thank you for being part of the panel. I just want to say the process is honest, and Justice Deepak Mishra will talk about it. I congratulate all the winners. We're in the BW Legal World community for long term. We still have a long way to go. As I've said before, we have to go beyond Delhi. We have to deepen it. We have to be able to serve the knowledge, information, and insights needs of the two communities that matter to us, the GCs and the law firms. So I'm sure Ashima, Kaustav, Krishnan, Sumit, and the entire team of BW Legal World and BW Business World will be able to do it. I don't want to stand between Justice Mishra and Mr. Lalit Bhasin's address. I just want to express my gratitude to you for being here, and I look forward to celebrating your success tonight with you post the awards. Thank you. God bless you.
Thank you. Thank you so much, sir. And now for our next keynote address, please join me in welcoming on stage Dr. Lalit Bhasin, President, Society of Indian Law Firms. Please, everybody.
Good evening, sir.
Honorable Justice Deepak Mishra ji, Dr. Anurag Batra, my very distinguished colleagues from the law firms and from the litigation lawyers, the General Counsel, in-house counsel, ladies and gentlemen. Happy Mother's Day. You see, what I'm going to speak about is giving away by the profession to the society. Like the mother gives away everything without expecting anything in return. That is the most selfless love which Mother's Day symbolizes. I want to tell you that our Constitution, the very preamble of the Constitution, says that we have to secure to the citizens of India justice, social, economic, political. Is the justice being made available in any form, you see, to the citizens of this country? We have to introspect, we have to think about it. If our impression is no, it is not being done, then there is a big responsibility, not only on us as the citizens, but also as enlightened citizens, being lawyers, being upholders of the values of the Constitution, to ensure that there is, you see, justice delivery system. Yesterday, I was here. There was the General Council get together, brilliant sessions, working sessions, and then later on the awards were given. My message to them was that they should claim the right, from the Bar Council of India, from the Government of India, to be recognized on equal footing as the external lawyers are, because they are doing no less work, important work, than we as external lawyers do. Actually, the development of the economy of our country depends upon the legal support which the General Council give to their corporate employers. It is based on that joint ventures are entered into, protocols are entered into, bilateral agreements, conventions, everything, because of the legal support. But the message I gave to them was, keep at the back of your mind that you have to give back to society also. Therefore, try to ensure that in some way or the other, while being very close to your top management, the board of directors, but if they are doing something wrong, you must assert yourself, because you are a lawyer who believes, you see, that values have to be upheld, constitutional values have to be upheld. Later on in the day yesterday, I attended, you see, the Arbitration Bar of India that was set up yesterday, initiative taken by no less a person than the Attorney General of India and the Solicitor General. The Minister of External Affairs was present, Mr. Ashwin Vaishnavi was present, and so many other dignitaries and all that. It was to set up the Arbitration Bar of India. Later on, I had some interaction. I say, after all, it is just like a bar association. So we already have the Bar Association of India, we have the Supreme Court Bar, High Court Bar, the NCLT Bar, the Consumer Protection Bar. You see, all the bars are there. Why, where is the need, you see, to create another bar? I have seen the bar in UK, arbitration bar. They exclusively and only deal with arbitration matters, not any litigation matter. They will not go to the courts. I wanted to consult someone, some senior counsel. He says, sorry, Lalit, I can't do it. I am, you see, in the arbitration field and all that. That is the arbitration bar. But how does it help in creating more effective way of dealing with arbitration matters? We are, I think, putting cart before the horse. And I said so very openly also later on after the inaugural function. I told them, first create those institutions where the disputing parties should have confidence that yes, arbitration will be quick, will be expeditious, it will not be very expensive also. Why two corporate bodies who have dispute, who are in India, Indian parties, they prefer to go to Singapore and not have the dispute arbitrated upon in India? Therefore, create those institutions. We lack those institutions. By just setting up one institution, which is called the International Arbitration Center, under the chairmanship of one of the esteemed former judges of the Supreme Court, that is not going to help. People will consider that to be a government-sponsored body. What we need to create are independent institutions and all that. That was the second function I attended. Today is the third one. In 2 days, these are the this is the third function I'm attending. And I feel more at home here because here we have the law firms, we have the general counsel who are aware and conscious of the fact that dispute resolution is most important. I think that is a very important factor in our profession today. Justice, we talked about 5 crore cases pending all over the country. So where is the citizen getting the justice? Our courts are busy with very high profile matters, political matters, religious matters, temple masjid matters. What about the justice delivery system for the citizens of this country whose cases are piling up? Even technology has not helped us. Technology has facilitated filing of cases, filing of evidence, filing of affidavits. But what about the disposal of cases? I asked the Honorable Chief Justice myself, you see, I say, yes, we give you full credit during COVID, virtual hearings, and now you see they are in place. That is all right. All these are facilitators. But what about the disposal of cases? What is being done? Therefore, my appeal has been yesterday also, and at the time of the arbitration bar inaugural also, and today also, that there is a big responsibility on the corporate sectors and particularly the general counsel, the advisors, and we as external lawyers to promote settlement of disputes. Mohit Saraf will say, I always keep on talking about, you see, the settlement of dispute, but that is a mission for me. That is a mission for me that I would like to promote samjhautas, settlement, because that is in our culture. That is our legacy. Even in ancient times, we had consensual form of administration of justice. There was no reference to law. Reference was only to dharma and justice. That was just a consensual form. At the panchayat level, at the Zilla Parishad level, even during, you see, the Mughal times, there was Adle Jahangir. Adle means, you see, justice. Emphasis has always been on justice until the British came and they foisted on us, you see, this adversarial form. We have to live with it because it is now a part of our constitution. Nothing can be done about it. What can be done is, without tampering with the constitution, is to promote settlements. Constitution doesn't prohibit that. Rather, it talks about justice in the preamble. But nowhere else, you see, it is mentioned that justice should prevail over law. What is happening now is law is prevailing over justice. There's hardly any justice available. Therefore, my appeal to this august body, you see, which is taking up this. And I'm very grateful to Dr. Anurag Batra for having taken these initiatives of bringing the different segments of legal profession together, the General Counsel, the External Counsel, the judiciary, the former judges of the Honorable Supreme Court and all that, so that there could be, you see, a soul searching as to whether we are doing something for the society. And the only way, as I look at, otherwise there'll be a complete breakdown in our system, is to ensure that these 5 crore cases at least do not become 6 crore or 7 crore. Slowly, gradually, this number should be minimized and eliminated. And that can only be achieved if we have a good system of mediation. I am very proud, you see, to share with you, some of you must be knowing it, that our Society of Indian Law Firms has very recently got its own building at the Rouse Avenue. And the building was inaugurated by Honorable the Vice President of India on 29th of April. And we have dedicated that building to dispute solutions, that will be a center for dispute solutions, you see, so that we can achieve what our Constitution mandates us to do. So thank you very much. Thank you.
Thank you so much. And I please request Ashim Auri, the managing editor of PW Legal World, to please join us on the stage and present a token of love and appreciation, sir, please. Please, Dr. Bhasin. And now we'll also be taking you to the jury process of the awards ceremony. After this, exactly what happened and the process of your awards, etc., etc., etc. But before that, we have a keynote address by the jury chair. Please join me in welcoming on stage the former Chief Justice of India, Justice Deepak Mishra ji. Everybody, please, sir.
Dr. Lalit Hossain and other members of the jury, Dr. Anurag Batra, Ms. Ashima Ori and other associates of the business world, award winners present today, associates and partners of leading law firms, General Counsel and legal heads, ladies and gentlemen. At the very inception, I must unreservedly express my delight to be part of the jury for the simple pure reason that immense efforts have gone into the systematic scrutiny, nuanced analysis, and finally proceeding with the process with sacrosanct objectivity. And I mean it. It's nothing else but the epitome of dedication and intellectual passion. To be selected to get an award is a recognition, and when it is conferred by an established concern like business world, the said recognition gets more accent and fructified pleasure. I'm obligated to say that law always requires constant learning. And in recent times, the study warrants one to be friendly with the digital climate, artificial intelligence, green economy, understanding the subtleties of mergers, acquisitions, e-commerce, insurance law, insolvency, and other ancillary aspects. That apart, I must state that it requires lateral thinking, out-of-box thinking. The field of law desires, I do not use the word expects, desires a lawyer to be globally relevant after globalization of commerce and the ideas intricately connected with it. Modernism requires and commands inbuilt enthusiasm as that association, industry, and creativity. The two major planks of sustenance in any field of work. Legal firms in the corporate sector have emerged that share legal knowledge, emphasize on collective specialization and individual intellectual honesty. A competent legal team not only engages itself in complicated transactions and gets them concretized, but also assumes the significant role of negotiators, becoming organized to sustain the reputation of the firms and the interest of the entities. They enable their clients to earn trust, which is the element vital in a highly competing economic world. Today's tremendous economic impact warrants constant, innovative, and stimulative ideas that leads to further growth of our economy. And I must tell you that whenever there is growth, it commands a different kind of guidance with expertise and skill. Growth of law firms today is not embedded in traditional thought and processes, but in their courage to have impact, ambition to dream and expand, and convinced attitude to be solution oriented by their determination to solve problems that are manifold. The growth of law firms, as I see, and I must say, depends upon their future vision and their present achievements. As is presently seen, they are expanding the net of employment. That's a thing not to be forgotten. And increasing the financial health of the community and society as a whole. 21st century, as I perceive, is the time of performance determination. Please mark my words. Performance determination. The field of law commands ethics as well as competitive administration. The present awards given by business world stand for that. I must say, without any innovation, that the business world team, especially Dr. Anurag Batra and Ms. Asima Ohri, deserve admiration to conceive the numerous areas to confer the hours they have chosen and also for the smooth organization of the same. And it's my obligation, a happy one, to congratulate the awardees. But my written text is over, ladies and gentlemen. I would like to comment. Most of you seem to me you are quite young. Some are quite old also in a different way. Never, and I warn you, become a pessimist. Pessimism has no space as far as the growth of Homo sapiens is concerned. All of us have to understand the distinction between following of a case and pendency of a case, failure of a case. The courts are working. What do you want? Docket exclusion or docket inclusion? I always believed as a judge since 96 till 2018 that there should be docket inclusion. People must come to court. They are invited to court. It's not why they come to court if they feel that the cases are not adjudicated. It depends upon your mindset. Second, you see, emphasis was laid on arbitration, mediation. I accept that. But simultaneously, Lok Adalat, please see the features of Lok Adalat in last 15 years in this country. Thousands and lakhs cases have been disposed of. I mean, compromised. I'll give a small example of compromise. Anyone who is keen can stand up and answer. The younger generation, not people above 45. You see, Section 138 of the Negotiable Instruments Act provides for settlement compromise. You don't give a check to someone unless you know him. It's a district court case. I understand. I was the chairman of SALSA. It was 2007. He had given a check for 15,000. A case is a case, and every case I name has a human face. The magistrate tried, he failed. The district judge tried, he failed. The legal secretary tried, he failed. They came to me because I was the chairman of SALSA. I said, what's the problem? Now he had given a check for 15,000. He said that he will give back 15,000. But I want 20,000, not a pile less. Obstinate. Obstinate attitude destroys your mindset for solution. You have to gradually assuage that. That's the duty of a person who is trying to solve the problem. He must have Himalayan patience and, if I'm permitted to say, Everest time ground reality knowledge. So, man was obstinate. How do you handle? Please do not think I'm claiming interest or I am claiming any kind of credit at this age and after 17 years. I don't need it. I said, all right. 20,000 you have to give, you have to take. 9 years. No problem, sir. I said, all right. You have got 15,000? 9 years. Give it to him. Give it to him. So he gave. He was reluctant to take. I said, take it. Put 10,000 in your left pocket and 5,000 in your right pocket. Put it. He did that. I asked the gentleman who had taken the check, you must be having another 1,000. No, sir. I check. So we got another 1,000. I said, give him, you put it in your shirt pocket. He did that. Then I said, you want 16,000 and settle? He said, no. All right, fine. Take out your money and give it to him and contest. You see, money in pocket does matter. It's a ground reality, common sense. And what is it called? Not common sense. A person who has to settle disputes must have oncoming common sense. So he agreed for 16,000. One. Second, Tax Bar Association is an independent bar association. 90% of the members do not come to High Court. They have a system, assistant commissioner, then eventually tribunal. Now things have changed, but anyway, once have changed, things are there. You see, I must tell you, people, when there are some advocates who are not even arguing Section 34 matters in High Court. They are confined to arbitration. So it's a step. A step forward is good. We must welcome it. Let's see how it shapes. Third, Dr. Lalit Vasni is a very good friend of mine. We talked about a very good thing. We said in our culture on earlier occasion, things used to be, disputes used to be settled by dharma. What was that dharma? Dharma was based on certain written and unwritten principles. Well, you have to go to the Shastras that deals with nuances of social governance, business governance, and other governance like Mimamsa and other books. You will get how much share, whose brother, whatever was there, they were not. And another aspect, they trusted our elders. Mediation, I must appreciate Mr. Dr. Lalit Vasni that you have talked about it, and you have also said that you have got your own building. Ask the negotiators to earn trust of the parties. That's the main thing. I know it. I don't have to tell. Everyone knows it. I'm not saying that they should be elders. They should be patient, eloquent, and simultaneously they should be absolutely humble. The power of unity is greater than nuclear power. I must say, we have got the written speech and the unwritten speech. Thank you very much because you have shown your courteous patience. Thank you. Okay.
Ashma? You want to do both of them? Yes. The former Chief Justice of India, Justice Deepak Mishra is here, everybody. And thank you, Ashima, for doing the honors. Thank you. And now, ladies and gentlemen, moving ahead for those discussions that you witnessed all throughout the day to the evening's celebration. My name is Aditya Malik, and once again, I'm delighted to welcome all of you to the fifth edition of the BW Legal World Global Legal Leaders Awards. It's an initiative to recognize and reward the law firms and lawyers who have made a mark in this very practice area. An annual initiative conceptualized different excellence in the legal ecosystem, identifying and also enabling law firms and individual lawyers with the potential to lead the way. This award ceremony is being broadcasted live on all BW Business World platforms, including the social media channels and also on the website www.bwlegalworld.com. I would request, please join in the celebrations of the evening by using the hashtag BW Global Legal Leaders Awards. I also take this moment to thank our partners, our exhibiting partner, Valuable, our legal tech partner, Lawyer Desk, our managed partner, Chandru Mahajan, advocates and solicitors, our event partners, Joy Travels Private Limited, Bandrum, Bali Coffee, The Thick Shake Factory, Reality Plus, Exchange for Media, IWM Buzz, Impact Weekly Magazine, and also Pitch. With that, can you please have the partners, Avi?
Hi, welcome to Wellness. We are trying this having technologies. We are excited to introduce a suite of applications transforming the legal landscape with GenAI to deliver efficient, accessible legal assistance directly to your device. Introducing Tablets, our flagship solution for designers and lawyers for seamless standards for legal efficiency and creativity. A pioneering platform crafted for the public establishes more benchmarks for legal empowerment and accessibility. Using Dragon, a web solution designed for aspiring legal professionals for its new standards for educational excellence and accessibility. With wireless, the future of legal empowerment is not the same thing, it's legal. We believe in actions and initiative work unlocking success for the legal professionals and the public life. And today, I'm happy to announce that this new era begins with the launch of our business zone, followed closely by the channel and coming to you in June. China has become its groundbreaking visions into reality. I was really gratitude for your attention and support. Have a great day.
Thank you. Also, Dr. Batra had first mentioned about the entire jury process and how we eventually arrived to the winners list today. We also heard the jury chair speak. And we wish to show you that what exactly happens in the entire jury process. How do we really arrive at this list that they're going to be announcing in a while? To show you that, can you please have the jury, Avi?
Congratulations to the winners. You very well deserve it. This was a rigorous process where each of one of you had submitted your credentials before the jury members, and the jury members had taken time. It was a very esteemed, respected jury members from various fraternity, and all of them had put in their effort, time, energy, and they had selected with lot of effort. They have selected the right. I'm sure that they have selected the right law firms. Congratulations to the all the winners. Best wishes to you, all of you.
Can you please have a huge round of applause for the jury members? And very important announcements from the winners. Once you receive your award and you step down from the stage, please proceed to stage left for a picture for the magazine. Also stay back till the very end for a group picture, which will then be followed by a networking dinner for the winners only. Also, we request you once you've received your award, please deliver an acceptance speech of 10 to 30 seconds. That's the budget allocated to me. Uske aage it's all up to you. Yes. The moment we're waiting for the fifth edition of the VW Global Digital Leaders Award to present winners to our first set of winners. Please join me in welcoming on stage Dr. Anurag Batra, Chairman and Editor-in-Chief of VW Business One, founder, Exchange for Media Group. Joining sir is Justice Deepak Mishra, former Chief Justice of India. Joining them is Dr. Malik Bhasin, President, Society of Indian Law Firms. Please join him. Well, categories and then winners in them. That should also be displayed on the screen in the form of an AV. So can we have the first one, please? Defense Banking and Financial Services law firm of the year, one with us, Ms. Ajay Sahani, Ms. Shruti Gaurati, and Ms. Anandita Koshi to receive the award.
Thank you very much, jury members. Thank you, BW Legal, for this award. I'm accepting it on behalf of the team and the firm. Thank you once again, and congratulations to all the winners who will be upcoming now.
Congratulations. Congratulations. Winners, please don't forget your individual pictures here after you receive the award. Moving ahead to the next one, please. It was a week like $1,000 partner, Ivan and Co. Best Dispute Resolution Lawyer of the Year.
Thank you, learned jury members, and thank you, BW Legal Award, for bestowing me such award and recognizing my work. Thank you.
Congratulations, sir. Please. Congratulations. And the next one, please. Professional and Associates Real Estate Law Firm of the Year. We have with us Saloni Saluke, Principal Associate, to receive the award. I am pleased.
Thank you so much. We are very grateful on behalf of Dhaval Vasanji and Associates, and we hope to win in other categories also from next time onwards. This is a huge honor. Really grateful for this. Thank you.
And as the screen also said, this is a shared award. The next one of the Real Estate Law Firm of the Year, please. Well, our friend partner, we have another senior partner, one of the Safety Award. Mr. Robin Partners, please.
Thanks to the jury members, BW Legal, and all my colleagues at Saraf and Partners. Thank you so much.
Congratulations. And the next category, please. Restructuring and insolvency law firm of the year. We have with us Pooja Mahajan, Managing Partner, and Mehul Party Counsel to receive the award.
A big thank you to Business World and to the jury and to my team members in the R&I practice. Thank you.
Congratulations. Moving ahead with our next category. Partners, Recovery Law Firm of the Year. We have with us Arnav Chaudhary, Partner, and Andy Volleyball Partner to receive the award. Let's give them a huge round of applause, everybody. Thanks to BW and jury members for distributing this award. Thank you very much. Congratulations. As the screen also said that this was a shared award. And the other emerging law firm of the year, please. Watch and associate. Yeah, was the founder and managing partner, Gaurav Watch, to receive the award. An applause for Gaurav and Associates.
Thank you very much. Thank you very much, honorable jury, BW Legal, clients, colleagues, family and friend. Truly humbled to receive this award. Thank you very much, everyone.
Congratulations, winners. A reminder, your individual photograph, and then also in the end for the magazine as well, a group picture. Please don't forget that. Moving ahead, next category. Intellectual property law firm of the year, we were also founder and managing partner. He will sing to receive the award along with his team. Let's give the entire team a huge round of applause.
Thank you, BW Legal. Thank you, jury members. Thank you, the team members of Intel Advocate and our clients. I must say that BW is doing great work. These kinds of awards are very inspiring. They're very motivating. They make us feel that we are perhaps doing things right, and we set a benchmark that we have to go over, and we'll continue to strive. And congratulations to all the winners. Thank you very much.
Congratulations. That was a shared award. And the other intellectual property law firm of the year. Would have Mittal associate partner, litigation, to receive the award. Anand.
Thank you so much to the jury members, BW Legal, and to our clients. This is a big one. So since I've entered this hall, that Anand, we tend to think of intellectual property in every little way. So I've been thinking from the start, is this chandelier a design? Is that a secondary shape mark? And I've been trying to think through that. So that reflects, and the fact that we've got an intellectual property firm of the year reflects our holistic strength. And thank you.
And what about my hairstyle? Is it an idea I can safeguard? I'll take your advice offline.
Congratulations. Next one, please. And company area law firm of the Apex of Excellence. We have with us Ms. Nandini Guru, the senior partner, to receive the award. Karanjawala and company, everybody.
Thank you to the jury and BW Legal and the whole team of Karanjawala and Company, not only the lawyers, but the staff also. Thank you so much.
Congratulations. And with that, the next category. Outstanding achiever. We have with us Samir Jain, the partner to receive the award. Congratulations.
I'm very grateful to the esteemed jury members, BW Legal World. A huge shout out to Mr. Samir Jain, our managing partner, whose leadership continues to inspire us every day to pursue excellence. Thank you, everyone.
Congratulations. And with that, thank you so much, Dr. Basin, for helping us with the awards. Once more, sorry, everybody. Dr. Alok Basin. I please request Nina Gupta, the managing partner of Basin and Company, to please join us on the stage and help us present awards. The next set of winners. Okay. Into the next category, please. And Company Irrigation Law Firm of the Year, Apex of Excellence. Once again, have with us Ms. Nandini to receive the award, senior partner.
Thank you to the jury and thank you to BW Legal World and thank you to all our clients who have faith in us. Thank you so much.
Please request you, Ms. Anil, Legal Director, Sada Yusha, can you to join us on the stage and help us present awards. Also a jury member for this one. Okay, with that, the next one, please. Next council Irrigation Law Firm of the Outstanding Achiever. We have with us Mr. Alishan Naqvi, the partner to receive the award. Let's give them an applause.
Thank you, all the jury members. Thank you, BW Legal World, for recognizing the efforts of our firm. And I am extremely humbled to receive this award on behalf of my entire team. Thank you so much.
Congratulations. Moving ahead, the next one. Xavier, the General Coordinator of the Journey Special Mention. We have with us Sumesh Diwan, the Managing Partner, to receive the award. Thank you very much. Round of applause, the entire team.
Hi, thank you, jury members. Thanks, Business World. It's a great validation, and thanks to my colleagues and our clients who make it possible. Thanks.
And with that, the next one, please. General Corporate Law Firm of the Year. We have with us a partner, Shinoj Koshi, to receive the award.
So a big thank you to BW Legal and the esteemed jury members. So this is certainly a recognition for all the partners and the team that makes this possible. So thank you once again.
Congratulations. This is a shared award. Next, the General Corporate Law Firm of the Year. And partners. We have with us Ayush Tandon, the partner, to receive the award.
Thank you, PW Legal, for organizing this, esteemed jury, and thank you to our AZB family. Thank you so much.
Congratulations. Well, not two, but we have three winners in this very category. The next, General Corporate Law Firm of the Year. Example, with us, Seema Jain, the founding partner, along with her team, to receive the award. Round of applause for Lex Counsel, everybody.
Thank you so much, jury. Your words mean a lot to me, sir. So the motto in our corporate team is do not strive for perfection, strive for excellence, and that's where the magic lies. Thank you very much.
Congratulations. And with that, the next category. Legal PNP Law Firm of the Outstanding Achiever. We have with us a senior associate Nachiket Yagnik to receive the award.
Thank you so much to the esteemed jury members, to BW Legal for bestowing this award to us. And I humbly received this on behalf of my team and the firm at large. Thank you.
Congratulations. Thank you so much for helping us with the awards. Thank you. Once for him is also a job member. May I request Arvind Narula, CEO of PW Healthcare World and also of Wellbeing World to please join us on the stage and help us present awards. The next one, please. Legal and Modern Platform of the Year. We have with us Subir Mishra, the founder and managing partner, to receive the award.
Thank you. Thank you so much for this recognition to, and especially thank you to the esteemed jury. For us, environment is something that we've only learned from Sudhir sir. And I think this is also the need of the hour to really work towards, environment and environment law. So thank you so much, sir, for the recognition. Thank you so much for BW Legal also.
Congratulations. Congratulations. This was a shared award. And the other winner, please. Law firm of the year. We have with us Abhijit, associate, to receive the award. Not a problem. I'm here to receive the award. Let's give them a huge round of applause.
Thank you so much, BW. Thank you, esteemed jury members. And this is for my team. Thank you so much. I wish Abhijit could come on the stage. I don't know where he is at the moment. Thank you so much. Thank you.
And with that, the next one. We have with us Mr. Arjun, partner, litigation and dispute resolution. We also have with us Suraj Raj Keshavani, senior associate, litigation and dispute resolution, to receive the award.
No, bigger round of applause.
Thank you for this recognition to the jury members, BW Legal. Congratulations to the other members and yeah, thank you.
Congratulations. Congratulations. Winners, please don't forget individual pictures and also a group picture in the end. With that, the next one. Amateur Mandalas Mergers and Acquisitions Law Firm of the year. We have with us Ms. Sahani, Bhuti and Ms. Anandita Kaushik, who receives the award.
Thank you, BW and the jury on behalf of our entire team. Thank you so much.
Congratulations. And the next one. Advocate, Oil and Gas Law Firm of the year. Here with us Ms. Pragya Ori, equity partner, who receives the award along with man. Along with the partner to receive the award. Arpita. Amritaji to receive the award.
We accept the award with humility and thank the esteemed jury and BW Legal for this honor. Thank you so much, everybody. Congratulations to all the winners. Have a great evening ahead.
Thank you, everyone. Thank you so much. And a big thank you to our clients for trusting us with such niche work. Thank you.
Congratulations. Moving ahead, the next one. Equity partner of the year. We have with us Ms. Radha Sahani, Ms. Rutika Rathi, and also Ms. Anandita Kaushik to receive the award. Round of applause.
Thank you, everyone. Really humbled to receive this award on behalf of the entire P practice at CAM as well as the entire firm. Thank you very much.
With that, the next one. PMR Legal, that's law firm of the outstanding achiever. We have with us Shanky Agarwal partner to receive the award. Along with Mr. Mukesh to receive the award.
Really humbled to achieve this or receive this award from the jury. Big thank you to the jury members and BW team. I also want to thank Mr. Bhutani, whose passion and excellence guide us every day. And not to forget our wonderful clients who trust us with such great work. Thank you.
Congratulations. And the next one. Round of applause for practice. Of the outstanding achiever. We have with us stage as Pathak, the partner to receive the award. Let's give them a huge round of applause.
Thank you so much. We are truly humbled and grateful to all the jury members and to BW Legal. Thank you so much.
Congratulations. With that, the next one. Yeah. We have with us Ms. Rahul Bhavan Council to receive the award.
Thank you to the jury members and PW team. I'm taking this behalf of my team. Thank you.
Thank you so much, Harbinder ji, for helping us with the awards. Thank you. Harbinder ji, I please request Mr. Mukesh Bhutani, the managing partner of BMR Legal, to please join us on the stage and help us present awards. And the next one. Essential Partners Banking and Finance Lawyer of the Year. Okay, round of applause, everybody. Banking and Financial Lawyer of the Year.
Thank you. Thank you, jury. Thank you, BW Legal. And truly delighted and honored to receive this award. I'm receiving this, but I think I may have done some bit of work, but the support of my past and present colleagues really reflect on this. Thank you very much.
Congratulations. And the next is a joint winner award. Please. King's Club and receive a Best Dispute Resolution Lawyer of the year. Thanks, everybody.
Thank you to the learned jury members, to BW Legal World. It certainly, is very valuable to me, getting it from uh, sir here. So thank you so much.
Congratulations. And this is a joint award, the best dispute resolution lawyer of the year. We found a managing partner and an advocate, and this is the best IP lawyer of the year. For Hemant.
Thank you once again, BW Legal, the jury members, and my team, here, my clients, all the associates. I'm truly humble. Thank you very much.
Congratulations. And with that, thank you so much, Justice Mishra. Thank you so much, sir, for gracing the occasion today. Once also, everybody, the former Chief Justice of India. Thank you.
There are some more awards to go, and we would want our jury members, three of them are here, and our jury chair, Justice Mishra, to be at the group photo with the winners. So he just. Thank you for giving your time, and please give Justice Mishra a big round of applause.
I please request Dr. Lalil Basin, President, Society of Indian Law Firms, to join us on the stage and present awards. And with that, the next one, please. It is Sagar Chandra and Associates Best IP Lawyer of the Year.
Thank you so much. Thank you, BW Legal. Thank you, honorable jury members. It's an honor to accept this award from everyone, but it's a bigger pleasure to be with Mr. Hemant Singh and sharing this award with him, because he's a doyen of this IP industry. And lastly, I'll to thank my wife, without whom I wouldn't have been here. Thank you, Ishani. Thank you so much.
And your mother, you definitely wouldn't have been here without your mother.
Everyone, thank you so much.
Congratulations. Winners, please don't forget your individual picture, group picture in the end. With that, the next one. James Sagar Associates, Best Corporate Governance and Compliance Lawyer of the Year. Congratulations.
Thank you, BW legal team. Thank you, jury members. Would like to also thank all my clients, my team members, and a special mention to my senior mentor at the firm, Mr. Sajay Singh, for all his support and guidance. Thank you.
Congratulations. With that, thank you so much, Mukesh ji, for helping us with the awards. Everybody wants for sir. He's also a moderator today. May I request Ved Shukla, founder of Milo Martin also, advisor to BW Retail World, to please join us on the stage and help us present the awards. And the next one. And Company. Best Real Estate Lawyer of the Year, joint winner.
Thank you so much. Thank you so much, honorable jury and the BW team, and congratulations all the winners tonight. Thank you so much.
Congratulations. And the next one. Partners, first Real Estate Lawyer of the Year, joint winner.
If you want to clap for it.
Congratulations again.
Thanks to the jury, to BW Legal, all my colleagues at Saraf and Partners, and especially Mohit and Saroj, who are my mentors at the firm. Thank you.
And the next one. The most innovative lawyer of the year, Shed. That's a joint winner. Let's give a huge round of applause, everybody.
Well, thank you. Thanks a lot, first of all, to my mother, and grateful to my family members and my wife, who's here to support me and have always been with me throughout. And esteemed and really privileged to have received this. During my pitch, I was mentioning this. You know, very few people, and I've been practicing settlements in the last 4 years very aggressively, but there's no particular category for that. Maybe somehow we just got fit in, but I was greatly thankful to Mr. Saraf, Justice Deepak Mishra, Dr. Basin, and Dr. Batra here. Thank you so much, sir.
Don't forget your father. Congratulations to you as well, ma'am. Congratulations. Okay, and this was a joint winner award. The other winner, please. BMR Legal Most Innovative Lawyer of the Year. Let's give Shanky everybody a huge round of applause. Innovative lawyer.
Thank you to the esteemed jury and BW legal team. It's an honor to receive this award. While this is an individual category award, but I would like to give the entire credit to my team who make it possible every day. Thank you.
Congratulations. And moving ahead, the next one. Again, thank you again, the partner, BMR Legal, this time tax lawyer of the year. Thank you, everybody. Of innovation, it's the tax lawyer. Again, let's do now.
Again, once again, thank you, the jury members and the BW legal team. It's truly an honor. Thank you.
Congratulations. With that, the next one. Marika Bhargava partner, Kedan Enco Environmental Lawyer of the Year, outstanding achiever. Let's give Marika here a huge round of applause.
Thank you, esteemed jury and BW Legal World. This is an honor, and this inspires me to live up to the faith reposed in me. Thank you.
Congratulations. With that, the next one. This founder and managing partner, Judge Legal Environment Lawyer of the Apex of Excellence. Proceed, everybody. Environment Lawyer of the Year.
Thank you. Thank you. So I'll take 30 seconds and say that I complete 25 years in legal profession. And 10 years back, I started asking for environmental law awards. And I can tell you that now there are so many awards on environmental issues. And everybody has been thanking their clients. So my clients initially for 10 years were the wetlands, the tigers, the leopards, the national park, the wildlife sanctuaries. And now they are the air and water. I'm fighting for the Delhi air in Delhi High Court for 10 years now. What I'm happy about is that I managed to create a mainstream law firm, which is one of the top dispute resolution law firm in the country now, as per all the ratings. And environment is just one part of it, but I've gone back to doing environmental law practice. Thank you.
Congratulations. Also, winners, we have an exclusive networking dinner for the winners only after the group picture. Please stay back for that as well. इसी के साथ next one. Shardul Lamachand Mangalas, Environment Lawyer of the Year, outstanding achiever. Well, meet everybody.
And thank you for this world. Thank you, jury members, and all my organization, my clients, colleagues. And it's very heartening to be sharing this award with so many two other environmental roles for the year. And it's really motivating, and I really look forward to working harder and better and making sure that I make a difference to the environment and do some good work. Thank you so much.
Two things, Mr. Mishra, Ms. Margo, and Navneet, if you get together and solve Delhi's air pollution, I'll try and canvas for a Nobel Prize for you. I live in Delhi, my children live in Delhi. So if you can do that. Second, on 5th of June, we have, of course, the World Environment Day, we have an event. So, of course, Ashima, those Priyanshi is, but Sudhir is part of it. So we'd love for you, both of you, to be part of it.
Thank you. Congratulations. You're also one of our panelists today. Thank you so much, Ved, for pairing us with the awards. Thank you once for Mr. Shukla, everybody. My request, Mohit Saraf, the founder of Saraf and Partners, and also Ashima Ori, the managing editor at BW Legal World, to please join us on the stage and help us present awards. इसी के साथ next one. Associate India Private Limited, best service provider to legal sector of the year. We have with us Hardik Kaur, Associate Vice President, to receive the award.
Thank you everyone for the award, and I'm accepting this on behalf of my team. Thanks a lot. Thank you.
Congratulations. And with that, the next one. Wallabian Pratap Info, award of the year, Apex of Excellence. Pallavi.
Thank you so much, sir.
This is actually a very big honor, because one of the first matters that I did as an AOR was the Hadia case, where your lordship was the Chief Justice at that point in time, and the way he had conducted that case, I think, goes down to show the ethos of the country and the Constitution. So thank you so much, BW Legal and the esteemed.
Congratulations, Pallavi. With that, the next one. This article found on law chambers of Russia, Mittal. The best dispute resolution lawyer of the year, joint winner. Let's give Risha a huge round of applause, everybody.
Thank you, BW Legal, and thank you to the jury members. I couldn't have been more honored to have received this award from Dr. Bhasin himself. and in the august presence of Justice Mishra and my first senior, my mentor, Ms. Shweta Bharti, who is there today. So I'm extremely honored for this. And this is such a special occasion for me because this is my past where I'm receiving this award and this is for the future. So thank you so much.
Congratulations. And with that, the next one. Alcohol Law Chambers of Ramesh Agrawal, you are off the outstanding achiever. Let's give Ramesh a huge round of applause, everybody.
Thank you very much, Business World Legal, and the esteemed jury. And I also want to specially mention Justice Deepak Mishra, the ex-CGI, with whom, in front of whom I've also argued and learned quite a bit over the years. Very grateful to you all. Thank you very much.
Congratulations. And with that, thank you so much, Mr. Saraf. Thank you so much, sir. Everybody wants for Moji, one of our panelists as well today. With that, the next one. Arvind Nair, Supreme Court of India, Best Counsel of the Year, joint winner. Let's give Arvind sir a huge round of applause, everybody.
Very honored and humbled. My thank you to Business World Legal. Thank you to the esteemed jury and thank you to all the law firms and the individual lawyers. A lot of you are here today. Some are not, who have reposed faith and trust in me to lead them in court. Thank you.
Congratulations. For that, we come down to our last few awards. The next one. Senior Advocate, Best Tech Lawyer of the Year. We have with us Hemant Chu again, the founder and managing partner, to receive the award. Congratulations, ma'am, and to you as well. So congratulations. Next one. Best M&A Lawyer of the Year. We have with us Ravi sir, the senior partner, to receive the award. Let's give Raj you also Ravi for receiving the award. Congratulations, sir. इसी के साथ next one. And this competition lawyer of the year. We have with us Pooja Mahajan, the managing partner, to receive the award. Let's give Karan along with Pooja ji a round of applause. Competition lawyer of the year. Congratulations. With that, the next one. Lower case of Panagan Babu, best fintech lawyer, outstanding achiever. We have with us Rudy, the principal associate, to receive the award. Congratulations. Moving ahead, the next one. Nishit Desai Associates, best fintech lawyer, apex of excellence. We have with us Shweta Sahu, leader in the international dispute resolution practice, to receive the award. Everybody. Congratulations. Moving ahead, the next one. Senior advocate, Joint Mehta, Supreme Court of India. Best Counsel of the Year, joint winner, Navadasa's wife. I just looked up. It said first and I just stopped. They have served with us to receive the award.
Good evening, all of you. It's an honor. It's a privilege. It's very encouraging, and I don't know what have I done about it or for it. An email landed up in my inbox, congratulating me, and I saw the jury, and then I was told that I'm sharing this award with Mr. Nair, and I think that was a privilege. I'm most humbled, sir, and of course, receiving it from and in the presence of Justice Mishra and from Dr. Bhasin. I mean, I couldn't have asked for more. Good evening. Thank you so much.
Congratulations. Winners, please don't forget your individual picture. Group picture also followed by the exclusive networking dinner for winners only. With that, the next one. Founder, Gooding Center for Legal Policy Think Tank, outstanding achiever. We have with us Aditya Prasanna, the senior president, to receive the award. Congratulations. May I please request Justice Deepak Mishra ji, the former Chief Justice of India, to please join us on the stage, sir, and help us with the final awards, please. With that, the next one. Bharti, Managing Partner, Amurabi and Solomon Partners, Women Lawyer of the Year. Let's give Shweta ji a huge round of applause, Women Lawyer of the Year.
No award is, complete without thanking the team. It is always the team which actually works hard behind our awards. So I want to sincerely thank my team and my clients, of course. Thank you.
Congratulations, ma'am. With that, the next one. Ladies and partners, Indian Law Firm of the Year joint winners. We have with us Ayush Tandon, the partner, to receive the award. Ayush, thank the team.
Thank you once again. I'll not take more time. Thank you.
I think whenever someone takes precisely 30 seconds or less, it's just going to be like, "Dekho, humne kar liya itne mein," not more than that. But congratulations to you. And the next one. Managing Partner, Sagar Chandran Associates, Managing Partner of the Year, joint winner. Very challenging, everybody.
I would just like to thank the BW legal team, the honorable jury. I would like to thank my partner in life and at work, Sagar. And as reminded by Anurag ji on this occasion of Mother's Day, both the mothers, my mother and mother-in-law, the wonderful team at Sagar Chandran Associates, who without whom this award would not have been possible, and our clients who repose their trust in us every day. Thank you so much.
And the next one. Rohit Saraf, founder, managing partner, Saraf Partners, Managing Partner of the Year, joint winner.
I know that Mrs. Saraf and Michael, so if you can hear me and see me, why don't they join Mr. Saraf on the stage? Please give them a big applause to be able to go so fast in a very short span of time and establish it.
Mohit Ji, Managing Partner of the year.
Thank you, BW Legal World. Thank you, jury. I think I'm really humbled. We started this firm 3 years back, Gitanjali and I, my partner who manages my life, and we are now 250 in matter of 3 years. So thank you very much. I think this managing partner role has been very easy for me just because the team is too good. Thank you very much. Thank you, team.
Congratulations, sir. With that, the last one, please. Pooja Mahajan, Managing Partner, Chandrayogan Mahajan, Managing Partner of the year. Everybody for Pooja Ji, please.
Thank you so much once again to BW Legal Team and to the esteemed jury. And I'm really privileged to be sharing this with Ishani and Mr. Saraf. And I would like to thank my team, my colleagues, my partners, and the support staff at CNM. Thank you.
Congratulations. And with that, we come to an end of the awards ceremony for this year. Congratulations to all the winners and a very, very, very happy Mother's Day as well. With that, may I please request all the winners of the evening to please join us on the stage with your trophies. A group picture. First with the jury members and then only of the winners. Please. Aye.
Winners and jury members, can we please have a joint photo? Mr. Vasani, are you here?